TV, I'm Raymond Brown. Stephen Kolokorius, an off-duty county jailer, fired 3 shots at 2 boys carrying BB guns outside a convenience store in Gainesville, Georgia. He claims he thought the guns were real, and he says he was trying to stop a robbery. But prosecutors have charged Kolokorius with aggravated assault. We've been listening to the testimony of the first young man who was fired upon, an alleged victim put forward by the state, and the judge has called a recess part of the way through his direct testimony. We're also talking to Stephen James, an experienced former prosecutor and currently criminal defense lawyer. And we were listening to his testimony without being able to see him because the judge has ruled that we can't see his face. And we had a kind of different impression than the one Clara gave us, who said that when you see him, he seems more reluctant and juvenile than he does surly and uncooperative, even though his answers seem clipped and curt.
Well, Ray, that's very, very important. That's why it's always important to be able to see as well as hear what a witness is saying while on a witness stand. I think the jurors, if they're getting the same impression that Clara got, will definitely get the impression that he's just young. If you hear his testimony and the things he did, the activities that he and his friends were engaged in on the day in question, it'll certainly support that position.
Now we should clarify something Clara talked about before, that is starting in 1986 with the Batson case and a series of cases, the Supreme Court has said that you cannot strike any potential juror when you're exercising challenges on the basis of race now or gender. And that if you challenge 3 blacks or 3 women in a row and I say that those are gender or race motivated, then you have to give a gender neutral or a race neutral explanation. You have to say, no, this is the reason why. And I think that's what led to the little discussion that she described during jury selection.
Absolutely. Typically, you have challenges for cause, a certain amount depending on the charges, and peremptory challenges are unlimited.
Right.
The challenges for cause go just basically without explanation.
That's where you have to convince the judge. This is why. But peremptories are the ones we're talking about.
Exactly. When you want to get people out and it appears that there is some issue, and they call that a Batson argument, then if it's based on race or whatever, you're going to be pretty hard pressed, as the defense attorney was, to explain why he struck 3 jurors, 2 blacks and a Korean woman. And in those type of instances, I think it's very important for the defendant to understand why he's doing it, that are basically race neutral. And of course, he'll get away with it at that point.
That's true. Okay. Well, the judge has offered pads and pencils to the jurors, and now we're about ready to resume testimony. Let's go back to Gainesville.
Where did you and Kellen go when you first came to the Citco? Where did you first go to at the Citco station?
I was at the end of the store, and Kellen went in the store.
Which end of the store were you at?
And this is where I was on the right side.
All right. As you faced the store, you were on the right side?
Yes, sir.
All right. What kind of things were on the right side of that store?
Nothing.
Maybe I can help you with some photographs. I'm going to show counsel states exhibits number 3, 4, and 5, and 6. Well, right now, I'm going to just show you states exhibits number 3 and number 4. Do you recognize the scenes shown in states exhibit number 3 and number 4?
Yes, sir.
Do they appear to you to be what location? What location do they appear to you to be?
That's the left side. I was on this end.
Okay. Well, is this the Citco store on the Athens Highway? That's what I'm asking.
Yes, sir.
Okay. Your Honor, I'm going to tender 3 and 4 at this point.
No objection, Your Honor. States 3 and States 4 will be admitted.
Okay. Then as you first came to the store, you said you were on what side of the store?
This side.
Okay. If this is the front of the store, this is the left-hand side of the store over here. See, if this is the front of the store, this is the left-hand side, this is the right-hand side. When y'all first came to the store, which side did you come to?
This side.
On the left-hand side?
Yes, sir.
On the side opposite from where the propane tanks were when you first came to the store?
Yes, sir.
Okay. And Did Kellen also approach the store from that side?
No, sir. He went straight in the store.
He went straight in the store at that time, okay? Now, when you got to the left-hand side of the store and Kellen went into the store, where did you go?
I was just standing waiting for him to come out.
Okay. Did he come out?
Yes, sir.
Where did you go then?
He went to the end of the store over there to get some water, and I followed him.
Which end of the store did he go to?
Right side.
Okay. Near what?
The water spigot.
All right. And where is the water spigot as shown in this picture?
Beside that red thing.
Beside this red thing?
Yes, sir.
Which side of it? This side or this side?
This side.
All right. On the right-hand side of it as you look at it.
Yes,
is that
sir.
correct? All right. We'll get closer to the jury with these a little bit later, okay? Now, did you use the spigot?
Yes, sir.
How did you use the spigot? What did you do when you were at the spigot?
Turned it on and got some water out of it.
Did you drink any of it?
Yes, sir.
How did you drink the water? Did you...
Out of my hands.
And drunk it in that way instead of bending down and just drinking it right out of the spigot?
Yes, sir.
All right. Well, if you had your hands held in that fashion, what did you do with the BB gun that you had?
Put them on top of the thing.
Of what thing is that you're talking about?
Whatever that red thing is.
Whatever the red thing is. What does the red thing have in it? Have you seen things like that before?
No, sir.
Okay. What color are those things within the red thing?
White.
Okay. So you said you put your BB gun on top of that. What did Kellen do with his?
The same.
Now, as you came up to the store, before Kellen went in, when you were waiting on the left-hand side of the store,
Yes, sir.
where was your BB gun then?
I had mine in my hand, and Kelly had his in his thing because he was going in the store.
In his waistband,
Yes, sir.
as you were just describing? Okay. Do you know, and did you see Kellen put it in his waistband then?
Yes, sir.
Okay. How about the position of his shirt? What did you see about that?
It was over the gun.
Okay. Did you and he have any conversation as to why he should do that?
No, sir.
Okay. Did he do that on his own?
Yes, sir.
Okay. Do you know why he went into the store at that time based on any conversation you and he had together?
To ask the man for some water.
Okay. And when he came out, is that when you went to the spigot?
Yes, sir.
Who used the spigot first?
Kelly.
And how did Kellen use the spigot?
He cut it on and got some water out of his hand.
Okay. What did he do with his BB gun?
Put it on top of the thing.
All right. How close was your gun to his gun?
I don't know.
All right. And Montell, I'm going to ask you a lot of details about all of this, okay? So I want you to give me your best memory about everything that I'm asking you about. Now, when so I think you said he used the spigot first and then you used the spigot. Is that correct?
Yes, sir.
Did you use any water anywhere else on your person besides drinking it?
No, sir. We were throwing it on each other like playing and stuff.
Okay. And when you were doing that, was your were your BB guns still on top of the red container thing?
Yes, sir.
All right. About how long were you out there drinking water from the spigot, throwing the water on each other at the spigot?
About 5 minutes.
While you were there, before the person that is the subject of this trial, before that person, did you see any other persons there at the store, around the store, customers, that sort of thing?
No, sir.
Were you paying attention about whether there are any
No, sir.
customers there or anything like that?
No, sir.
Were you watching to see whether there are any customers coming
No, sir.
in or out or anything of that nature?
No, sir.
What was your purpose at being at that Citgo store at that time when you and Kellen were out at the Spigots?
Getting a drink of water.
Did you have any other purpose at all?
No, sir.
Montell, did you intend to rob the Citgo store using that BB gun?
No, sir.
Did you have any conversation with Kellen
No, sir.
about whether or not he had any intention to rob that store with that BB gun?
No, sir.
Were you and Kellen going to rob that store with that BB gun?
No, sir.
Did you intend at any point to point that BB gun at anyone?
No, sir.
When you were at that Citgo store, did you point that BB gun at anyone?
No, sir.
At any time?
No, sir.
Okay. When you got through using the spigot, drinking the water from it, that sort of thing, can you tell me what objects you had with you beside the gun as you described where you put it when you were using the spigot? Did you have any other objects with you?
No, sir.
Do you recall whether or not you had a towel or Kellen had a towel?
I had a towel
And how long had you had the towel?
all day.
And why did you have a towel?
Carried it around my neck
And why did you carry a towel around your neck?
because it was hot.
And why did you use a towel for that purpose?
I wetted it, put it on top of my head.
Okay. Have you done that before?
Yes.
When it's hot in the summer, do you do that frequently or not frequently?
Yes,
or
sir.
was this the first time that you had done
No,
that?
sir.
Did you use the water for the towel there
Oh, yeah.
at the Citgo?
I wet the towel, yeah.
What did you do with the towel after you wet the towel?
Put it around my neck.
Where was the gun at the time you put the towel around your neck?
On the time.
Mr. Dare, I would pass pads and pencils out to the jurors. If you would like to use it, you can. You don't have to, but if you'd like to, throughout the progress of the case, feel free to use your own notepads. You'll leave them here at night in the jury room in any chair that you might occupy. Does everyone have one or have access to one, even and including the alternates?
No, sir. I need the two at the end.
All right, if you wouldn't mind passing those back down, thank you. All right, Mr. Dare, you may continue.
After you got through using the spigot, what did you intend to do?
Leave
And what direction were you going to leave?
this way.
All right. I need for you to describe to me which way you're talking about when you say this way.
Going behind the store.
Sorry, say that again.
This way.
You intended to leave around this way?
Yes, sir.
Okay. Did you go around that way at first, though?
No, sir.
Why did you not go away, leave going around that way at that time?
Because I was going to go keep straight.
You were going to go what?
I was going to go keep straight and go around this way. And since I got some water, I went around this way.
I'm sorry, I could not hear that last answer.
All right. Try to, after you got water, I want you to speak up, okay? And if I'm, we're probably not in a very good location, but would you tell me when you were going to leave, you said you were going to go around this way, is that correct?
Yes, sir.
Did you instead go this way, across the front of the store?
No, sir.
Tell me what you did, Montell and Kellen, after you got water.
walking off. I looked up.
I'm sorry?
I was looking up and I was beginning to leave.
Okay. And when you were looking up and beginning to leave, did you see anything?
Yeah.
Him being who? Would you just describe who it is that you're talking about as being him? All right. And just for the record, please, what color clothing does that person have on that you're talking about?
A green coat.
Okay. May the record indicate these pointed out the defendant, Kolokorius.
Any objection to that, Mr. Sumner? All right, the record will reflect that.
When you were looking up at that time, as you were fixing to leave, what did you see Kolokorius do?
Point the gun.
All right. I need to get some more details before that from you. Did you, MONTELL Butler, see Kolokorius, the man you pointed out in the green jacket, outside of the Citco store?
I seen him running in the store.
All right. Did you see where he came from as he ran into the store?
No, sir.
Did he say anything to you when he ran into the store?
No, sir.
Did you or Kellen say anything to him as he ran into the store?
No, sir.
When you say he ran into the store, was he running into the store or walking into the store, walking fast, running, or how?
Running.
He was running into the store. I see. What was it, as you saw him running into the store, do you recall what it was that he was wearing?
No, sir.
Did you notice whether or not you and he had any eye contact with each other as he ran into the store?
No, sir.
At the time that he ran into the store, where was your BB gun?
Still all the time.
Where was your towel at the time that he ran into the store?
Around my neck.
Did you notice at the time that he was running into the store where Kellen's BB gun was?
No, sir.
Did you notice what Kellen was doing, if anything, at the time that Kolokorius ran into the store?
No, sir.
After Kolokorius ran into the store, what is the very, very next thing that you did?
Look to see what he was running for.
Now, where did you go, if you did, or did you move? Let me ask you this, I'm sorry. At the time that he was running into the store, where in relation to the red container with the white tanks were you?
In front of him.
In front of them? Okay. Where was Kellen?
He was in the back of it.
All right. Now, at this point, I'm going to ask you to come to the jury again, because we're going to use this photograph. Now, what I'm going to do is we're going to, now, can't stand too far behind the court reporter, but I want you to stand over here, because she's going to be able to watch you speak, and that's going to help her. Do you see this diagram?
Lady on the end can't see.
All right.
All right, Mr. Dare.
Yes.
Ms. Alderman, if you want to move, you can move. Mr. Dare, I want Mr. Butler to talk to the jury. I want to make sure the jury can hear and see everything that he's saying, please.
Yes, sir.
Hold on, Mr. Butler. All right, you may proceed.
Your Honor, I'm going going to call this exhibit, I think, exhibit number 7, this diagram here. And if I can confer with Mr. Summer for a moment.
All right, please do so.
Thank you. Your Honor, counsel and I have agreed to stipulate that this will call State's Exhibit number 7. We'll recognize in the stipulation that this is not the scale, but is a representation of a diagram of the store and locations of the store, and we stipulate that it can go out into evidence with the jury and be used during testimony.
All right, I'll allow that as a stipulation. Ladies and gentlemen, there's certain limitations to the charge that I'll give you, that what the lawyers say is not evidence, and certain exceptions to that also. One of the exceptions would be if the attorneys have reached a stipulation, that stipulation just announced by Mr. Dara can be taken as evidence by you in his description of what that poster or chart is. All right, Mr. Dara, you may proceed.
Thank you. Now, Kellen, as we talk about, Montel, as we talk about this, do you see this location here?
Yes, sir.
And you see where that says propane storage?
Yes, sir.
All right. Maybe it'd be helpful if we turn it upside down so that it'd be in the same sort of location here. As we talk about this area here, Montel, do you see that this thing here on State's Exhibit number 4 corresponds with this location here?
Yes, sir.
You see that?
Yes, sir.
All right. You see these locations as being the front door area here,
Yes, sir.
with the going in and then coming out here.
Yes, sir.
All right? Is this the red thing that you were speaking of, where you had laid your BB gun and where Kellen had laid his BB gun? Okay. Speak loudly for me, all right? Now, when you saw Kolokorius run into the store, what did you do? And you can use this pointer. Show me where you were and all that sort of thing.
I was like, right here.
In front of the propane tanks?
Yes, sir.
Were you in front of Kellen or on the...
In front of Kevin.
So you were closer to the doors than Kellen was?
Yes, sir.
And what did you do when you saw him run into the store?
Oh, I had looked around to see what he was running for.
You looked around to see what he was running for?
Okay.
Did you go or walk in that direction?
Yes, sir.
You did?
Yes, sir.
How about Kellen? Did he walk in that direction?
Yes, sir.
How far away from the propane tanks, if these are in fact propane tanks, how far away from the propane tanks did you get, Montel?
So right in the middle of it. Right here.
Did you go further than that?
No, sir.
Are you sure?
Yes, sir.
How about Kellen?
He was behind me.
What happened next, Montel?
He started shooting.
Who started shooting? How do you know that?
Because I seen it, I looked up and I seen the glare shatter. And I started running.
You looked up and saw some glass shattering and you started running.
Yes, sir.
Did you feel anything at that time?
Yes, sir.
Did you know whether or not you had been struck with anything at that point?
Yes, sir.
At the time that these shots were being fired, where were the BB guns?
Still on the ground.
Did you have the BB gun in your hand at all
Yes,
at
sir.
that point?
Yes, sir.
Is that what your recall is?
Yes, sir.
Were you walking in this direction? Stored in front of those doors. How many shots, if you did hear shots, how many shots did you hear fired?
Can't remember. Go back to the phone.
About 3 or 4? How did you react to shots being fired? What did you do? Where did you run to?
Go back to the store.
Around what side of the store?
This side?
As you face the store, around the right-hand side of the store?
Yes, sir.
I want you to speak up very loudly, Montel, okay? I'm sorry. Who was in front of who? Were you all running together, or was one of you in front of the other?
I passed Kelly.
You passed Kellen,
Yes, sir.
all right? So, was Kellen also running?
He was shot for a minute and I told him, come on, let's go. We start running.
Did you pick up your BB gun?
No, sir.
I'm sorry?
No, sir.
Did Kellen pick up his?
Yes, sir.
What did you do with the BB guns?
So I'm still on top of the thing.
Did you not carry the BB guns with you?
No, sir.
Montel, if the BB guns were not found on top of the red container later on, how did the BB guns get where they were found?
Objection, Your Honor. Calls for this witness to offer speculation, which is
Overruled. I'll let that question be asked if he can answer it.
Montel, did you take the BB gun?
objection leading.
Well, there's not leading when there are several possible answers.
All right, I'm going to take into consideration this witness's age also. You may ask the question. Overruled.
Did you take the BB gun with you when you left?
Yes, sir.
Did you see whether or not Montel took his BB gun with him when he left?
Yes, sir.
You did not see, or you do know, or you don't know?
Mr. Derrick, you asked the question, did he see whether Montel took the BB gun? Is that what you're asking?
That's correct.
This is Montel.
This is...
I mean, Kellen. Please excuse me. Did you see whether or not Kellen took his BB gun with him?
No, sir.
So do you know whether or not he took his BB gun with him or not?
No, sir.
You do not know. Do you know whether or not he left the BB guns there or could have taken both of the BB guns, or do you know?
I don't know. I just know I didn't grab it.
What did you do with the towel that you had, if anything?
I think I dropped him all right.
Where did you drop it? Do you recall?
I don't know.
All right, have a seat again, please. Where did you run to, Montel?
To some bushes
Where were the bushes located?
behind the store.
What kind of bushes were they? Do you know that kind of
Kudzu, whatever.
kudzu? Did you stay in the kudzu very long?
No, sir.
Oh. Where did you end up?
On the dirt road.
Earlier on in your testimony, you described a dirt road. Are you talking about the same dirt road or a
Yes,
different
sir.
dirt road?
Same one.
The one that was being built for the subdivision that's now there?
Yes, sir.
Did you see any people when you were there?
Yes, sir.
What people did you see when you were there?
The people that was working on the road.
Did you do anything in connection with those people?
I told them to call the police and ambulance.
Did you notice anything about yourself at that time?
Yes.
What did you notice about yourself at that time?
That I was bleeding and stuff.
Did you notice about yourself where you were bleeding from?
Yes, sir.
Where were you bleeding from?
My neck.
Any other places on your person?
In my chin.
Any other places on your person?
No, sir.
Okay. When was it that you first noticed that, Montel?
When we came to the dirt road, I asked Kelly, have I been shot? He said it was just a little cut.
All right. Did anyone there at the dirt road assist you in any way with that? With your injury?
They had looked at it and stuff.
Okay. Besides the people that you ran into over there, the workers that you ran into at the dirt road, did other people start coming to that location?
No, sir.
Okay. Did you eventually see some law enforcement officers?
When they called the police.
Okay. Who was it that called the police as far as you knew?
I don't know.
All right. Did law enforcement officers come to the location where you had run into the workers
Yes,
who
sir.
were working on the road?
Yes, sir.
All right. What happened when the law enforcement officers got there?
They read us our rights and told us we was under arrest for trying to rob a store, I think.
Okay. Were you trying to rob the store?
No, sir.
Did you do anything to rob the store?
No, sir.
Can you testify as to whether or not you approached the doors of the store?
I didn't approach the door.
Can you testify as to whether or not you pointed the BB gun at anyone?
I did not point the BB gun.
Can you testify as to whether or not you intended to rob the store?
I didn't intend to rob the store.
Okay. Were you treated in any way for the injury that you received?
When the ambulance came
Did the ambulance take you anywhere?
to the hospital
Okay. Did you stay at the hospital very long?
overnight,
Did you have any sort of treatment there that you know about?
Dad
Go ahead.
put stitches on it and closed it up with some kind of tape.
Do you have any after effects of that? Well, do you have any scars as a result of that injury that you received?
Yes, sir.
Are they on your person now?
Yes, sir.
And can they be seen?
Yes, sir.
Where are they particularly, please?
Right here. Right here.
All right, would you mind stepping forward just for a moment? All I want you to do is just show the jury those, if you would. Come here. All right, show the jury what you're talking about. Right there, and where else? Right there. All right, thank you very much. Did you have any injuries there prior to this incident of July the 15th of 1997? Before this incident of July 15th, 1997, did you have those scars? Were those scars a result of what happened on July 15th?
Yes, sir.
When the shots were fired, did you have any feelings at the time that the shot was being fired?
No, sir.
Why is it that you ran when shots were being fired?
Because I was getting shot at.
And how did it make you feel to get shot at?
Scared.
Can you testify as to whether or not you were in fear of receiving injury? at the time you were being shot at?
I didn't know.
Were you scared?
Yes, sir.
Were you scared of receiving injury?
What?
Were you scared of being shot?
Yes.
Okay. Now, okay. At the time that you were there on the dirt road, were you placed in handcuffs at some point?
Yes.
Did they move the handcuffs or keep, how were your hands situated when you were handcuffed at first?
In front of him.
Were you eventually charged with any attempted armed robbery or anything like that?
Yes.
At the time that you were arrested, is that correct?
Yes, sir.
Do you have any pending charges for attempted armed robbery of that store? That's what I'm asking.
No.
When you left the hospital, did you go home?
Yes, sir.
Now, Montel, at this time, Mr. Summers is going to get to ask you some questions.
All right, Mr. Summer, cross-examination,
Thank you, Judge Fuller. Montel, my name is Dan Summer. I represent Stephen Kolokorius. You understand that?
Yes, sir.
I'm going to be asking you a bunch of questions this afternoon. If I ask you a question you don't understand, you tell me you don't understand it and just ask me to repeat it, and I'll be happy to do that, okay?
Yes, sir.
All right. Montel, may I call you Montel?
Yes, sir.
Montel, how old are you now?
16,
When are you going to be 17?
March 2nd.
So you just turned 16, is that right?
Yes, sir.
Now, last year in July, I think Mr. Dare asked you, you were on a break from school, is that right?
Yes, sir.
Were you working? Did you have a job?
No, sir.
Did you have any income?
No, sir.
Would it be safe to say that you had no money back in
Yes,
the
sir.
summer of 1997? What did y'all do for entertainment?
What do you mean?
I think you said you shot hoops, is that right?
Yeah.
What other kind of things did you do?
Play around and stuff.
All right. In particular, looking in front of you, you've got State's Exhibit 1 and State's Exhibit 2. May I approach, please?
You may.
Montel, if you would you tell me, please, which gun is yours?
This one was mine.
This
the
is
one
yours?
that I own.
All right. Was this the one that you kept up under the bed?
Yes, sir.
All right. And how about this gun?
That's the one I got from T.R. Tom.
And you traded, as I understand it, a beeper, is that right?
Yes, sir.
All right. What did you have a beeper for?
Objection, irrelevant.
Very relevant, Your Honor, and I ask you to be allowed to
Not at all,
answer.
if we might approach the bench.
All right, you need to approach.
Well, it didn't take long before questions were asked to which prosecutors objected. Stephen James, do you have any sense of where the defense is going with the beeper argument?
Certainly, they want to establish that this guy had no gainful means of employment, had no way of getting money. The defense that he was planning, the defense that the defendant is putting forward is that he was preventing a robbery. The guy had no job, no money, carried a beeper, Why? He wants to raise the question in the jury's mind that maybe this is a bad person.
A, how did he get a beeper? And B, was the beeper to communicate in connection with some illegal transactions?
A 13-year-old with a beeper with no job, what was the purpose for it?
And a 13-year-old that prosecutors have established was kind of wandering aimlessly about. Why would he have a beeper?
Correct.
On the other hand, the prosecution is saying, if you don't have something to tie this up with, it's just speculation, and you're asking jurors to speculate.
Exactly, and if that is the case, that would be wrong. However, it's a good shot by the defendant to try to, get in the jury's mind, why would they have the need for a beeper for such a young man with no job?
We also should point out that there has been a notice filed, a notice of claim, that there may very well be a suit against the public authorities. It hasn't been filed yet, but there's a notice that's been sent, which
Absolutely.
is the thing that happens before a civil suit is filed.
Right.
But that's a separate issue, and at the moment, that hasn't come up, though it wouldn't surprise me if at some point the defense brought that issue up as well.
Absolutely. I mean, that may go to motive for the outcome and interest in the outcome of this criminal case other than seeking justice.
Now, at the end of the prosecutor's direct, you were a little surprised that he hadn't explored the question of the allegation by the defense that this witness hadn't cooperated.
Ray, I was highly surprised. That, to me, was something I felt was left dangling by the prosecution. It seemed like he was heading in that direction by indicating, getting from the witness the testimony about being handcuffed, initially accused as a defendant of or a perpetrator of an alleged crime. However, I thought he would develop that into saying, hey, maybe this is why this defendant wasn't so cooperative. Wanted his mother present, wanted his lawyer present, because the police had already shown that they were taking a position against his better interest.
Maybe he thinks it's self-evident. Maybe he's planning a landmine. But let's see. Let's go back into the courtroom. Oh, well, I thought that actually the sidebar did break up, but it appears that the judge is merely sending the jury out of the courtroom. Maybe we'll hear more legal argument on this point. It could prove to be an important one because I think the defense really wants to stretch out and paint this young man as a bad guy.
Well, it looks like the defense really has done their homework on this case, and they really know where they want to take their defense, and every opportunity they get, they're going at it.
And indeed, it's ironic because in some cases one can argue, well, it's irrelevant whether somebody's a bad guy or not because bad guys are entitled to protection too. On the other hand, here, the question is, were they looking to rob the store? Let's go back now to Gainesville and hear legal argument.
I might ask you.
Montell, you indicated that you traded a beeper
Yes, sir.
for, as I understand it, State's Exhibit 2,
Yes, sir.
this gun. And what did you have a beeper for?
They were given to me.
All right. Who was it given to you by?
My cousin,
Your cousin's name?
Roger.
Was it a working beeper?
No, sir.
All right. Why did you have the beeper then?
I had it. I was wearing it.
I'm sorry?
I was wearing it.
All right. Was it just for show?
Yes, sir.
Then it's just absolutely irrelevant.
I would really like to try my case the way I want to try it. That doesn't put his character in evidence. It doesn't do anything, Judge. The beeper's material because we don't have it. And it's fair game. It's the evidence. It's the state brought it up.
All right, it is a piece of evidence that's been mentioned by the state, and I'll allow the questions to be asked, and those are the questions you're going to limit at this time, correct?
Well, I want to know, in addition to that, he traded the beeper for who? Okay. You had this beeper, it was given to you by a cousin, is that right?
Sir.
And it wasn't working, is that right?
Yes, sir.
You had it for show.
Yes, sir.
And you traded it for the gun, is that
Yes,
right?
sir.
Okay, where's the beeper now?
No.
Okay. That's it.
All right. Over objection, I'll allow each of those questions to be asked and answered. All right, Ms. Vigor, let's ask the jury to come back in, please.
Well, the judge permitted defense counsel to explore an area. Obviously, the prosecutor couldn't say for certain at sidebar what the answers would be. The judge, having heard it, is going to let those questions be asked, but as far as I can tell, only those questions on this subject.
Right. This is a limited purpose questioning area just to determine for the defense purposes where this beeper came from, and you heard the answers. This is called an offer of proof
But
by
it
the
sounds
defense.
like we're going to be on the razor's edge throughout this testimony, with the defense wanting to explore areas, prosecutor trying to hold them back, and the judge perhaps having to make judgments subject matter area by subject matter.
Absolutely. But Ray, I'd like to add this also.
Okay, before you add that, he's about to ask more questions, so hold that thought. Let's go back to Gainesville.
if you're ready, please proceed.
Thank you, Judge Fuller. Montel, I was asking about the beeper. Would you describe that beeper, please?
It was a slide in and slide out page. It was like a wood grain color.
Where did you get the beeper?
From my cousin,
And what's your cousin's name?
Roger
Does Roger have a last name?
Butler.
And it wasn't working, is that right?
Yes, sir.
Yes, sir, it was not working?
Yes, sir.
And can you tell us what you did with the beeper?
I just wore it.
You wore it out, like on your belt?
Yeah.
But it was not a functioning beeper, is that correct?
Yes, sir.
And as I understand Mr. Dare's direct examination, you, at some point in time on the 15th of July, 1997, traded that beeper for a gun.
Yes, sir.
All right. And as I understand it, correct me if I'm wrong, we're talking about State's Exhibit 2?
Yes, sir.
This Crossman air gun, is that right?
Yes, sir.
And you were over at, this is your cousin's house? Or Kellen's cousin's house?
Kellen cousin.
And tell me his name again?
Which one?
Where the fellow you traded the gun for the
Oh,
beeper?
Tony Turner.
Tony? And you traded the beeper that you had
Yes, sir.
for the gun, is that correct?
Yes, sir.
And I believe you said you traded the beeper because you didn't have any money, but you wanted the gun, is that right?
No, sir.
All right, correct me if I'm wrong. Why did you trade the beeper for the gun?
Because I wanted the gun.
All right, that's what I thought I asked you. You wanted the gun, but you didn't have any money to pay for the gun or to trade for the gun. So you used the beeper, is that right?
Yes, sir.
Now, would you tell the jury where the beeper is now?
I don't know.
Do you recall Agent Kersey here asking y'all if you would please assist him in recovering the beeper for this investigation?
No, sir.
You don't recall Agent Kersey asking you or anybody to go get the beeper so he could look at it?
No, sir.
All right. Has any effort been made to recover the beeper?
No, sir.
Do you know where the beeper is now?
No, sir.
Did you ask Tony if he still had the beeper?
Yes, sir.
And what did he tell you?
Objection.
They don't
This
have
court's hearsay, Judge. Move strike to the question
Yeah.
in hand.
The state's been about 3 hours getting into here, say it's kind of a minor issue.
Continue.
Your Honor, I object to comments of counsel. If he could restrain himself to asking questions and make an appropriate objection.
All right.
I'll try to do
Counsel,
that.
From this point forward, when you have objections, voice those objections to the court if you would, please.
I'll be
and
happy
keep
to,
your
Judge.
comments directed to the court also.
Yes, sir. Did you ask Tony what he did with the beeper?
Yes, sir.
I'm sorry, no, sir?
No, sir.
All right. Thank you, Montel. Now, as I understand it, y'all were wanting to go shoot hoops that day over at Butler, is that right?
Yes, sir.
And you went over there and it was closed, is that correct?
Yes, sir.
So thereafter, you went over to Tony's house, is that right?
Yes, sir.
And Tony indicated he had a BB gun, correct?
Yes, sir.
And you wanted to see the gun, correct?
We was going over there to get a bike.
A bicycle?
Yes, sir.
But you ended up getting this BB gun, right?
Yes, sir.
What were your plans for later that day, Montel?
I didn't have no plan.
What time was it, best of your recollection?
I don't know.
Was it around lunch, if you can remember?
I don't know.
Did you have any plans in particular right then and there?
No, sir.
Now, how far is Tony's house from where you were staying at the time?
It's a walk.
All right. Is it towards the Sitco or the other direction from the Sitco?
The other direction.
All right.
Going on the road is.
So y'all agreed that you went back to your place where you were staying,
Yes, sir.
and y'all got State's Exhibit number 1.
Yes, sir.
This was your gun,
Yes, sir.
and this was kept up under the bed. Is that right?
Yes, sir.
And tell the jury what it is that you were doing with the gun under your bed.
So I ain't never used it. I ain't never played with it or nothing. I ain't had no use for it.
If you had no use for it, why did you keep this gun up under the bed?
It wasn't like under my mattress. I threw it under my bed.
All right, I understand. Under the bed. So, and you were just with Kellen at this time when you got back to the place you were staying. Is that right?
Yes, sir.
Yes, sir? Okay, I'm sorry, I'm having a little difficulty here. All right, so you retrieved State's Exhibit 1, your gun, and you gave it to Kellen. Is that right?
Yes, sir.
Kellen Clark, the other fellow that you were with this day. Is that right?
Yes, sir.
Now, did y'all have any discussions about what you were going to do that afternoon?
No, sir.
But you would agree that you left out of the house with these guns. Is that correct?
Yes, sir.
Tell me again how it was you were dressed, Montel.
I had on a pair of shorts and a t-shirt and a towel and red and white Nikes.
All right, how was Kellen dressed?
Can't remember.
Did you have 1 or 2 t-shirts on?
1.
Sure you didn't have 2?
Yes.
Did you tell anybody that you had 2 t-shirts
No,
on
sir.
that day? Did anybody have a baseball cap on that day?
Yes, sir.
Who was that?
Me.
Okay, what type of baseball cap was that?
It was I think a red Atlanta Braves hat.
And you also indicated that you had a towel, is that right?
Yes, sir.
And what was the towel for?
Put over my head.
Well, I thought you had a baseball cap on your head.
I can put it on top of the baseball cap.
All right, you put a cap on your head and then a towel on that, is that
Yes, sir.
right? Did you do that day?
Yes, sir.
So you're walking around with the hat on and the towel over it, is that right?
Yes, sir.
Now, what were your plans that day when you left out of the place you were staying with these guns?
Kelly asked me did I want to walk somewhere with him. I said, yeah.
Where were y'all walking to?
To Gainesville Road.
And what was your person going to Gainesville Road?
Going over this girl house named Courtney.
All right. And is Courtney's house in the direction of the Citgo?
It's past that.
It's past the Citgo. Let me ask you something, Montel. Why was it that you went from Tony's house back to the place you were staying, which is in the opposite direction of the Citgo, to retrieve the other gun?
I went to my house to eat.
All right.
And then while I was there, I gave him that one.
You said that one. Let's make sure we're on the same page here. You're talking about number 1.
Number 1.
All right. Let's just call it the black gun, and we'll call this the silver gun, even though they both have black and silver. Now, Montel, these look like real guns, don't they?
Yes, sir.
In fact, they're very realistic looking, aren't they?
Yes, sir.
Can you tell that these are fake guns from a distance?
No, sir.
All right. Would you agree, Montel, that any reasonable person might believe?
Objection, Your Honor. This is argumentative question at this time.
It's a cross-examination.
Question.
But it doesn't.
I need to hear the question. You don't have to answer the question. I need to hear the question.
Montel, you just said these guns were very realistic looking, especially at a distance, right?
You may answer that question.
You agree?
Yes, sir.
Montel, do you think it might be reasonable that other persons like you might think these are real guns from a distance?
Repeat.
You do not need to answer that question. Mr. Darrett.
The question is argumentative because the ultimate issue, one of the ultimate issues that jury is to determine for themselves. It asks for an opinion without basis. But basically the first two.
Right, and I would sustain the objection to that question. You do not have to answer that question.
Let me ask it this way, Montel. If you're standing there and I'm standing here with these guns and we don't know each other and you've never seen these before, would you agree that the first thing that might pop in your head that these are real guns?
Probably.
Now, you didn't have any CO2 that day?
No, sir.
And when we're talking about CO2, you see this little silver canister in here?
Yes.
That's CO2, right?
Yes.
That's the propellant. Have you actually put a live CO2 canister in here, filled it with BBs in either gun, and shot it? All right. Do you know how the CO2 cartridge got in there?
That was in there when it was gave to me.
In any event, as I understand it, you took these guns and set out for Courtney's house that day, is that correct?
Yes, sir.
And I believe you testified you didn't have any plans, is that right?
Yes, sir.
Can you tell the jury, Montel, why it was that you left out of the place you were staying with Kellen armed with these 2 replica weapons if you didn't have any plans for them?
Showing off. Just carrying them.
Who were you showing them off to?
To whoever we met.
And what do you mean by showing off? Help me with that.
Showing them my new gun.
Did you anticipate showing it off to Courtney?
We didn't get to Courtney's house.
All right. Who did you anticipate showing off your gun to?
To whoever like asked me.
All right. Were you proud of the guns?
Yes.
Now, you agree you weren't out target shooting that day, correct?
Yes, sir.
Because you didn't have any CO2 and you didn't have any BBs or pellets, is that right?
Yes, sir.
So if anybody were to say that you were out target shooting, they would be mistaken.
Yes, sir.
And you didn't have any purpose or plan other than just go out and show off the guns, is that right?
No, sir. Yes, sir.
All right. That was your plan, just to show off the guns?
Yes.
And as I understand your testimony on direct, Montell, and help me with this, at various times you were walking with the guns out like this, is that right?
Yes.
All right. Was there a time when you got the gun and did like this and pulled your shirt up over it?
Yes.
All right. Why would you do that?
Well, we wouldn't have to. The shirt would go over it anyway.
I'm sorry, sir.
We didn't have to. The shirt would go over it anyway.
All right. Well, my question is, if you didn't have any purpose in having the guns, why was it necessary in your mind to hide the guns up under your shirt while y'all were...
We got tired of holding them.
All right. Did there come a time when people just in and about the area, driving by or walking, looked at you and Kellen?
It was a couple of cars blowing at us and stuff.
I'm sorry, they were doing what?
Blowing.
Blowing their horns?
Yeah.
Do you know why they were blowing their
No.
horns at you? Did that concern you?
No.
Was there a time when people were looking at you and perhaps you saw them and you got the guns and stuck them up under your shirt?
No.
Pants? You never did that?
No.
Do you know a man named Parker Risley?
No.
Do you know a man named Cecil Ferguson?
No.
Where were y'all going that day, ultimately?
The courthouse.
All right, but Courtney wasn't there, right?
We didn't reach courthouse. We went to Tyler's house.
Went to Tyler's house. Were you planning on, when you set out, going to Tyler's house?
No.
That just popped up in your mind?
Yes.
All right. And what was your plan from Tyler's house? Where were y'all gonna go?
Go back home.
All right. What's the quickest way to get home from Tyler's house?
Some of the paths they showed us, I don't know.
All right. Would that path have taken you by the Citgo?
I don't know.
Why didn't you just, if your plan after Tyler's house was go on home, why didn't y'all just go on home?
We were trying to find a ride home.
Couldn't find a ride?
No, sir.
How far is Tyler's house from the Citgo?
I don't know.
What caused you to go up past the Citgo?
That's where we came.
Was there a quicker way home?
No.
That was the quickest way home? Is
Yes.
that right? Were you walking on 129 with the guns out?
Yes.
Were you walking on 129 with the guns hidden up occasionally?
Sometime.
And I believe you said because you got tired of holding them, is that right?
Yes, sir.
Did you ever point the gun at Kellen?
No, sir.
Did he ever point the gun at you?
No, sir.
Did you ever make a statement to any GBI officer or anybody else that y'all were funning around pointing the guns at each other?
No. No, sir.
You sure about that? You don't remember what Kellen was wearing, is that right?
Yes, sir.
Do you recall if he had two T-shirts on?
No, sir.
Do you recall if he had a towel on?
No, sir.
Do you recall if he had a baseball hat like you did?
He had a blue hat on, I think.
A blue hat? All right. All right, Montell, as I understand it, on direct examination, you told Mr. Dara that when you got near the Citgo, Kellen wanted water, correct?
Yes, sir.
And you said, and I quote, "I wasn't thirsty." Is that right?
Yes, sir.
Is that a correct statement?
Yes, sir.
So Kellen was the individual who wanted to go to the store to get water. Is that right?
Yes, sir.
And in fact, Kellen, as I understand it, went in the store and spoke with a gentleman in the store.
Yes,
Is that
sir.
correct? Now, was Kellen's gun out when he went in the store?
No, sir.
Where was it?
On the side.
Can you tell the jury if you know why
No,
Kellen...
sir.
I didn't ask the question yet. Can you tell the jury if you know why Kellen would have stuck the gun up under his shirt when he walked into the Citgo store?
No, sir.
Do you know what the word casing a joint means?
No,
The
sir.
phrase casing a joint? It means checking it out. You ever hear that expression?
No, sir.
Do you know if Kellen was casing the Citgo?
No, sir. He wasn't. He wasn't.
He wasn't. But you were outside, is that right?
Yes, sir.
As I understand it, sort of, you're facing the Citgo off to the left, is that
Yes, sir.
correct? And the water fountain or the water spigot's all the way on the other side, is
Yes,
that
sir.
right? And Kellen came out and went to go get a drink, right?
Yes, sir.
Now, you weren't thirsty, is that right?
Yes, sir.
But you will admit that you went over there to get a drink anyway.
Yes, sir.
All right. Why would you go get a drink if you weren't thirsty?
Just to go over there and get some water.
You just said you weren't thirsty.
Your Honor, objection, because there's no question there. It seems to be just a statement.
Can you
of counsel.
explain to the jury the inconsistency between your direct testimony that you were not thirsty and your statement that you went over to get water? Can you explain that inconsistency?
You went and got water, and so I just said, forget it, I'm finna go get some water too.
Right. But you weren't thirsty,
And I
right?
wet my towel while I was over there.
And what were you going to do with the wet towel?
Put it back on my head.
That would have obscured your face and head to some extent, wouldn't it?
I know.
And that would have concealed your identity to some extent, right?
No.
It would not having a towel over your head conceal your
That's-
identity?
It's an argumentative question.
He is on cross-examination,
It doesn't
and I
make
would
improper
appreciate being able
questions.
to try my case.
Your Honor, I appreciate counsel giving me the opportunity to object to, number one, the irrelevant questions that are argumentative. And it is an argumentative question.
It's
It's
a
an
lit-
argument of counsel. I'm glad to let him try his case, but he should do it properly.
I am. It's a legitimate question. He's on cross, and I'd like to ask him a question.
Overruled. Ask the question.
Would a towel over your head, sir, conceal your identity?
If you can give me a hat and a towel, I'll show you I had it.
Well,
And they have it over my face.
your head, correct? I mean, your testimony was you were going to wet the towel and put it up over your head.
Like it would.
And my question to you is, Montell, would that to some extent conceal your identity?
No, sir.
You do admit that you drank water, is that right?
Yes, sir.
And as I understand your testimony, Montell, at the point in time that you went over to the spigot and Kellen was over to the spigot, can I have the witness go down, Judge? You wrote it. Thank you. Stand over here so we can see. As I understand it, you set your gun and Kellen set his gun up on the propane tank. And as I understand your testimony, that's the last time you touched your gun. So when you left the Citgo, your gun, according to your testimony, was sitting up on this tank right here. All right? And if we're looking at Mr. Dara's diagram, that would have been right here. Is that correct? And that's the last time you held State's Exhibit number 2. Okay, thank you, sir. Have a seat. Now, as I understand your testimony, you did not pick up the gun once you got your drink, is that correct?
Yes, sir.
Did you observe whether or not Kellen picked up his gun after he got his drink?
I don't know.
You do not know whether or not he was holding his gun, is that
Yes, sir.
correct? How long were you at the spigot, Montell, before you saw Mr. Kolokorius come up to the store?
But I don't remember.
Now, what first drew your attention to Mr. Kolokorius?
Because I looked up and they were running the store.
All right. Now, do you remember speaking to a Do you remember speaking to an agent with the Georgia Bureau of Investigation initially on July 15th, approximately 7:35 p.m., while you were at the medical center?
Yes, sir.
All right. Do you remember that gentleman's name by any chance?
No, sir.
Does Special Agent J.D. Brannion ring a bell?
No, sir.
You do remember speaking to an individual who identified himself as a GBI agent? Montel, do you remember what you told him?
No, sir.
May I approach the witness, please? Montel, do you recall telling Agent Brannion that statement?
No, sir.
Let me ask you then. Did you tell Agent Brannion, quote, as the white male walked into the store, he waved his hand acknowledging the presence of Clark and Butler?
No, sir.
Did you tell Agent Brannion with the Georgia Bureau of Investigation that the white male walked into the store?
No, sir.
Would that be a mistake then?
I guess.
Do you know, Montel, whether or not Steve Kolokorius saw these guns in and around you and Kellen when he walked into the store?
He had to.
And why do you say that?
He wouldn't start shooting.
Do you know that for a fact, or are you just guessing?
Just guess.
Montel, do you think Mr. Kolokorius was running, or was he just jogging?
Running.
All right. Was it like a 100-yard dash kind of run, or was it kind of a trot?
Kind of a jog.
Kind of a jog. So if I were to say that Mr. Kolokorius might have been jogging into the store, is that a little more accurate?
I guess.
All right. Well, I'm asking you. Don't let me put words in your mouth. Would you agree that he was jogging into the store?
No.
Tell me then, what was he doing?
He was running.
All right. Did Mr. Kolokorius say anything to you?
No.
Did you say anything to him?
No.
Did he give you a dirty look?
No.
Did you give him a dirty look?
No.
I believe you indicated that Mr. Kolokorius threw up his hand kind of like a half wave. Is that right? Is that true?
I guess.
Well, don't guess now. Tell me, did it happen or not? Did he throw up a hand like, hey?
No.
Or what's up?
No.
All right, so, let me approach again if I can, Judge Fuller. Same paragraph. Montel, in the statement here, as the white male walked into the store, do you recall making this statement to Officer Brannion?
No.
All right. Let me ask you this. Did you tell Officer Brannion that he, referring to Steve, waved his hand acknowledging your presence?
No.
All right. Did you not say that?
No.
All right. Therefore, as I understand your recollection is, Steve Kolokorius never threw up his hand. Did he even ever acknowledge your presence according to your testimony here today?
Say what?
As I understand your testimony here today, Mr. Kolokorius ran into the store. Did he even look at you all?
I guess he did. Yeah, he looked out.
All right. Well, let's not guess. Did he look at you?
Yeah.
All right. Did you look at him?
Yeah.
Did you make eye contact like me and you were doing? You did not make eye contact. Do you know if Kellen, you may not know this, do you know if Kellen made eye contact with Mr.
I don't know.
Kolokorius? Did you say anything to Kellen, or did Kellen say anything to you about Steve running in the store, or walking in the store, or jogging in the store, whatever it
No,
was?
sir.
And as I understand your testimony, the next thing that you recall happening is shots being fired. Is that correct?
Yes, sir.
And come on down with court's permission again. Speak up nice and loud. I don't hear you. case were represented in this diagram as being right here, would you agree with that? Go ahead and make a little X. Can I do that without messing you up? Sorry. I want him to make a little X on this diagram showing exactly where he was standing when the shots rang out.
You know, I wouldn't have an objection, except I expect some other witnesses who were there to be using the same diagram, and therefore I would not.
Okay, let's try this. Montel, stand on that side. Put your finger exactly where you were in this diagram. And would you agree that that puts you about in the middle of the propane tanks? Is that correct? That's your recollection? Shots, all three shots? Okay. But the first shot, you know which shot hit you? Do you know if any shot hit you? Well, you can't see a bullet, can you? Go ahead, go back. Did the bullet hit you? You know if it was a piece of... I'm sorry.
Start over with, did you see the bullet hit you, I think.
Thank you, Judge. Did you see the bullet hit you, Montel?
No, sir.
Do you know if it was a piece of glass that may have hit you?
No, sir.
Have they ever recovered the bullet as far as you know?
No, sir.
After the first shot, you indicated you started running, is that correct?
Yes, sir.
And you ran off to the side of the building.
Yes, sir.
Now, Montel, when Mr. Darrow was doing his direct examination of you, I understood that you started to say that you wanted to walk back across the front of the building. Did you say that?
Yes, sir.
All right. Tell the jury why you would walk back across the front, or you wanted to walk back across the front of the building.
To the other side where I was going, before I came back down that side.
Did you start off to walk in front of the building before the shots came out?
That's how I got shot.
All right. And so before, let me make sure I understand this. Before the shot came out, you said you started to walk off in front of the building, which would have been in this direction. Sorry, you can't see that. In that direction.
Yes, sir.
How far did you get before that shot rang out?
That's how far I got to the end of the pound.
So in other words, you started out going home in front of the building before the shot came out, right?
Yes, sir.
How many seconds was it when you started to walk before the shot rang out?
About 2 or 3 seconds.
All right. So I'm going to look at the clock. You're standing at the propane tank. Your gun's on the propane tank. You start to walk off. Bam! Is that about right?
Yes, sir.
All right. Were you going home without your gun?
I think I had my gun in my hand. I don't know.
All right. Now, Montel, I probably wrote down about 4 or 5 times on direct where you said you were sure that you had laid the gun up on the propane tank and never picked it back up.
I really don't remember.
Well, you may not, but you said on 4 or 5 occasions on direct examination, did you not, that you never picked back up the gun after you got your drink of water.
I said it did.
All right. And you just acknowledged that you started walking away from the propane tanks 2 or 3 seconds and the gun went off. So you would have been at least some distance from the propane tanks, right? Did you have the gun in your hand?
That's when I was looking. I looked up, and I was looking to see what he was running in the store for. And I walked and see what he was running in the store for. That's when I got shot.
Montel, was the gun in your hand or was it not in your hand?
No.
All right. So you were walking off, leaving your gun behind.
I was seeing what he was running in the store for.
Would you agree that's not what you said on direct?
Yes.
All right. So would you agree you've changed your story, Montel?
That's argumentative, Your Honor.
He's on crumbs. All right. Now, in your statement to this gentleman, special agent in charge, lead prosecutor, lead investigator, well, not lead prosecutor, lead investigator, Mr. Kersey, you made a statement in your lawyer. Was it your lawyer's office? Where was that statement made? Do you remember?
Nope.
Do you remember giving a statement where there was a videotape rolling?
Yes, sir.
To Mr. Kersey?
Yes, sir.
Do you remember telling Mr. Kersey on a number of occasions you were absolutely positive the gun was on the propane tank and you never picked it up again?
Yes, sir.
All right. And you would agree that that statement is inconsistent with what you said here today?
Objection. That's an argumentative question. Counsel can argue these things, Your Honor, and just because it's cross-examination doesn't mean a question is less argumentative.
This is the
And
best.
it's an objectionable question.
All right, let me hear the question again, son.
You told Kersey, and you said on direct, that you put the gun in the propane tank, got your drink, and never picked it up again.
Yes, sir.
All right. Then, when I asked you about walking off, you indicated you walked off for a couple seconds, the shot rang out. I asked you about you forgetting your gun back at the propane tank, and then I think...
wasn't.
I'm sorry.
I wasn't going nowhere. I was going to see what he was running for.
All right. Let me ask you that then. When you were going to see what he was running in for, was the gun in your hand?
No, sir.
It was still in the propane tank?
Yes, sir.
All right. So you weren't walking off to go home, right?
I was seeing what he was running for.
Can you explain for the jury, Montell, how it is that if you're standing at the propane tanks here and over here, that you were shot, assuming Mr. Kolokorius was standing right here?
So I was walking toward that way.
So I just thought you said that when you were shot, you were standing in front of the propane tanks.
Oh, I didn't know when I was shot, so I couldn't say it.
Now you don't know?
I don't know when I was shot.
Would you agree, in theory, under the laws of physics, as I understand them, which is pretty limited, that you could not physically be struck by a projectile standing in front of these propane tanks, assuming an individual discharged a firearm in that direction?
Your Honor, I'll object. The witness has not been established as an expert in the law of physics, and therefore the question is objectionable to asking an opinion of that nature. There's no basis for it. It's an argumentative question besides that.
I'll sustain objection. I'll let you ask the probability or improbability from this witness's perspective, but just limit your question to that.
Thank you, Judge Cole. Can you explain how it is you got shot in the neck if you're standing in front of the propane tanks, assuming that individual who discharged the weapon was standing here?
Right, so I was standing in front of it. I'm talking about the other way.
All right, let's come on back down with course permission, Montell. Come on down. Thank you, and I appreciate the court reminding me. Don't forget it. Okay, Montell, stand back over there, if you would, please, sir. All right. Initially, as I recall, you put your finger there, right, where you said you were standing. Now, tell the jury this time where it was you were standing when you were shot, best your recollection.
When I was shot, but I was not.
All right. So you're still maintaining you were here? Did you not say a minute ago you were walking over to see what the man was running in for?
That's why I was standing there when I started walking.
All right. So put your finger now where it was you think when the bullet went off and you were shot.
I was walking this way.
All right. We're moving here a little bit. Put your finger best you can recall. Right here. Now we're about at the end. Don't let me put words in your mouth. You tell me.
Right here?
About right there. Okay. Have you been back? Were you back at the store a couple days later to see where all the activity was? Did you notice that the window was shattered right here? Did you notice that the bullet hole was right here? Did you notice that the broken glass was right here? But you're saying you were shot over here. Can you explain to the jury that if the shattered glass and the bullet holes are all here, how it was, and we're talking here in this picture, okay, how it was that you got shot over there?
That's what I understand.
You don't understand that, do you? Okay. Thank you, Montell. You don't have an explanation for that, do you, Montell?
No, sir.
Would a reasonable explanation be, perhaps, that you were standing in front of the door with a gun in your hand?
I wasn't that close.
You weren't that close. And You agree you have no explanation for that, do you?
Sir.
Thank you. You agree, though, that's where the glass broke in the front door.
Yes, sir.
And actually, even to the left of that, you agree with that?
Yes, sir.
And you agree the bullet hole in the frame was in the front door frame. Is that right?
Yes, sir.
And you would agree that there's no bullet holes in and around the propane tank. Is that right?
Yes, sir.
All right. Let me ask you again, was the gun in your hand when the shots rang out?
No, sir.
Was the gun in Kellen's hand when the shots rang out?
I don't know.
You left as soon as that shot came out, and by the way, you didn't even know you were hit by glass or a bullet until later on down the road, right?
Yes, sir.
Can you tell the jury if you know that if you left your gun on this tank, which is depicted here, how the gun ended up over here and over here? First of all, let me backtrack. Did you know that's where the guns were found?
No, sir.
If that fact were to be shown, would you have an explanation, Montell,
No,
how
sir.
the guns ended up in front of the store?
No, sir.
This is your gun.
Yes, sir.
You didn't move it, right? Did you see anybody move it?
No, sir.
Did it go on its own? Did it move on its own?
I don't know. Can't move on.
Mr. Dara asked you if you were scared, and you said you were scared.
Yes.
But you also said, and this is a quote, "I didn't know I was getting shot at." Is that right?
I did know I was getting shot at.
Let me tighten that question up a little bit. I'm sorry, I apologize. You didn't know you were shot.
Yes.
Is that true?
Yes.
When did you first figure out that you'd been either shot or hit by some flying glass?
When we had came out of the bush and I was like killing, I haven't been hit because it felt funny for me.
Now, you said you had some tape on it at the hospital?
Yes.
Did they stitch it, do you know, or did they tape it?
They taped it.
All right. Did they say anything about what's called a flesh wound?
Objection, Your Honor. Some of the
Well, all right, let me ask you this. Montell, is that a serious injury to you?
Yes, sir.
All right. Were you in intensive care?
No, sir.
I believe you said you stayed in the hospital overnight, is that right?
Yes, sir.
Were you admitted? You know what that means, admitted?
No, sir.
Admitted means they check you into the hospital. Were you checked into the hospital for any kind of surgery or anything like that?
I don't remember.
Did you have to have a blood transfusion?
No, sir.
I think, did you say Kellen said it was just a little cut when he looked at it?
Yes, sir.
All right. Is that what Kellen said?
Yes,
Just
sir.
a little cut? And that's about right. It was just a little cut, right?
No, when I looked at it, it was.
All right. Now, as I understand it, Montell, the officers at some point put handcuffs on you and read you your rights. Is that correct?
Yes, sir.
And did they carry you down to the city to give an interview?
No, they took me to the hospital.
Did they carry you down to the city at any time?
No, sir.
Were you ever formally arrested?
Huh?
Were you ever formally arrested in this case, as far as you know?
No, sir.
Were you ever booked? You know what booked means?
No, sir.
Where they take a picture, like
No,
Mr.
sir.
Kolokorius, when they stick him in jail, make a mug shot out of you,
No,
put
sir.
it in the newspaper, print your name?
Objection.
You do anything like that?
Your Honor.
Were you ever taken to jail,
No,
Montell?
sir.
Montell, in your later statement that was videotaped with this gentleman, Mr. Kersey, did you tell Mr. Kersey that you saw a dude coming up, going into the store? Did you tell him that?
Yes, sir.
Did you tell him next, quote, he waved? Did you ever tell him that?
I probably did.
All right. Now, why would you tell him that he waived on July 18th and today say that you never said that before?
No.
Your Honor, I want to object to the question only on this grounds. He asked him about a statement in a different statement to another individual earlier. Now he's asking about new statement to this agent, and yet intimating that we're talking about the same statement. And
I'll clear
therefore,
that up. I'm sorry.
I object to that.
I'll try to clear that up.
I didn't hear the intimation, but Ms. Summer, with this witness's age in particular, if you'll make it clear as to what statement you're talking about.
Thank you, Judge. I'll do my best. Okay, Montell, you gave a statement at the medical center to an Agent Branyon. You don't know the dude's name, but you remember talking to some guy
Yes, sir.
about the case. And I think I asked you if you told him that the dude, meaning Mr. Kolokorius, waved his hand acknowledging your presence. And correct me if I'm wrong, but when I asked you that a little while ago, you said you didn't say that, right?
Yes, sir.
Okay, is that true? You didn't say that?
Yes, sir.
All right. Now, jumping to July 18th, with the interview that's on videotape, I ask you again if you recall making a statement to this gentleman, Special Agent Kersey, quote, he waved, meaning Steve. Do you remember, first of all, making that videotape statement?
Yes, sir.
Stop there. Do you remember talking to Agent Kersey?
Yes, sir.
Do you remember telling Agent Kersey, quote, he, meaning Steve, waved?
It's like threw up his hand.
Well, you tell me.
That's what I said.
He threw up his hand? All right. Now, let me ask you, what is the truth? Did Steve throw up his hand, or didn't he?
He did.
He did. Then why would you tell the jury that he didn't earlier?
Your Honor, what he said in the question earlier, Your Honor, is that he did not recall making that statement to that man, and said that he didn't make that statement to that man. That is not to say that the man didn't do that, and therefore the question is improper.
Judge, we'll
Recall what the testimony was. Try to rephrase your question, Mr. Summer.
I'm sorry, Judge, and I'm trying to be clear here. Did you or did you not say, in my earlier questioning, when I asked you, did Mr. Kolokorius wave, you said no, or correct me if I'm wrong?
Yeah, I said he didn't wave.
You said he did not wave. All right. Is the truth of the matter that he did do something like that, throw up his hand? Is that true?
From what I seen, he did.
He did. Okay. Like, kind of friendly. Yo, what's up? Right?
It happened so fast, man.
All right. Well, I mean, is that it? I mean, he didn't give you the finger, did he? He's like, yo, what's up? Right?
I guess.
All right. Do you remember telling Agent Kersey that we, referring to you and Kellen, were going to go in front of the store to get to this path y'all wanted to take home?
Yes, sir.
All right. Is that true? Y'all had to go in front of the store?
We didn't have to. Could have went to the back.
All right. You could have gone to the back, and I'm going to pick this up again. Isn't it true that you told Agent Kersey that you wanted to go in front of the store to go home?
Mm-hmm.
And you could have gone that way, and you could have gone this way, right?
Yes, sir.
But you told him you wanted to go that way.
That's the way.
Taking you directly in front, correct?
Yes, sir.
What other kind of games, Montell, have you played with these guns?
Now, I ain't never played games with no gun.
All right. You never played any kind of games with these guys?
No.
Cops and robbers?
No, sir.
Cowboys and Indians? Nothing like that? Then why did you have under your bed a replica .45 semi-automatic weapon?
Because it wasn't even mine, it was my little brother's.
I thought you said to this jury, States 1 was your gun you kept under the bed.
It wasn't mine, it was mine, but it wasn't, I didn't use it.
All right. What did your brother use it for, if you know?
Objection, Your Honor. It's absolutely irrelevant anyway.
All right. What was your brother doing with it?
I don't know.
Did you say to this jury on direct this was your gun?
It was both ours.
But you didn't tell the jury that, did you?
I didn't have to.
Well, didn't you say it was your gun?
Yeah.
It is your gun. Right?
Yeah, it's mine.
And this is the gun you keep up under your bed. Right?
Right.
And it's broken. Right?
Right.
No legitimate legal use as far as you know for this gun. Right?
Objection, Your Honor. It's a BB gun, and the question's improper. It implies that he knows the law in reference to BB guns. It is an improper question because he doesn't have a good faith basis for saying there's no legitimate legal use for a CO2 BB gun. And
Judge.
And it makes an intimation that's improper. It doesn't matter whether he's got him on cross-examination or not. He needs to follow rules of evidence, and he needs to do it properly.
Trying to get to the truth.
All right, I'll sustain the objection. You can ask the question, just leave out legal purpose, if you would. And also, with the use of the gun, don't twirl it around like that, if you would, for me, please, Mr. Summer.
I won't do that. Let me make sure we're on the same page, Montell. The gun was broken, right? You never played with it.
Yes, sir.
You didn't have any use for it.
Yes, sir.
You kept it up under your bed.
Yes, sir.
Why would you keep a replica .45 semi-automatic up under your bed if you had no use for it?
Where else gonna put it?
In somebody's face in a robbery, maybe?
No.
Thank you, Montell.
All right, Mr. Derrick, any redirect for Mr. Butler?
No, sir.
All right, Mr. Butler, you may come down from the witness stand. Ms. Roberts, if you will.
Your Honor, I think because of the time, I'll call a shorter witness in time. He's back from out of state. So
All right, let's do that, Mr. Derrick. I indicated we would quit about 5:30. I don't want to call any other lengthy witnesses. If you can call a short witness, please.
I think so. It'd be Mr. William Warner.
Tell Ms. Roberts who that is.
She knows, Mr. William Warner. Yeah, I'm sorry. I didn't realize.
Judge, one thing, I want Mr. Butler with the state.
No objection.
He will do so. Thank you. Face to the jury box and raising your right hand and taking this oath for me, please, if you would. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God, and any evidence you'll present to this jury that is trying the case styled in the Hall County Superior Court by indictment number 97CR1306, the state of Georgia versus Stephen Paul Kolokorius, for 3 separate and independent counts? Count 1, aggravated assault. Count 2, aggravated assault. And count 3, reckless conduct. If you so swear to tell the truth, so help you God, please state, I do.
I do.
Lower your hand, have a seat, please, and if you'd be kind enough to speak into the microphone for us.
Good afternoon, sir.
Good afternoon.
Would you state your name, please, for the jury?
My name is William R. Warner.
Yes, sir. And where do you reside, sir?
I live in Rock Hill, South Carolina.
And are there occasions when you come to Georgia?
Yes, sir.
How far is Rock Hill from here?
220 miles.
What is your
Approximately.
business, sir?
I'm a field engineer for Dennis Apparatus. I work on heat control systems for synthetic fiber.
And do you travel in that business?
Yes, sir.
And does that travel from time to time bring you to the Gainesville area?
Yes, sir.
I want to direct your attention specifically to Tuesday, July the 15th of 1997.
Yes, sir.
Did you have an occasion to be at a Citgo station on the Athens Highway on that particular afternoon?
Yes, sir.
And why was it that you were at that location?
I stopped to buy fuel, buy gas.
And if I showed you a picture of that station, do you think that you could perhaps recognize it?
Yes, sir, I'm sure I could.
Let me show you an item previously tendered and admitted as State's Exhibit number 3. Have you seen that location before?
Yeah, yes, sir.
Does that
I
appear?
believe that's it, yes.
Okay. Did you pull your vehicle up to one of the stations or pumping islands there?
Yes, sir.
Do you remember, if there were 2 pumping islands, do you remember whether you pulled up to the one nearest the store or the one
I
furthest?
pulled up to the one nearest the store.
Nearest the store?
And they use the pump as you're turning into the pump island. I used to pump on the far side, on the nearest as you turn in to the pump.
The nearest side as you turn in?
Yes, sir.
Okay. So that would be the pump that would be nearest to the front door, is that?
No,
Okay.
that'd be the other one.
Okay. Was your vehicle parked on the side that's closest to the store at that island or away from the store at that island?
Closest to the store.
All right. Did you see any individuals as you were pulling in?
Yes.
Who did, well, would you describe the 2 individuals that you saw?
Okay, as I was pulling in, I noticed 2 gentlemen running behind the store, on the side of the store behind it, through the field. And the only reason it caught my attention, the gentleman kept looking behind him. He had some type of blue helmet on, of some sort, hat of some sort. It was 2 black gentlemen, Afro-American gentlemen.
Okay. As you were facing the store,
Yes, sir.
were they running around the right side or they running around the left side?
The right side.
How about the best you can do with any physical description besides being 2?
Okay, one looked probably, fairly, slender, looked like he was, pretty physically fit.
Okay.
The other gentleman was heavier, husky build, probably maybe, 5'8", 6 foot, somewhere in that area. It's too far to really tell, how tall they were. But they looked pretty tall, the one guy did.
Okay. Did you pump gas into your vehicle?
Yes.
Did anything draw your attention as you were doing that?
Yes, I heard glass shattering, and at that time I stopped pumping gas and kind of looked around the vehicle and saw the glass had fallen all over the place, and I finished pumping my fuel, and then I saw a weapon laying on the ground, looked like a 9mm or something like that, and about that time the police pulled up.
Okay. Did you hear any shots at all?
No, sir.
Okay. But you did hear glass break?
Yes, sir.
As you pulled into the store, did you notice whether or not any of the glass was broken at that time on the front of the store?
No, sir, I did not notice that when I pulled in. I wasn't really paying attention to it, to the store itself.
Okay. And you said you heard the glass break, and then did you see any of the glass fall?
Yes, sir.
And where did you go then?
I finished pumping my gas, and like I said, that's about the time when the police officers pulled in, and I gave one of the police officers my card.
You said you saw something on the ground. Is that correct, Mr.
Yes, sir.
Warner? And where was it that you saw that?
It was between my vehicle and the store.
Okay.
It was approximately, in this picture, about where the propane, just before the propane tanks.
All right,
Yeah.
I'll show those, show that to the jury here in just a moment. At this point, I'd like to show you an item that I'm going to mark State's Exhibit number 8. Can you testify whether you recognize the item shown in State's Exhibit number 8?
Yes, sir.
Okay. I'll tender number 8 this time. Okay.
States 8 is admitted.
And what is number 8?
That's my credit card receipt.
All right. And is this your signature, in fact, on
Yes,
there?
sir.
Okay. Does this credit card receipt show what time it was that you paid for your gasoline? Let's take a look at it.
Yes, it does.
Do you recognize?
16:48 and 45 seconds.
And do you recognize what the term 16 would mean?
Yes, sir. That's 4:48 military time.
And more specifically, then 4:48 p.m. Is that correct?
Yes, sir.
Now, from your recall, would that time as indicated on that receipt be accurate to you as you remember
was
it?
pretty accurate, yes.
Did you see any of the events prior to you hearing the glass fall and seeing the glass fall?
No, sir.
Other than what you testified about the people that you saw run around
Right,
the
that's
site?
all I saw was just two people running. I couldn't recognize them if I saw them today.
Were
to be
they
honest with you.
already around the side of the store? Were they?
Oh, yeah, they were behind the store, running
Behind
through
the
the
store?
field, yes.
You remember how much money you spent on the gas at that point?
It was 20, I mean, at the time when when I heard the glass break or altogether?
Well, altogether.
Altogether it was $20.65.
Okay. Well, I mean, if you know.
I had no idea.
Okay.
When that happened, I just wanted to get my gas pumped and get out of there.
All right. Did you get a pretty good full tank at that point?
Oh, yes, yes.
Did you go in and pay for the gas?
No, sir. The owner of the store came outside to my vehicle and took my credit card inside. He just, brought it inside. I waited there, and that's when I gave the officer my business card. And Mr. Patel, I found out his name was later, brought my card back, my receipt and card back to me. I signed it, and then they moved the police car so I could leave. And I told them where I would be staying and everything that night.
Okay. Now, this one, I'm sorry, I wanted to ask you then this. And we'll call this State's Exhibit number 9. Let me show you State's Exhibit number 9. Do you recognize the location, at least, shown by this photograph?
Yes, sir.
Your Honor, I will tender State's number 9.
No objection?
No, sir.
States 9 will be admitted.
And do you recognize the farther away location
Yes, sir.
of this item here in State's number 3?
Yes, sir.
Okay. Well, what is it about the location that I'm pointing to here, if anything?
What do you mean? What is it? It's,
Well, what is
it's a
that?
gun.
Okay.
It's a gun in a bag.
All right.
Well, partially in a bag. Looks like a 9mm.
At the time that you observed this item, did you observe it at that location?
Yes, sir.
Okay. At the time that you observed it, did it have the bag on it?
Yes, it did have the bag on it.
Do you recall?
To my recall, I believe it did.
Were you there before any officers arrived?
I was there just before the officers arrived, and I saw the gun after the officers arrived.
You saw the gun after
Yes,
the
sir.
officers arrived?
After the officers arrived,
Okay.
I saw the gun.
All right. Did you at any time see this gun before the officers arrived?
No, sir. No, sir, I did not.
Okay. So, do you know or did you see how it was the bag got there?
No, sir.
At that? Okay.
No, sir.
Did you ever see, to your recall, the gun without the bag?
No, sir.
And only saw that after the officers arrived?
Yes, sir.
I see. I don't think I have any further questions for Mr. Warner.
I'll just leave that with you, Mr. Warner. Thanks for coming down from South Carolina. I know it's been a long drive. My name is Dan Summer. We spoke on the phone briefly.
Yes, sir.
All right. Mr. Warner, do you have any firearms training, sir?
Do I have any firearms training?
Yes,
No.
sir. All right. You refer to that gun in the bag as a 9mm. Why do you do that?
I've seen 9mm. I've got friends that are law enforcement officers, and it looked like, you know, a 9mm they carry.
Did that gun look like a 9mm to you?
At a glance, yeah, kind of.
Did you ever get a good look at the gun?
No, sir. I never went close to the gun.
Do you know at this point in time whether it's anything but a 9mm?
I have no idea.
Your first reaction when you saw the gun was what?
Just stay away from it because, you know,
But I
something
believe-
had happened.
All right. But what I'm getting at is, what did you first think when you saw the gun in terms of what the gun was?
What do you mean? What do you mean in terms of what the gun was?
What did it look like to you?
It looked like, you know, 9mm. You know, it's something of that nature.
Okay.
No.
It looked like a cap gun?
No. No, it was a little bit heavier. It looked like a cap gun. It looked like a solid weapon, yes.
Solid, right?
Yes.
Realistic.
Yes, very realistic.
Would you be surprised to learn it's a BB gun?
I would be surprised, yeah.
Thank you, Mr. Warner. Have a safe trip back.
No further questions, Mr. Warner.
All right, Mr. Warner, you may come down. Mr. Warner may be excused. Is that correct, counsel?
Yes, sir.
All right, then, Mr. Warner, you may be excused. Thank you for coming. You may leave. Thank you. All right, ladies and gentlemen, we're going to take this opportunity to recess for the evening. If you'll make sure you follow strictly the instructions that I've given you previously, I will not repeat those. Just make sure that you recall at all times in your service in this case that anything you learn about this case needs to come from inside this courtroom. Any other contact that you might have with it, make sure you avoid it at all costs. So with that, I'll look forward to seeing you at 9 o'clock in the morning in the jury room, please, and we'll get started at that time. You're in recess. Thank you.
Welcome back. I'm Fred Graham. Carol Randolph and I have taken over here in the Court TV studios. We're going to take a quick commercial break here. We come back, we will continue our coverage of this case after this.
I'm with you at that time.
No.
Okay. About what time was it that you left Tanner's place?
I don't remember.
Okay. Were you looking at a watch?
No, sir.
Were you keeping track of what time it was in any way?
No, sir.
When you left Tanner's house, where did you go and how did you get there?
First, we was walking, and he was on his bike. And then this dude named Javante came up, and so he pulled me, and Tony pulled Kelly.
All right. Let's go through that a little bit. You said Tanner was on his bike?
Mm-hmm.
All right. Whose bike had a problem with the tire?
He had two bikes.
He had two bikes, okay? So Tanner was on a bike that did not have a problem with the tire, is
Yes,
that correct?
sir.
I see. And then you and Kellen, did y'all have any vehicle or were you still on foot?
Still on foot.
All right. And then you said somebody was pulling somebody?
Yeah, Javante Stevens came up, and then he pulled me to my house, and Tony pulled Kellen to it.
Okay. How did those people pull you all to your house?
On the back of a bike.
On the back of a bike. Okay. I'm trying to picture this if you don't mind. I mean, did you ride on the back of the bike?
Yes, sir.
I see. And Kellen rode on the back of the other bike with the other fellow named Stevens?
Tony. I rode on the back of the bike with Javante.
Durante Stevens? Okay. And Kellen rode on the back of the bike with Tony?
Yes.
I see. And you went where?
To my house, to the trailer park.
Okay. Did Tony stay with you there?
No, sir.
Did Stevens stay with you there?
No, sir.
Were you and Kellen still together?
Yes, sir.
What did you and Kellen do at your house at that point?
I fixed me something to eat, and then I found that gun right there and gave it to him.
All right, now you're talking about which state's exhibit when you...
One.
Okay. Yeah, and you gave that one to him?
Yes, sir.
And when you mean you gave it to him, I mean, did you give it to him as a gift so that it was his, or did you just...
I was like, I don't need this one no more, so you can have this one.
Okay.
So,
You told him he could have it?
yes, sir.
Was it his at that point?
Yes, sir.
I see what you mean. What, if anything, did you and Kellen do with those guns then at your house there?
Put them on the stand until we got ready to leave.
Did you play with them at some point between you and Kellen? And if so, where did you do that?
What you mean?
Did you play with them at some point, you and Kellen?
When we had them with us?
Did y'all point them at each other at any point?
No, sir.
Okay. When, who else was home, if anybody, at your Floyd Road address in the trailer park when you and Kellen were there and you had both the guns out, the BB guns out?
Nobody.
No one. Okay. How long did you all stay there, you and Kellen?
Until I got finished eating.
You may or may not remember this, but do you recall what you were eating?
No.
Okay, did Kellen eat too?
Yes, sir.
Did you go to cooking something, or did y'all make a sandwich or something like that?
Made the sound.
I see. Was that your lunch on that day?
Yes, sir.
All right. Had you eaten anything at all during that day before then, except for the tater chips that you described earlier?
No, sir.
Okay. Do you remember how long it was you and Kellen stayed at your place then?
About 15 minutes.
If it seems that the direct testimony of this young man is simply meandering around, well, there's a certain amount of validity to that. But the kernel of the purpose by the prosecutor is to attempt to show that here were these two teenagers on a muggy summer afternoon, and as teenagers would, they were rather aimlessly wandering around. They did happen to have two very realistic-looking weapons. They were BB guns. They were not harmful, but they looked very dangerous. The defense has already told the jury in opening statements they're going to attempt to show that the young men were moving around to set themselves up to rob a convenience store. The prosecution is trying to head that off in advance. We'll take a break. We'll return after this.
When I saw it at the scene yesterday, just casually walking by. I thought it was a Smith 9mm automatic. So it is very realistic just to a casual observer.
Could you tell the difference between a real gun and a fake one? Well, County Jailer Stephen Kolokorius couldn't, and it landed him in a lot of trouble. And welcome back to Court TV. I'm Carol Randolph. Kolokorius mistook 2 BB guns for real guns and shot at the 2 teenagers carrying them. Now the state of Georgia has him on trial for aggravated assault. And once again, we're showing you some testimony that occurred earlier today, day 1 of the case against Mr. Kolokorius. Once again, one of the victims, this is MONTELL Butler, who's on the stand. He was 15 years old at the time. And we're going back in as he continues now with his direct examination, telling that jury about the summer of 1997 and the incidents leading up to the shooting. Let's listen.
Where did you go then? And how did you get there?
Started walking.
From Floyd Road? Am I talking about the right location where your house was?
Yes, sir.
Okay. And where did you go?
To Gaines Mill Road.
To Gaines Mill Road. Okay. Do you know how far that is?
It's a pretty good walk from where I used to stay.
A pretty good walk, and then you said what?
From where I used to stay.
From where you used to stay on Floyd Road? Okay. Do you where you live now, is that a little bit closer than where it was then? Okay. I'm going to show you a map in a minute. Maybe we can see some of these places, all right?
Yes.
What route did you take? What roads did you go by when you were on foot between Floyd Road and Gaines Mill Road?
We cut down there where they building no new houses at down there.
Were they building some new houses? Were there any roads up through there?
Just dirt.
Okay. Were they preparing a road along that dirt that you're talking about?
Yes, sir.
I see. Was that place open to the public yet for travel, as far as you know, from what you were able to observe? Okay. But as far as walking along it, could you walk along it?
Yes.
Okay. Do you happen to know the name of that subdivision? Is it built now or not?
I got part of it done, but not all of it.
What's the condition of that roadway now? Do you know?
No, sir.
Do you know whether or not it's still dirt or whether it's paved now?
It's paved. They got grass and houses down there now.
Do you know whether or not there are any people living down there in those houses?
No, sir.
Okay. But you know it's a new road that's been paved?
Yes, sir.
Back then it wasn't. Is that correct?
Yes, sir.
I see. Now, you even met Courtney before then?
Yes.
Okay.
I knew her.
You knew her, but you didn't know where her house was?
Yes.
Did you know where Tyler's house was?
No, sir.
Had you ever been to Tyler's house before that date?
No, sir.
Well, then when you and Kellen got to Tyler's house, how about 1 and 2? Did you have State's Exhibits 1 and 2 with you?
Yes, sir.
Who had which? Or did one have both or what?
I had the second gun. He had the first one.
Okay. Now, when you walked up from Floyd up to Gaines Mill and you were going to go see Courtney, but you stopped off at Tyler's, what were you and Kellen, if anything, what were you doing with those BB guns?
We just had them in our hands. Okay. Walking with them.
From Floyd to Gaines Mill, by the route that you took, did you go along Athens Highway at any point on the way to Gaines Mill?
Yeah. Yes.
You did? Okay. And when you were walking along Athens Highway on that occasion, was there a sidewalk?
No, sir.
How close were you to the road as you were walking along the Athens Highway on that occasion?
We were pretty close to the road.
Okay. On what side of the road were you walking? The road facing traffic or on the side of the road that was with traffic?
Facing traffic.
On the way to Floyd over to Gaines Mill on that occasion, when you ended up at Tyler's instead of going to Courtney's, that's what we're talking about right now, besides holding the BB guns in your hand, did you do anything else with the BB guns on that walk?
We might put them in our pants or something.
Okay. Did you have any holster or anything of that nature?
No, sir.
And when you said put them in your pants, describe where it was that you would put them.
Right here, close to your belt buckle.
In your waistband, in front?
Yeah.
I see. Did you have on a shirt?
Yes, sir.
Did Kellen have on a shirt?
Yes, sir.
When you would put them in your waistband, did you leave them open then, or
No,
was
sir.
your shirt pulled over them?
Yes, sir.
Did you have any reason in particular to pull your shirt over them at that time?
No, sir.
Did you ever have any particular reason to pull your shirt over them?
No, sir.
Were you trying to hide them from anybody at that
No, sir.
point? Were you trying to hide them from anybody at any point?
No, sir.
When you were walking from Floyd over to Gaines Mill and you ended up at Tyler's house, can you tell me whether or not you had the guns mostly in your hand or mostly in your waistband?
Mostly in our hands.
Now, as you were holding them in your hands, you and Kellen, as you were walking from Floyd over to Gaines Mill, when you got to Tyler's instead of going to Courtney's, this is the time I'm talking about now, were you doing anything with the guns between you and Kellen?
No, sir.
When you got to Tyler's house, who was home?
Tyler.
And I'm trying to remember whether you had met Tyler before then.
No, sir.
Was this the first time you'd met Tyler?
Not the first time, but the first time I had been over his house.
I see. So you knew Tyler some before then, is
Yeah,
that
a little
right?
bit.
Okay. Now, what did you and Kellen and Tyler do at Tyler's house?
We sat on the porch, and he got us a glass of Kool-Aid.
Tyler got you a glass of Kool-Aid?
Yes.
Did he get himself one, too?
No, sir.
Okay. Did you have anything to eat?
No, sir.
Go back in your memory, Montel. I want you to tell me everything that you did at Tyler's house. Remember the best way you can. Everything that you did at Tyler's house.
We sat on the porch.
No, not on the pump.
So how is it, if you know, that one could see through the video camera outside looking in?
I don't know.
All right. Is it possible that there is not a camera outside looking in?
It was in, one camera is on the register direction.
Yeah, but that camera's in the store, right?
Right, inside the
All
store, right.
Think
We
so.
don't have camera in outside of the store.
Okay. So it would be impossible to have a video from the outside looking in. Is that correct?
Yes, sir.
But it is possible, to some extent, to see things that are going on around and near the cash register. Is that correct?
Yes, sir.
Was your video camera system operating properly the day this
Yeah,
happened?
yes.
Have you seen, by any chance, the videotape
Yes,
of what
sir.
happened?
Mm-hmm.
Do you recall what you saw being what you remember?
Yeah.
Would you agree that if the video perhaps showed something a little different, you would defer to what the video showed rather than what you recall from your own memory? That's a hard question, I'm sorry.
Yeah, right.
All right. If you said something happened one way,
Okay.
and the video showed another way,
Right.
would you agree that you would go with what the video showed?
Yeah, I think so.
All right. Now, Mr. Patel, what time of day was it when the young African-American male walked in the store?
It's around about in between 3:30 to 4.
In the afternoon?
Yes, sir.
And would you tell me, please, exactly what he said to you?
Right. The guy walked in and he was looking for the water. He asked me the water fountain, and I told him water is outside.
Right. Did he come in and ask for permission to get a drink?
No.
He came in to ask where
For
the water
just
fountain
water,
was.
yes, sir.
And the water fountain is outside, is that right?
Right, it's not fountain, but water tap.
A tap, a spigot is what we call
yes,
it.
yes, sir.
And you can see that spigot very clearly, can't you?
No, there's a propane tank right behind that.
All right. Is the water spigot behind the propane tank or off to the side?
Up to the side.
All right. Someone standing in front of the propane tank could see the water spigot off to the side.
Yes, sir.
It's not obscured by anything or hidden by anything. Is that right?
No.
Can you recall at all how the young man was dressed?
I don't remember that much.
You indicated to Mr. Dara that when the young man came in, you saw another young man standing outside. Is that correct?
Yes, sir.
Do you recall where he was standing in front of the store?
No, I didn't see him.
I'm sorry, I thought you just said you saw another young man outside.
Right, they're walking. I saw them walking.
Right. Where were they walking?
I don't know how to say that, but on the front side of my store.
Right. Do you remember giving a statement to Agent Kersey, who's not here right now, a gentleman with the Georgia Bureau of Investigation?
Mm-hmm.
Do you recall telling him that you could see, quote, two black males outside of the store but near the door?
No.
Did you not tell him that, or do you just not recall telling him that?
No, I didn't tell them.
You didn't? You're denying that you told Agent Kersey that you saw the two young men outside of the store but near the door?
Right, outside of the store, not near of the door.
All right. May I approach, please, Your Honor? Mr. Patel, I'm going to put up something different here. I'm going to put this up here. Can everybody see that in the jury? If you would, let's sort of go over this. Do you recognize this establishment?
Yeah, that's
right. What is that?
Okay, this is a gas station.
This is your store?
Yeah, this is my store. This is right.
Okay, go ahead.
You go ahead. You ask me, I can.
All right, thanks. We'll point out some things for the jury.
Yeah, okay.
Better
the water, water tap is over here.
We're having a jury trial this time.
Oh, I'm sorry.
Sometimes we have a bench trial, but this is a jury trial.
Yeah,
so
I'm sorry.
That's okay.
Yeah, the water tap over here, okay? I saw the guys, two guys from here, they're walking. One guy was going over there. One came inside the store.
All right. So you saw two young men walk up. And
walk up over here.
One stopped here.
One over there, right.
And then did he stay there?
I don't know that. I didn't see after that.
But they came up from this direction.
This direction. One going on over here. I don't know he was standing over there or walking.
Now show the jury where that little water spigot is.
Over here.
All right. So let me ask you, Mr. Patel.
Okay.
If two people came up this way and stopped here, could you see that water spigot?
From over here?
No, sir.
No, I was inside.
I know. Listen to my question.
Okay.
We'll get through this. Two young men walk up here. One stays there, and the other one comes into the store.
Right.
Now, if two people were walking here and one stopped here, can you see the water spigot from where they were?
It was a small tab, you know. If you pay attention, then you can see.
All right. So would there have been anything preventing anybody who was standing right here from seeing that water spigot?
I don't know. Depends.
All right. That's fair enough. So one individual stayed here, and then another one went inside?
Right.
All right. At that point in time, when the young man came into the store, did you see anything in his hand?
No, sir.
Did you see anything tucked up under his waistband?
No.
Did you see this?
No, I didn't see that.
All right. Did you see this in the other young man's hand?
No.
Did you ever see these two things, states 1 and 2, being placed up on the propane tank?
The police guy found one bullet or gun, I don't remember, from outside.
All right.
Over here.
All right, let me ask you again. Did you ever see those two young men place states 1 and states 2 up on top of the propane tank?
No, sir.
All right. Stay with me here. Look at this diagram. Do you recognize that diagram?
Okay, yeah, this is our register. This is a door. This is a register. 1 register, 2 register. Okay.
All right, keep describing. Describe everything in the store for us.
The guy came here inside and come here, asked me the water. I told him water fountain outside.
And where did he go?
He just left.
And then where did he go?
He just left.
And where did he go?
Go outside on this one. I don't know, did he drink water or not.
How about the other young man? Did you see him outside the store?
No, I didn't see him.
For example, did you see him over here, walk back over here when the other young man came out?
No, I didn't see that.
Did you see him here in the photograph when the other young man came out, walking across the storefront?
No, I didn't see that.
Go ahead and describe the rest of the store. What's all this stuff?
Okay, this is all aisles, 3 different aisles. We put that oil and all the merchandise.
All right.
And this is a cooler. This is a fountain, Coke fountain. This is coffee machine. And this is a backside storage, office.
All right. Would you point for the jury where the cameras are located in your store?
Yeah. One over here.
And which direction is it facing?
Facing toward this side.
So if the camera, is it mounted in the ceiling or on the wall?
On the corner.
All right. And is it pointed in this direction?
One right.
So the field of vision would be person standing in this area, correct?
This camera shows who's coming in, who's out.
All right.
Okay? And one camera over here too.
And what direction is that camera pointed in?
This one.
So the field of vision is in here.
Right.
All right. And how about another camera?
One here, one over there. Okay?
And
here,
this field of vision would be like that?
Right, like that.
So from this camera, can you see what's going on at the cash register?
Right.
All right. Return, please. Thank you, sir. Now, you indicated that a customer came up sometime at or near the shooting incident?
Before or after?
You tell me.
Yeah, it was before one guy left. Okay?
All right. Was it the same person who purchased gas and paid for it with the credit card?
No.
All right.
That another one. After shooting, that same guy, right? After shooting, that he used a credit card.
All right, let me ask you a question. It doesn't seem to be very important, but it might be. Did you walk out and get his credit card, this customer, or did he go in the store and give you his credit card?
Right, I don't remember that much.
All right. Did you say on direct examination that he came into the store and paid with a credit card?
No, I don't remember that.
All right. Mr. Patel, you were speaking with your wife, is that right?
Yes, sir.
And how long had you been on the phone when all of this occurred?
I think I started, I dialed and that guy came, and I don't remember, did I talk or she talk, and I hang up. It was on or off, I don't remember that.
All right.
But she heard, only she heard, call the police like that.
Who said call the police?
That guy.
Mr. Kolokorius told you to call the police?
Yes, sir.
Did you call the police?
No, I was so shocked. I told him to do that.
All right. And did he call the police?
He did that, yes, sir.
Right. Did he say anything else to you when he told you to call the police?
No.
Right. Let me get back to the phone call. Do you recall what you were speaking to your wife about?
Yes, sir.
And what was that?
About just general talk, about the kids.
All right. About the case or about business?
About the kids. I have 3 kids, After school, they are at home or not.
Children?
Children.
All right. How many children do you have? 3?
3, yes,
How old
sir.
are they?
17, 14, and 12.
Are they all in school?
Yeah.
Are they doing well?
Oh, yeah.
Good.
They are scholars.
All right. And you were talking to, what's your wife's name?
Gita.
Gita?
Yeah.
It's my mom's name. It's interesting.
Is that right?
And you were talking to Gita about the children.
I didn't talk too much, and I don't remember what I talk and what's it right.
Were you what's called engrossed in a conversation with your wife? When your wife talks, you listen, right?
Right.
All right. And she was talking and you were listening, right?
Right.
And you were paying attention to that, right?
After that, the guy came. I didn't pay any attention, so I don't remember what, I don't know what I talked with her and what she talked, you know.
All right. Prior to the guy coming in, whatever you were talking to Gita about, you were focusing on that, right?
Right.
So you really weren't paying a whole lot of attention to the goings-on of what was happening outside while you were talking to your wife.
Right.
And that's perhaps why you can't remember a whole lot in particular.
That's an argument of the question, Your Honor.
I'll rephrase. Yes, sir. Would you agree that your attention was more focused on your wife's conversation than what was going on outside the store?
No, I was watching everywhere, inside and outside, while I'm on the phone.
All right. But you agree you can't remember what happened to the young man after they left, the young man after he left the store? Other than going to the fountain?
No, no, I don't.
Approach, please.
Right.
Mr. Patel, do you know which direction Mr. Kolokorius was shooting when he fired the 3 shots? Yeah, that's a great idea. Come on back now for permission, Coach. Show the jury with the pointer where you recall.
Okay, he came inside, okay? There's only one way we can go in out, okay? And there's a 2 register here.
All right.
And he came here, and he stayed here and started shooting by the door and window.
By the door and window.
Right, and he was keep moving, okay? Like here to here.
Moving back and forth.
Right.
And your test?
I was over here.
All right. Did you have a phone in your hand?
I don't remember. I hang up or I don't know. It was on or so.
It was a cordless phone, is that right?
Yes, sir.
Not one with an extension cord, but a cordless phone.
Yes, sir.
And your testimony is he was shooting right in the front door area.
Right.
And if we look at the photograph of your store,
right,
can we see broken glass? Show the jury where the broken glass is in your store.
One broken glass was over here.
All right.
Second here, and third was that. It was 2 door. 2 door was broken, and 1 window was broken.
All right. In and around this area.
Right. Yes, sir.
So it appeared to you, and correct me if I'm wrong, that the person was shooting at something in this area.
Over here.
Or over here.
Yeah.
But this area is where the bullets were going to.
That's true.
Were the bullets going down here to the propane tank?
I don't think so.
All right. Thank you, sir. Now, you indicated that when Mr. Kolokorius came in, you thought you were being robbed. Is that right?
Right, because I did not know. I don't know he's a police guy, and he did not tell me anything. You know, he's a police, and what's going on outside. So that's why, you know, I was so shocked.
He just
started the shooting.
Right.
And after he told me to call police, that time I realized he's a police guy.
Right. He never told you when he came into the store that he was a police?
No.
He just went behind the counter and then started shooting?
Yes, sir.
All right.
Nick, approach the bench, Your Honor, this time.
You may.
And as you see, the attorneys have rushed to the bench. Nancy Ginsburg, here, what is happening is a sidebar outside the jury's hearing. And the reason for sidebars is to protect the appellate record. In other words, make a record of what's happening, but make it outside the jury's presence. You want to make a speculation about what this sidebar is about, clearly related to this witness.
Well, clearly question has been asked, and the prosecutor is objecting to it, but they don't want to state their objections on the record in front of the jury. If they state their objections in front of the jury, then the jury will know what they're talking about.
Exactly. And many times, once you state an objection, the jury hears your whole line of thinking, and basically you've given the witness's answer in front of the jury by your speaking objection. Here on the stand, Mr. Patel is going through the events of that evening, and the defense is trying to make an issue as to whether or not he actually was paying that much attention to the events because he was on the phone with his wife.
Well, if they can show that he wasn't paying attention, then they can discredit him as a witness who has information about the event.
Another issue here, I think the defense attorney, Mr. Summers, has really developed quite a rapport with the jury. And another thing, Nancy, he seems to be communicating better with Mr. Patel than the state did. In fact, I noticed the state having to explain their questions on direct examination. Clearly, the witness was not prepared by the state before the witness was put on the stand.
Well, it's clear that Mr. Summer has a very easy-going way about him, and that helps him connect with the jury, which is good for him. This is the prosecution's witness, however, and the prosecution should have prepared its own witness.
I noticed when the state asked the witness whether or what was the demeanor of one of the teens that evening, they had not prepared this witness as to what they were talking about and had to step back, rephrase the question, and it was like pulling a tooth from Mr. Patel. Not any fault of Mr. Patel's on the stand, but clearly he had not been prepared regarding the question. And as you can see in the courtroom right now, the court reporter is standing up at the bench along with the attorneys, just typing furiously. You can see that a bench conference is going on. Let's take a quick break so we don't miss any live courtroom activity. Join me back for live testimony. Kolokorius says he thought the sit-go was being robbed, and he fired his weapon, grazing one of the teens on the neck. Two questions that will be answered in court may lead to his downfall. Number one, what type of weapons were the youths holding? The answer, BB guns. And number two, were they robbing the store? Well, apparently, the cashier didn't think so at the time. And now the jury has a question of its own. Is Kolokorius guilty of aggravated assault and reckless conduct? When we left the courtroom, the attorneys were gathered at the bench. They're still there, so let's take this opportunity to discuss the law for a moment. Nancy Ginsburg, as you know, an armed robbery can take place with a replica weapon. It doesn't have to be a real weapon. In fact, it's more what was in the mind of the victim at the time of the robbery. And very often, guns that don't work, guns that haven't been fired in 20 years and couldn't possibly work, have been used in armed robberies, so to speak. So here, when the sheriff saw what he believed to be legitimate weapons, they were BB guns. Do you think these jurors will consider his thoughts to be legitimate?
Well, that's the whole case. Yeah. They have to decide, based on the evidence, whether or not they believe that his beliefs were legitimate.
And here at a distance, seeing two teens outside the sit-go station, my only question was, why didn't he just simply pick up his cell phone, call for backup? I know he was off duty and was not in his law enforcement vehicle, but to open fire, he's got a lot of explaining to do. Any speculation or a wager as to whether he will take the stand?
Well, I suppose it depends on how the prosecution's case goes. I believe that the defense attorney will evaluate the case at the end of the state's case to decide whether or not he wants to put his client on the stand. If he feels that the prosecution has not put forth enough evidence to prove its case, and he may not put his client.
Nancy Ginsburg, of course, no defendant is ever in a criminal case under the obligation to take the stand. They have an absolute right to remain silent in court. But it seems to me here, trial strategy-wise and practically speaking, the jury is going to want to hear from Kolokorius, to hear his thoughts. I mean, the defense can only carry it so far with witnesses. At some point, the jury's going to want to get inside of his head and find out what he was thinking. I see veteran defense attorney Dan Summers going back and forth to counsel table. It looks like the bench conference is breaking up. The attorneys are returning to their relegated sides of the courtroom like two boxers in the ring. Let's go back into the courtroom.
Mr. Patel, you've indicated that when Mr. Kolokorius came in, you thought he was a robber. Is that correct?
Yes, sir.
And he never said he was the police?
No.
And he never showed you a badge?
Yes, sir.
Mr. Patel, tell the jury why you would think Mr. Kolokorius was a robber when he came into your store.
The way he came in, the way he started shooting, and that wasn't cause. I don't know why he did like that.
All right. Let me ask you this. Did the fact that Mr. Kolokorius have a gun make you think he was a robber?
Right. The way he came with the gun.
So you would agree that seeing a gun in your mind created the thought that this person is a robber?
Yes.
If he'd come in holding a Coca-Cola, would you think he was a robber?
I don't think so.
All right.
Nobody can rob with a Coca-Cola.
All right. If he came in holding his baby, would you think he was a robber?
I don't think so.
All right. The thing that made you think he was a robber was a gun.
Yes, sir.
Had a person, any person, come into your store, whether it was Mr. Kolokorius, Mr. Clark, or Mr. Butler, with this gun, you would have thought they were a robber.
No. When he started shooting, that time I know that he's a robber.
All right. But he never robbed you.
I don't know what's going on. He just started shooting, so I thought, fourth aim should be on mine.
Right. But did Mr. Kolokorius rob you?
No.
No. All right. He called the police, right?
What?
He called the police.
No. He asked me to do that, and I told him to do that. That time, right, he did that.
Okay, then he called the police.
Right.
He never took any of your property.
No, sir.
Didn't take your money.
No.
Didn't threaten you.
No.
All right. Have any person come into your store with a gun, would you agree that the first thought in your mind is, oh good, it's gracious, this person is going to rob me?
Objection here, Your Honor, because of it offers speculation through the question.
Overruled.
The issue that the jury would be determined.
All right, and overruled. Yes.
If a person came into your store with this gun,
right,
would you agree that the first thing that you would think of, and pardon me for pointing it, is that, oh no, this is a robbery?
The gun is on the hand.
The gun in the hand?
Right. There. Yes, yes.
All right. Let me ask it this way. If you're in your store...
Okay.
Okay. Yeah, you can stand there.
Yeah.
And you look out and you see two individuals walking across the front of the store with the guns up, starting to point in your direction. Wouldn't you agree that the first thing you're going to think of is, oh my goodness, right, these people are going to rob my store?
Yes, sir.
Objection, and move to strike the answer. The question is hypothetical, based on no facts before the jury, based on no evidence before the jury, improper. The rules of evidence should be followed in this trial. I object to the question.
Move. All right, overruled. Thank you, Judge. If two people, black or white, man or woman, young or old, were walking across the front of your store with guns up, you would think, oh no, they're about to commit a robbery.
Right.
Now, why would you think that?
With the gun.
With the guns.
Right.
Why would you think that?
The people using the gun for the bad thing. Okay?
Right. You're a reasonable person, aren't you?
I don't know. I'm not perfect.
You seem like a mess. It's the gun that would make you think robbery.
Not all the guns. So many police car came here, so I don't think it's robbery.
Let me ask you one other thing. It wouldn't be necessary for the person to actually open the door, walk in, stick a gun to your head for you to figure out there was a robbery about to occur, right?
Robbery or murder.
Or murder.
Right.
Right. Just a moment, please, Your Honor. Mr. Patel, you've been very kind. Thank you, sir.
Oh,
for the question.
thank you.
Just a couple of questions. When the young boys, after the fella who asked where the water spigot was, went outside the store, could you even see the propane tanks from where you were at that time?
Yes, sir.
But when they were out at the propane tanks and the water spigots, were you watching them at all at that time?
No.
Okay. Do you know from your own personal knowledge then whether or not they put anything they had on top of the propane tanks?
No, sir.
Okay. So when Mr. Summer asked you whether or not you saw them put anything on the propane tanks or they put anything in the propane tanks, you wouldn't have any way to know that. Is that correct?
Right.
I see. That's all I have. Thank you.
Can I just ask one other question? Mr. Patel, when the young man came into the store to ask, did he ask for permission to get a drink of water, or did he ask for water?
Asked for the water.
He asked for water. Did you know that Mr. Clark had a gun in his waistband?
Objection, Your Honor. Based on, well, I think there's some evidence, but
there is.
Okay, I withdraw the objection.
Did you know the young man had a gun in his waistband when he walked into the store?
No, I didn't see that.
Would it have made a difference to you had you seen the gun?
Right now, yes.
Thanks.
Mr. Dare, any other questions?
He untucked his shirt and hid a gun in his waistband for this witness.
You saw no gun, and nobody held any gun when the young man came to the store, correct?
You're right. That's correct.
He had no gun in his hand.
Right.
Was he nice to you?
Right. He didn't ask any money or he didn't try to rob me.
Was he polite?
Right. He was polite.
Did you have any concern about him?
No.
Thank you. No further questions.
Summer, any further questions?
Thank you, Judge Nestor.
All right, Mr. Patel, you may come down. May he be excused?
I'd like to leave Mr. Patel on call, and I've discussed that with him before, but he could be excused from the courthouse at this time.
All right, then I'll excuse Mr. Patel, subject to telephone call notice. Thank you. You may leave.
Your Honor, I'll call Chris Vickery at this time.
And as you observed, the ploy used by the defense attorney there was pretty effective. Dan Summers untucked his shirt in front of the jury and hid a gun in his waistband and approached the witness. He got the witness, Mr. Patel, to say in front of the jury it would have made a difference had he known the young man was armed when he came into the sit-go station. Now, Nancy Ginsburg and I were discussing why it's so important as to what Mr. Patel was thinking. What's your take on that, Nancy?
Well, I think the defense is trying to show if Mr. Patel believed that they may have been a robber, then the defendant could have believed that they may have been robbers.
Could have reasonably believed it. And another issue here we've learned is that the defendant could actually see the gun and Mr. Patel could not. Will that make a difference? Let's go in live.
Nothing but the truth so help you God in any evidence you present to this jury that is trying the case that is styled in the Hall County Superior Court by indictment number 97 CR 1306A is the state of Georgia versus Stephen Paul Kolokorius for 3 separate and independent counts. Count 1, aggravated assault. Count 2, aggravated assault. Count 3, reckless conduct. If you so swear to tell the truth, so help you God, please state I do.
I do.
May lower your hand, have a seat, and please speak into the microphone for us.
Ms. Vickery, good morning.
Good morning.
Would you tell us what your name is, please?
Christopher Paul Vickery.
Ms. Vickery, you told me at an earlier time it's the first time you've ever testified in court. Is that correct?
Yes.
Because a jury is sometimes can consider things like that, are you a little bit nervous this morning?
Yes.
We'll try to take it carefully. What is your job, Mr. Vickery?
I work as a firefighter paramedic for Hall County Fire Services.
And what generally are your duties in that way?
Fire suppression, emergency medicine, in the field.
Are you sometimes called upon to go to locations where people may have received injuries?
Yes.
And where is the station that you would be dispatched from?
Permanently would be ASIC 7 off J.C. Jewell, Fire Station 7.
Yes, sir. Is that where you were stationed on Tuesday, July the 15th of 1997?
No, sir.
Okay. Where were you stationed then?
129.
Where particularly along 129 South is Station 1 located?
Half a mile north of 323, Gillsville Highway, on the left.
Half a mile north of Gillsville Highway? Okay. Are you familiar with a location known as the Sitco station at 21? Be a Kangaroo before then.
Yes, sir.
And how far is that station from that location, approximately, if you don't know exactly?
No more than a mile and a half.
Did you respond to a location in connection with the incident that is the subject of this trial?
Yes.
Where did you first respond?
I do believe the store beside of the dirt road. There's 2 stores there, I believe, and I can't remember which store it was, but we responded to the store that was dispatched to.
Are you familiar with the store known as Ferguson's?
I do, I guess. Not.
Okay.
At the time of the call, I didn't.
Well, let me ask you this. Do you recall whether or not you responded to the store that is shown on this exhibit, State's Exhibit number 4? Was that store or a different store?
That was the store I believe I pulled into.
Okay. Was a man named Clark R-U-A-R-K with you?
Yes.
And does he work with you, do the same sort of work?
He is not my partner, but we do the same job.
I see. Did y'all come in the same vehicle or different vehicles?
Same vehicle.
Did you stay at the store where you first responded to?
No, when we got to the store, we had negative contact with the patient.
Okay. Did you go then to another location?
Yes.
What location did you go to?
Went to a dirt road adjacent to the store.
Okay. Are you familiar with that particular dirt road? Were you familiar with that particular dirt road at that time?
I knew they was cutting a dirt road.
Okay. Are you familiar with that road now by any chance?
Vaguely.
Do you know whether or not it's completed or not?
No, sir.
You don't? Okay. How did you get to that dirt road?
We got back on 129 north, headed north on 129, and made a right turn onto the dirt road.
How far did you go down the dirt road?
A quarter of a mile.
Is that
through dust, dry dust, and maybe 4 minutes to travel it, 5 minutes.
Okay. So is it an estimation on your part about how far down the dirt road that you went?
Half a mile. I'm sorry, about a quarter of a mile.
Okay.
No more than a half a mile.
All right. And I guess what I'm asking is that based on looking at your odometer or
No.
just a guess on your part there? All right, sir. Now, did you eventually make contact with the patient at that location?
Yes.
Where did you first see that person?
I saw the patient in police custody.
Okay. Was he cuffed?
To the best of my knowledge.
Was there another person who is not a law enforcement officer there?
Yes, a city rescue.
Okay. Was there another young fellow who was there besides the fellow that was the patient?
Yes.
Who was he a civilian, the one I'm talking about
yes.
now? And would you describe him, please?
Young black male, 15 years old maybe.
Okay. The person that you describe as a patient, did you at some point learn his name?
Yes.
Do you recall what that is specifically now?
No.
Okay. Do you recall whether or not you've heard the name Robert Montel Butler?
Yes.
Not? Do you recall whether or not that was the patient?
I can't say that he is the patient, but from remembering my trip report, putting the name with the trip report, probably is.
Is that the name that you wrote on your trip report as being the patient?
I didn't write a trip report.
Okay. At any rate, you treated only one person there,
yes.
Is that correct? What was it that you observed, if anything, about what injury he had?
He seemed to have a laceration to the left neck and very minor cut to the ear and the jaw.
What could you tell, if anything, about the laceration to his left neck? Would you describe that the best way you can?
Very little bleeding. Looked like a puncture wound. Superficial.
Okay. Did Clark, in your observation, can you tell whether Clark Ruick also observed that or not?
Yes.
Okay. Was the person that you treated ambulatory or not ambulatory? And if you could explain what that word means, I'd appreciate that too.
Yes, he was ambulatory. Ambulatory means he was walking, able to get to the med unit without a stretcher or assistance or being carried.
Right. How was it that, did you participate in his treatment there at the scene?
Yes.
What did you do for him there?
I believe I set up the IV line and set up the IV bag, and I drove.
All right. Who was attending to him during the drive?
Clark.
Do you recall whether that person you treated said anything to you?
No, just scared.
Did you write out a report of your involvement?
Yes.
Did you review that report some yesterday?
Yes.
When was it that you made that report or wrote out that report?
Maybe half a month or a month later, the incident.
Do you recall whether or not you put the date of August 5th of 1997 on that report?
Yes.
Would you recognize a copy of that report if I showed it to you again?
Probably.
Is this an accurate copy of the second page of your report?
Yes.
And is this your handwriting that you put it in?
Yes.
Okay. Do you recall in looking at this part of your report here whether or not the patient that you treated said anything to you? Looking at this part right in here.
Yes.
What did he say to you? Does that refresh your memory,
Yes.
sir? And what was it that you recall he said to you?
That he didn't understand why a man shot him. Came in the store and shot him.
Did you clean the ambulance later yourself?
Yes.
Did you check on that patient after you did that?
Yes.
If you like, you can refer to your report, and I'll go back and stand where I was before.
All right.
What was the nature of the conversation that you had with him on the second time you had a conversation with him?
I told him that he was lucky, that I thought he needed to thank God and maybe consider getting in church, and I wished him the best of luck.
How did he talk to you?
He was still maybe not in a physical shock, but in a state of shock, kind of nervous. But said he mainly agreed and all.
All right. Just a moment.
In a courtroom in front of a jury. Right now we're on a quick break. The judge gave the jury a seventh inning stretch, so to speak. They're out having a cup of coffee, and joining us in a few moments will be Court TV's Clara Tuma for the lowdown and the skinny about what's going on in that courtroom. Nancy Ginsburg, the last witness we were watching on the stand was firefighter Vickery. And in his own way, he described what happened when he got to the scene. Where is the state headed? Has Vickery added anything new?
I think the state put him on for a very limited purpose, and that was just to show that the complaining witness's character is good, that he was scared, and that he was polite again to the paramedic.
You're right. I think the state is trying to make the teens out to be very polite young men that were up to no wrongdoing that evening, but that's a very, very dangerous move by the state because, as you know, once good character is brought in on a witness, then the witness may be impeached by the other side with bad character, which would be a bad act, a criminal conviction, if there are any, and then the jury could be tainted against the victim if there is any bad character to be heard. I think you're right. I think the state is on a campaign right now to make the teens as likable, as congenial as possible to this jury, to have the jury identify with them. Also, I think the state brought this witness on to show that the victim was ambulatory, could walk around, could talk, was coherent. I think they're trying to indicate that what he was saying was with a clear mind. Now, that's a double-edged sword, because the defense will bring that in to show that the victims weren't harmed so much, or at least that will be the defense take on it. Do you see where the defense attorney, Dan Summers, is headed?
Well, with this witness, he'll try to show that the contact that the paramedic had with the teenager was limited, that the conversation that he had was irrelevant to the actual facts in this case.
I think one thing that the defense will bring out is, again, that the victims were ambulatory, that they were not in serious medical emergency shape. I think that he may question firefighter Vickery as to whether or not he saw a gun on the two teens, and whether that made any impact on him at all. And he may delve further into what was said at the scene, what these victims said, what the store owner said. I expect a lot out of Dan Summers on this cross-examination of firefighter Vickery. Standing by right now outside the courthouse, and we'll meet up with her after this break, is Court TV's Clara Tuma with the lowdown about what's happening in that courtroom. Everybody stay with us. Welcome back to Court TV, everyone. I'm Nancy Grace. A 26-year-old off-duty sheriff with a degree in criminal justice from Louisiana says he thought duty called last July. He says he observed two youths outside a Citgo service station brandishing weapons. He thought a robbery was occurring. That's his story, and he opened fire. One of the teens were grazed on the neck during the incident, and now the sheriff is on trial for aggravated assault and reckless conduct. Well, joining us as promised outside that courthouse in Gainesville, Georgia, Court TV's Clara Tuma. Hi, Clara.
Hi, Nancy.
Clara, you have with you Reverend Eugene Green. He is a pastor at St. John's Baptist Church. Welcome, Pastor.
Nancy, he can't hear you, but we say welcome to Court TV, Reverend. Thank you so much.
Thank you.
And Nancy, let me tell you before I ask Reverend Green a question, he has been actively involved in this case since the beginning, and he was in court yesterday. He watched some of jury selection there for most of the testimony, back again today. And Reverend, why are you here in court watching this trial?
Basically because I just believe in fundamental justice and fairness. And I wanted to have an opportunity to make sure that I was continuously participating in the process. This has been a concern for the entire community, and I just wanted to make sure that there was some closure to this, and the fact that it's part of the criminal justice system, they have 12 jurors seated, that's good news for me.
And when you say it's been a concern for the community, what is that concern?
It's concerned that any time that there is conflict with law enforcement, and particularly in our community where it involves young black males, it's a concern for us. And when this incident happened, there was, in my opinion, a very slow process in terms of acting. But I am grateful, and I can say today that justice has prevailed to this point. And I'm here today and on yesterday to see the culmination of that process, that these young men and the young man that's accused has finally got his day in court. And that's the way our system functions.
Now, let me ask you a little bit about what you thought about Mr. Butler's testimony yesterday. We heard from one of the young men yesterday. How did you think he did on the witness stand?
I thought he did well. I thought he was able to express himself, I'm sure, to the best of his ability. A bit nervous, but he told a story that I felt was good. I was pleased with it. My main concern is that this process has begun, and he has his day in court. And the accused officer has his day in court, have two capable attorneys. That's the process.
You said you were concerned about the system being slow to work. Was that because the two people, the two alleged victims, are African American, or because the defendant is white, or a jailer, or what was your concern there?
Well, it's obvious that they were black and the jailer was white. But my concern was basically about the fundamental fairness of it. I felt that the process was slow in terms of actually not only accusing the officer, but actually indicting him. And finally, the grand jury made that decision. I felt they were slow in doing it, but that was the process. And the community was very vigilant in asking that there be at least a speed up of justice in at least indicting the young man, and to give the community the opportunity to have him come to court and let the jurors of his peers make the determination of his guilt or his innocence. Justice delayed is always justice denied, and that was one of our concerns. And since it has come to fruition today that the jury has been seated, we'll have to wait in terms of the outcome.
Now, some people have told us that this incident and then the way it was treated in the system has sort of stirred some simmering tension between the African American community and law enforcement. Do you agree with that? Disagree with that?
I certainly agree, but the tension is always there. If there's going to be any tension throughout our history, it will be a part of law enforcement, and there's no exception in this county. There have been many persons who've acted very responsibly in terms of some incidents that takes place in the community. But yes, there's no question. There's always tension between law enforcement and black males. That's a part of it. But we have worked, and I hope we will continue to work to provide some sense of fairness and allow the justice system to do what it does best.
Now, on this jury, it's a 12-member jury, 11 whites, 1 African-American male. Do you have a problem with that jury composition, or do you think that's a fair breakdown?
I always have a problem with that. It's a matter of the process by which juries are selected. Now, if they're contending that it's fair, that may be the law, but it's certainly unfair in my eyes. But that's something that we have to continue to work on and push toward making a reality. But I don't think it's fair, even if it's the law by appearance. But results is not fair. Yeah.
Well, Reverend Eugene Green, thank you so much for coming to talk with us. We hope to visit with you again as the trial goes on and get your thoughts as we hear from the other young man and from other witnesses in the case.
Thank you very much.
Okay. Thank you so much, Reverend Green. Nancy?
Clara, we were watching the state's cases. It started off this morning, and of course the state and the defense always try to start their cases off first thing in the morning with a bang. The state chose to call Mr. Patel. What can you tell us about his testimony, Clara?
Well, Nancy, the state called him to try and show that he sensed no threat, that he did not feel a robbery was imminent, which is the whole defense case. He was there the whole time and says, hey, this one juvenile came in, but I never sensed any sort of threat from him. In fact, he called the young man polite in some of his final testimony.
Clara, Danny Summers, as I know him best, has handled a lot of high-profile cases throughout the Atlanta and the Gainesville area. He started his career in Atlanta and then moved to private practice in Gainesville. Interesting the way he did quasi-performance in front of the jury on the cross-examination of Mr. Patel. I know he had his back to you, but Clara, did you notice that at one point Summers untucked his shirt and hid a handgun in his waistband? And then when he held his shirt up, now the jury was privy to all this, although our viewers probably couldn't quite make it out. When he held his shirt up, showing his tummy, you could also see a weapon stuck in the waistband. Patel agreed on cross-examination that would have made a huge difference had he known the teens were armed. Did it make an impact on the jury?
Well, it may have, Nancy. He's been playing with those weapons from the beginning. In fact,
gee, I hope they're not loaded.
they're not, and there's a disagreement. Are those toy guns or are they replica weapons? The prosecutor says they're just toys. The defense says they look real to anybody who's not examining them up close. Yesterday, Nancy, he was twirling them like a six-shooter would twirl the gun, and the judge finally had to say, Mr. Summer, please quit twirling those guns. It seemed to be making the jury a little bit nervous because he stands 2-3 feet from the nearest juror. But he's been doing, he used them to point at one point today on the diagram he was using, trying to let the jury see those weapons as much as he can, because his contention is even experienced people who are experienced in guns would not realize that these were replica or that these were fake guns, that they weren't real unless you looked at them up close. From a distance, he says, it's all the same.
Well, Clara Tuma, from what you've just told me, Dan Summers' gun-twirling experiment worked, because it clearly worked up the fear in the judge and the jury, and that's just what he wants this jury to think that his client thought when he saw the weapon. So here Summers has, without a single word, provoked fear and nervousness amongst the jurors and the judge. And I guarantee you he'll use that in his closing argument to the jury. Excellent trial tactic. Let me ask you another question about Mr. Patel. It seemed as if he was not quite prepared on a lot of his direct examination. He had not been explained what was meant by the question demeanor, the demeanor of the teens as they entered the store. And his testimony, while clearly heartfelt and sincere, was halting. Was he prepared, Clara, for direct examination?
Well, I'm not sure, clearly not to the question about demeanor, because he wasn't certain what that word meant. But when he was asked to describe specific things that constitute demeanor, was he polite? How did he look? How did he treat you? Those sorts of answers, he answered those fine. He didn't seem to remember exactly what he had told the police officers, because there were a couple things when the prosecutor had to say, well, you say this now, but back then, didn't you say something else? But on cross-examination, he also seemed, it seemed to me, even though English is his second language, to pay attention to the question and to answer the question that was asked. He didn't get trapped into saying something he didn't mean to. He seemed very specific about nailing down the time frame of the question and nailing down exactly who the questioner, who the subject of the question was.
And of course, Clara, the store clerk, Mr. Patel's state of mind is not going to be the issue here. The issue is going to be the defendant, Kolokorius' state of mind. And of course, the teens will testify there was no robbery going on. But still, whether Patel believed a robbery was about to occur will go a long way with that jury. And I see that the defense is laying the foundation for inconsistent statements. As you recall, they asked Mr. Patel a few questions about what he told other people that evening. He said, no, that's not what I said. I think they're setting him up to bring on those witnesses to contradict his testimony. Clara, what, if any, is the relationship between these attorneys in the courtroom?
Well, Nancy, it's a lot of huffing and puffing, as we've seen in front of the jury, but it's not that way outside of court. Gainesville, Georgia is not Atlanta, Georgia. It's a smaller community, and here's the relationship. The judge used to be district attorney. While he was district attorney, the defense attorney worked for him as a prosecutor, as did the prosecutor worked for him as a prosecutor. Well, the judge later became a judge, and then the defense attorney and the prosecutor worked together as colleagues, working side by side on cases. Then when Dan Summer left the office, he's now an adversary. So there's a long-standing relationship, and you can see that mutual respect among the three of them, particularly among the two attorneys, because even privately, they don't snipe at one another or criticize the other. Even privately, that respect is obvious. So you see him in front of the jury making objections. My opponent needs to do this or that, but that respect is underlying it, and you can certainly see it when court ends. And you can see the way, Nancy, I'm sure you noticed when the defense attorney, Dan Summer, was pointing out something to the witness, and he just reached over and showed the prosecutor where he was reading from. A lot of prosecutors would have made a much bigger deal. I need to know where he's reading from. This is a smaller area, smaller courthouse. There's a long-standing relationship here, and that shows.
Clara, you are so right, and isn't it refreshing after all the cases we've covered where we often question the attorney's motives and their strategies to see attorneys that that hold their own in the courtroom but yet remain gentlemanlike toward each other and the judge as well. Now, that's an unusual combination, isn't it, Clara? And you and I have seen plenty of courtrooms where it's down and out warfare.
It is, and I don't mean to suggest, and I know you don't either, that one of them is rolling over or that they're not making the objections that they should make, because they are. And in fact, we expect there to be a mighty big fight later in the trial as they discuss whether they can get in the prior juvenile records of one of these alleged victims, and that'll be fighting with no holds barred in that. But as soon as that's over, then we see the attorneys are back to normal. Business is business. And when you finish the business, then you're friendly again.
Clara, you're right. We were discussing earlier, once you open the good character to a witness or a defendant, then the state or the opposing side, if they have the ammunition, can come back with bad character. Clara, thanks so much for joining us and for bringing us that interview with Reverend Green, who clearly is speaking for a segment of that community. Clara, I'll catch up with you later in the day. It's great talking to you as always. Everyone, the jury is about to come back into that courtroom. We don't want to miss any live testimony. Stay with me. For carrying weapons to rob a gas station. Well, it turned out they were BB guns and no robbery was taking place. And so, the off-duty sheriff, Kolokorius, was charged with reckless conduct and aggravated assault. On the stand right now, under cross-examination, firefighter Vickery. Let's listen.
How could you tell a bullet wound versus a flying glass wound with respect to what you saw, Mr. Butler? If you take away the fact that you had heard it was a shooting. Say you didn't know it was a shooting. Okay. And based on what you observed, could you tell if it was a bullet wound or flying?
I would think the glass would have a more of a laceration, jagged edge. The bullet had more of a blunt trauma, more, I'd say, round appearance.
Did you look at the wound under any kind of microscope?
No, sir.
Did you actually get up into the wound to see if it was jagged or straight?
No, sir.
Can you really tell if it was a bullet wound or a glass wound?
I would say it was a bullet wound.
And that's based on what?
Just the way the wound was round. Not much less round, but more kind of, it wasn't square or octated or nothing like that. It was just rounded.
But you described it as superficial, almost like a gash, cut, nick, right?
Yes, sir.
That's all. Thank you, Chris. Appreciate it.
Any other questions?
Mr. Vickery, aside, may I have our report?
Yeah, sir.
Do you agree that you described more than one wound that you observed?
I saw 3 wounds.
Did you state the patient seemed to have a gunshot to the left lateral neck?
Yes, sir.
Did you also state there was also a wound to the ear?
Yes.
And I think jaw?
Yes.
And there was no serious bleeding?
Right.
Thank you. No quick questions on this bit?
Any other questions?
Yeah, I don't mean to belabor the point, Judge. I'm just trying to firm this up in my mind. You said he had 3 wounds?
Yes.
All right. If it was a bullet wound, wouldn't you just expect 1 as opposed to 3? 3 would be more consistent with some, almost like a shattering in bits and pieces of projectiles flying through the air. Wouldn't you agree?
Yes.
Thank you.
I don't mean to belabor it either. But of those 3 wounds, did one appear to be a gunshot wound described with the round entry as you described?
Yes.
Thank you. No further questions?
I'm not going to beat a dead horse.
All right, Mr. Vickery, you may be excused at this time. Is that correct, counsel?
Yes, sir.
All right, thank you for coming. You may leave. Thank you.
Clark, Blue Arc.
And there you see firefighter Vickery leaving the courtroom. And clearly what the defense is leading up to here is that maybe a bullet never hit the teen at all, that maybe a flying bit of glass fragment is what hit the youth in the neck. Do you think it worked, Nancy Ginsburg?
No, there was no earlier testimony that anyone was hit by glass, although I think they're trying to focus on the photo of the broken glass window.
I think they are too, and the fact is, even if the defense doesn't prove that glass hit the teen as opposed to a bullet, if it raises a specter of doubt in one of the jurors' minds, it could be goodbye to the state's case. I see the state is calling the next witness. Looks like another firefighter. Let's go in live.
Swear to tell the truth, the whole truth, and nothing but the truth, so help you God, and any evidence you'll present before this jury that is trying the case is styled in the Hall County Superior Court by indictment number 97CR1306A is the State of Georgia versus Stephen Paul Kolokorius for 3 separate and independent counts. Count 1, aggravated assault. Count 2, aggravated assault. And count 3, reckless conduct. If you so swear to tell the truth, so help you God, please state, I do.
I do.
You may lower your hand. Have a seat and please speak into the microphone for us.
So would you state your name and your occupation?
Clark Cruark. I'm a paramedic for Hall County Fire Services.
And how long have you been employed in that capacity, sir?
Been employed for 10 years this month.
Do you have occasions in that capacity to respond to help treat people who have received gunshot wounds?
Yes, I do.
How frequently have you done that over the last 10 years?
Probably between 20 and 30 times.
All right, sir. I want to direct your attention to July the 15th of 1997. Did you have an occasion to respond to a certain location on that afternoon, and if so, about what time?
Yes, sir. We responded to what I refer to, I believe the store's changed names, but we knew it as the Kangaroo Store on 129 South, and we were dispatched at 16:58 hours.
Okay. Being dispatched 16:58, is that 4:58 p.m.?
4:58 p.m.
All right. What time did you arrive to that, which you described as the store that you had known as the Kangaroo?
We arrived at 5:02 at the Kangaroo Store. We had been dispatched to the area of the Kangaroo, and that's the time we got to that store.
All right. Do you recognize this store that is shown on State's Exhibit number 4 here?
Yes, sir.
Is that the store that you're referring to?
Yes, sir.
If it's referred to only as the Citco and not also shown there as being Kangaroo, or is it still nonetheless the same store?
Same store. It was previously a Kangaroo for several years.
I see. Did you stay at that location, or did you go to another location at that time?
We moved from that location after officers summoned us to come. There was another convenience store next door called Ferguson's, and just past there they had cut a new road into where they were going to start a subdivision, and they told us they'd located a patient down that road and for us to come to that location.
Were you and Mr. Vickery in the same vehicle or different vehicles?
We were in the same vehicle.
And who was driving?
Chris was driving.
What were your responsibilities to be when you got there?
When we arrived, we found a young black male that was in handcuffs, and we were advised by the officers that he had been hit by a bullet. We questioned them as to possibly what size bullet, being pertinent to the type of injuries it could cause. They advised us that they thought it was a 9mm. And we found this subject standing there in handcuffs with a gunshot wound, or what appeared to be a gunshot wound, obviously at the neck and a couple of other more superficial injuries.
Tell me about what you described as what appeared to you to be obviously a gunshot wound. What led you to those kinds of thoughts?
Well, naturally, being dispatched out on the call, we were dispatched on Signal 1, which is a gunshot wound. And when we found the subject, he had a wound on his neck, and it's a very unusual looking wound. It looked as if somebody had taken something about the size of your finger and had pushed a hole through the skin, and the skin was kind of puffed up and still kind of in a backward position when we got there.
Based on what you observed of the wound itself, did it appear to be a gunshot wound to you?
Based on the information given to us by the officers and the type of injury, it did fit the description of a gunshot wound.
Could you describe the shape of the entry of that wound?
It appeared to be basically a round type entry, and there was no exit. I felt around the wound trying to find the actual bullet. I could not find anything I could guarantee was it. Therefore, I didn't know which direction the bullet had taken, if it had grazed him and gone on, or if it had gone inside and taken another direction.
Okay. I think when I talked with you yesterday, you described something to me that you were able to observe there about the wound itself within the person's neck. What were you able to observe?
When we looked at the wound, we moved it around a little bit, trying to determine the extent of the damage. And what actually impressed me most about it was you could actually see what I assumed possibly to be a jugular vein. It was a large vein, and you could actually see it pumping inside this wound. So I knew it had come pretty close to some major arteries.
Okay. Would you describe the other wounds and their location?
He had a wound on the same side as the gunshot wound on the left jaw that was more of, if I had to describe it, it'd be an abrasion or a scrape type injury. Also about the same size as the hole at his neck. And he had a superficial wound to the right ear. It was more of just like a small scrape or cut type wound, very minimal bleeding.
Okay. As far as the two wounds on the other side of his head, did you make any observations of them? It gave you any thought about whether they might be related to each other?
The right ear, I wouldn't think possibly would be related, but these two here were pretty much in line with one another.
Right. What treatment did you give him there at the scene, if any?
We bandaged all of his wounds. Anytime you have a neck wound, it's hard to bandage because you don't want to cut off circulation, but we were able to put some pressure dressings over that and keep it clean and contain bleeding, which was pretty minimal. We went ahead, just due to the fact that we could see vessels inside the wound and didn't know the extent of the damage, we went ahead and started an IV line of lactated ringers just to keep a vein open in case we needed it later on, and transported. We did transport with lights and sirens to the hospital because, as I said earlier, I didn't know the extent of the injuries or where the bullet had gone. I felt it best to get on to the hospital.
All right. Were you the one with him during the travel to the hospital?
Yes, sir, I was.
Who, if either one, were there anybody besides you and Mr. Vickery dealing with the medical aspects of this?
We had I serve as an EMT instructor for a technical school, and we had an EMT student that was riding with us that day, and she basically assisted with some of the bandaging.
Okay. But besides you three then, were there any others who were assisting there?
There were two EMTs from the City of Gainesville Fire Department that were also on the scene, but they had minimal contact with the patient since we all got there about the same time.
I see. And was that person identified to you by name? You had not known this person previously, is that correct?
No, sir.
Was that person identified to you by name at some point?
At some point, they did identify him to us as Robert Montell Butler.
All right. Did you talk with Mr. Butler?
Very briefly in the back of the ambulance.
What is it that, did you make a recordation about that conversation?
I did. I asked him what happened, basically trying to assess what had gone on and to make sure that I did look for injuries in all the places that they might be found. And when I asked him what happened, and he did make a statement to me then.
When was it that you prepared your report?
The state trip report was prepared immediately after the ambulance run was completed, and then we were asked later on, several days later, we were called by the Gainesville Police Department and asked if we could write up a summary of what went on, anything we heard, anything that was said, and I typed mine up and sent it to John Sisk with the Gainesville Police.
All right. So whatever report, did your trip report indicate whatever he said, or was it whatever he said in the report that was prepared several
Not in the trip report, because it was not pertinent to patient care.
Okay. So whatever you wrote down to record what it was you recall would have been your recall several days after the incident. Is that correct?
We went back a couple of days and sat down and reviewed the call and made sure we were pretty well on track with what had gone on.
Okay. Could you tell us what it was you recalled at that time that you prepared your report, what it was he said to you?
When I asked him what happened, he informed me that he did not know that he was in the store and some white dude started shooting.
What else did he say, if anything?
That was the only thing that he said to me outside of where he was having pain. And
did you ask him whether he knew what type of bullet had hit him?
I had asked him, he didn't know, and one of the police officers on the scene told us they thought it was a 9mm.
I think that's all the questions I have, Mr. Rourke. Thank you. Mr. Summer may have some questions.
Thank you, Judge. Mr. Rourke, good afternoon. Sir, how long have you been an EMT?
Been an EMT since 1988.
10 years?
Correct.
What type of training and experience do you have?
I've been through 220-hour basic EMT course. I went through a 12-month paramedic course. I've challenged and passed the National Registered Paramedic exam, and I serve as an EMT instructor.
How many calls have you answered with respect to injured persons?
Total ambulance calls probably between 20 and 30 every month.
All right, so 20, 30 times 12 times 10? Many hundreds.
Several.
I would imagine 10 years, that kind of experience, you've seen about every kind of wound there is. Would you agree?
Well, there's always something new.
All right. The care that you provided to Mr. Butler on July 15, 1997, was it in accordance with your training and experience and your official duties?
I feel that it was.
Was it appropriate care?
I feel that it was.
All right. Did it matter to you whether he was young or old, black or white, rich or poor?
No, sir.
All right. You gave him the best help you could, is that right?
Yes, sir.
Now, with respect to the wound that you observed, actually the wounds, you said you saw 3, is that right?
Correct.
You went out to triage this individual with the knowledge that it was a possible gunshot wound, is that correct?
Correct.
And I note in your report you said this appeared to be a gunshot wound, is that correct? Can you state as a matter of fact it was a gunshot wound?
The only way I can state that is based on the evidence the people gave me. The state of Georgia does not allow EMTs or paramedics to make an actual diagnosis, so we cannot say for sure it is anything.
All right. You're not a medical doctor.
That's correct.
Now, when a bullet traveling at, what, 600-700 miles an hour hits a piece of glass, do you know what happens?
I sure don't. I'm not a ballistics expert.
All right. Would you agree that one might assume that the glass would shatter?
I would assume that, yes.
Would you agree that shattering glass, being hit by an object at a high velocity, would throw out a shrapnel-type material?
You know, he asked him a question, apparently trying to establish him as an expert. He answered it in such a way that shows that he's not. And then he's asking him questions of asking his opinions of things like this. I object to that.
That's a good objection. I'll move on.
Right, thank you.
Do you know whether or not Mr. Butler's injuries were consistent with perhaps shrapnel or shards of glass?
No, sir. I'm not able to make that decision.
All right. So as I understand what you're saying, you can't tell it was a bullet wound, correct?
That's correct. Correct. I'm just having to go on what I was told.
Nor can you tell if it was shrapnel wound, right?
That's correct.
Now, in conjunction with you going out there, you made some kind of report at or near the time. That's your ambulance report. And then you were asked by the city, Gainesville City Police, to do a more detailed report. Is that correct?
Correct.
And I believe Mr. Dare asked you if you heard Mr. Butler say something, and you said, he said, and I wrote this down, and correct me if I'm wrong, sir, that he, referring to Mr. Butler, was in the store and some dude started shooting. Is that right?
When we sat down, because we made an effort to make sure we got everything, and what we have down here is he informed me that he did not know that he was in the store and some white dude started shooting.
All right, and I've got your report here, and let me read you the quote. That he was in the store and some white dude started shooting, correct?
That's what I've got on this paper.
All right. May I approach, please? Mr. Rourke, let me show you a piece of paper. Do you recognize that piece of paper?
I do.
And what do you recognize it to be?
This is the report that we typed and sent to Officer Sis.
All right. Have you read that report?
Yes, I have.
All right. Is the copy that you have a true and accurate copy of that report?
Yes.
Is it your words?
That's my words.
Did you type that yourself?
I typed that myself.
All right. With court's permission, could I have Mr. Rourke read his report?
On July 15, 1997, at 16:59, I responded on Med 1 to the area of Ferguson's Convenience Store on Highway 129 South on the report of Signal 1B. This is a gunshot wound where backup is needed. We arrived at 1702 at the Kangaroo next to Ferguson's and were advised by officers that a possible armed robbery attempt had taken place and one of the suspects had definitely been hit by a bullet. This person had left the scene, and officers from the City of Gainesville Police and Hall County Sheriff's Office were attempting to find him. Shortly after our arrival, we were directed to go to the end of a new road being developed beside Ferguson's store. Upon arrival there, we found a young black male, later identified to us as Robert MONTELL BUTLER, who had what appeared to be a gunshot wound to the left lateral neck, a superficial laceration-type injury to the left mandibular area, and a minor laceration to the right ear. The subject was in handcuffs with his hands behind him. I asked the officer if he could place the arms in front to allow us to obtain blood pressures and to start IV lines if needed. He changed the position of the handcuffs at this time. While assessing Mr. Butler's wounds, I asked him what happened. He informed me that he did not know that he was in the store and some white dude started shooting. He had no idea of what type bullet had hit him when asked, and I felt it would be pertinent to the extent of potential injuries. An officer on the scene advised me that it possibly was from a 9mm shell. I, along with an EMT student that was riding that day, bandaged Mr. Butler's neck and mandible and proceeded to assess vital signs and establish an IV as a precaution. There were no unusual incidents during the transport to the emergency room, and care was turned over to the hospital staff at 17:20 hours. When questioned as to why the subject was in handcuffs by ER staff, I informed them that based on information we had received on the scene, that the subject possibly had been involved in an armed robbery. Gainesville officers were at this hospital at this time, and I advised the ER staff that the officer might have additional information.
Thank you, sir. Appreciate your time.
Officer, understanding that you're not allowed to make a final diagnosis.
That's correct.
Of things. The wound that you observed and that you described on the neck, based on your training and experience and observations of such wounds that you have received, that you have observed in the past, did it appear to you whether or not, can you describe whether or not that wound appeared to you to be consistent with the gunshot wound?
It was a puncture-type wound in appearance.
Was it rounded?
It did appear to be basically round.
Did it appear to be the approximate size of a bullet entering a person?
Yes, sir, it did.
Did it appear to be an entry wound?
I would have labeled it an entrance wound.
Thank you. No further questions.
All right, you may come down. May this witness be excused, counsel.
Okay.
Okay.
You may be excused. Thank you for coming.
And there you see the second firefighter of the morning leaving the courtroom. The big issue with this witness was whether or not the teen had been injured by a flying bullet or flying glass. Here comes the next witness, Nancy Ginsburg. What was the point of the last witness's testimony?
Well, I think the prosecution was able to show that the wound was near an artery, and the defense was able to show that the witness was unsure the source of the wound.
And of course, we'll hear both of those themes in closing statements. Let's go in and hear the next witness.
By indictment number 97CR 1306A, that's the state of Georgia versus Stephen Paul Kolokorius for 3 separate and independent counts. Count 1, aggravated assault. Count 2, aggravated
Under the
assault.
Georgia law, every time a witness is sworn in, the indictment should be read to the witness before their testimony.
I do.
I do.
Lower your hand and have a seat, and please speak into the microphone for us.
Sir, would you tell us what your name is, please?
Cecil Ferguson.
And what is your occupation, Mr. Ferguson?
I am a laborer for a fire alarm company at this time.
Okay, I'm sorry. Did you, in July of 1997, how were you employed at that time?
I was co-owner of Ferguson's Food Mart.
I see. Where is Ferguson's Food Mart located?
20 Gangsville.
Is it still that now, or is it something else now?
It's closed at this time.
I see. And who else owned the store besides yourself?
My wife.
I see. How long had you had that business?
5.5 years.
Are you familiar with a store then known as the Sitco, but prior known as a Kangaroo?
Yes.
And where is that store located near what used to be Ferguson's food store?
Yes. It's across Wilson Drive.
Across Wilson Drive?
Yes.
All right. Are there any buildings between your building and the Sitco store building?
No.
If you're facing the Sitco store, what side on the left or the right is Ferguson's?
On the left.
All right. Do you see that photograph that's up on the wall there?
Yes.
Do you recognize that store? You want to see it closer? Nope.
It looks very much like the one next door to our store.
Do you recognize that?
Yes, it would be the one next door.
Okay. Is that the Sitco / formerly Kangaroo as you described?
Yes.
And I guess to get a map location. Rather than have you get up, I'm just going to have you point out where we're talking about, and then with court's permission, I'll take it to the jury and show exactly where you pointed. How about that? Back this up. Give you some bearings here. Do you see Athens Highway and then the Gillsville Highway along here?
Here's our location. This spot here, that's the Sitco location there.
And what's coming up between here?
That's Wilson Drive that goes down between the two of them.
All right. During this time, sir, were you familiar whether or not there was a new road being cut somewhere?
This subdivision here was being built at this time. They were also working on Athens Highway down through here.
And when a subdivision was being built up through here, did they cut a road down through here?
Yes, there was a road going down this way.
So with that road, I want to get my bearings here. which way did your store face Athens Highway? Did it face that way or did it face this way?
It faces this way.
Does the Sitco store also face that way?
Same direction.
And the dirt road, does it go down this way or does it come up this way?
It goes down that way. Somewhat parallel to this one.
Okay. Where in relationship to your store, sit over here, correct? And the Sitco over here, where in relationship to your store is the dirt road?
I believe it to be in this area here. Now,
are there any buildings between what was your building and the dirt road?
no,
Okay.
there are none.
Okay. If you're facing your store, is the dirt road to the left of your store or the right of your store?
To the left.
That's helpful. Thank you. The jury's...
They were going toward Athens when I first saw them.
All right, so that being the case, the boys would have to walk in front of your store first to go by the Sitco.
Yes,
And that's what they were doing, is that correct?
that's correct.
Were the boys on the your side of the street, which is the same side as the Sitco, or the other side of the street?
On our side of the street.
How far away from the young man were you when you first noticed them?
Probably 75, 80 feet, I guess. They came on the corner of the lot. I noticed them.
Coming from Gainesville to Athens.
Yes.
What's the first thing that drew your attention to these individuals?
The guns.
All right. Describe the guns.
They were handguns. One was appeared to be a foot long and about and a nickel or stainless steel color. The other one was a black steel and was a couple, 3 inches shorter, seemed like.
Do you know whether the more physically fit or taller young man had the black gun, the bigger gun? Or did the other gentleman have the gun?
I don't remember now.
But you agree the first thing that drew your attention to these individuals were the guns?
Yes.
Approach, please. Mr. Ferguson, let me show you States 1 and States 2. Do you recognize these items?
No. They were too far away for me to recognize them.
You cannot identify these two items as the items that were in the hands of the young man?
No, I can't.
Can you state today whether or not the guns that you observed in the young man's hands were real or not real?
No, I cannot.
Can you tell us what the young men were wearing?
One was wearing a black shirt and light pants. Seems the other one was all in black or dark color.
All in black. One of them was all black and all dark, and the other was a black shirt with light pants. Is that correct?
Yes.
Now, this was a hot summer day, was it not?
Yes.
Did you notice if they had any towels around their neck or on their head?
I didn't notice.
Did you notice whether or not they had a baseball cap on their head?
I didn't.
Did the young man ever look at you?
They never looked our direction that I noticed.
But you were looking at them, is that correct?
Yes.
I believe you stated on direct examination you were curious. Mr. Ferguson, is that right?
Yes.
Why would you be curious about two young men walking by your store on a hot summer day?
Because of guns.
Did that signal anything to you?
It was time to be cautious or curious.
All right. Did you, at any point in time, consider calling 911?
Yes.
Why would you want to call 911?
To see what the situation really was. But I decided not to.
Is that a decision you regret today?
I hadn't really thought about that.
Do you remember speaking with this gentleman with the Georgia Bureau of Investigation?
I spoke with someone from the Georgia Bureau of Investigation, but...
You remember who was Agent Kersey?
I could not tell you now who he was.
Approach, please. Mr. Ferguson, if you would, read those two sentences there.
Here, I'm going to enter objection because the question being asked has been asked and answered. Further, it's irrelevant. It doesn't matter about that. He can talk about facts, but what his feelings are about those facts in connection with this particular question is irrelevant.
Judge, as I recall the law, I think it would be Kuzort and Gibbons talking about prior inconsistent statements being admissible for impeachment and or substantive evidence. And
that depends on whether or not those things are relevant.
Yeah, I think it's relevant.
Well, I question the relevance. I'll let you ask it, but I would note that your question was whether he regretted that decision today.
Let me ask you, if I can, to rephrase it.
Please.
Did you tell Agent Kersey that you wished you had called 911 now?
Yes, I did.
Is this statement accurate? At the time that I saw them, I debated calling 911, but did not because they were young and could not tell if the guns were real. I wish that I had called now. Is that accurate?
Yes.
Now, as I understand it, the boys with the guns walked off towards the Citgo and out of your line of vision. Is that correct?
No, they stayed in the line of vision at that time. Till they, for 10 minutes or so, getting to close to the Gaines Mill Road.
Did you watch them for the full 10 minutes?
Watched till they were out of sight, yes.
Now, I imagine you're a busy business owner, having many things to attend to, customers and whatnot. You took 10 minutes out of your day to sit there and watch these two men walk off in the distance with these guns. Is that right?
Well, since the road construction is going on out there, it had been quite slow and I had time to do it.
Would it be because you're curious?
Yeah, I was curious.
Did the boys ever put up the guns in their pants the first time you saw them?
Yes, they did.
At what point, and if you would relate it to where they were in reference to your store and the Citgo, did you first notice one of them put up the guns?
They were crossing Wilson Drive, which is between the two stores.
All right.
And as they approached the curbing going on to the Citgo parking lot, they raised their shirts and put their belts under, guns under their belt.
Both individuals did that?
Yes.
Were the guns concealed at that point, based on what you could observe?
Yes.
And then you watched them for some period of time, and then they went out of your line of vision. Is that correct?
Yes.
Did you have a conversation with your wife at that time, Mr. Ferguson, about a contingency plan?
Yes.
Tell the jury what we discussed about that.
Well, I told her if they had come toward the store, she would have gone to the office and watched them on the surveillance cameras. Because in the office we had a phone, and if anything were irregular, she could call 911 before she could be stopped.
Would it be safe to say that because of what you observed, because of that conversation, it was reasonable to anticipate a robbery?
Objection, Your Honor. He can talk about what he observed, what he did, but to speculate is improper, shouldn't be done. These are all decisions for the jury to be making, not for individual witnesses.
Judge, you've already ruled on this issue.
Overrule. I appreciate your objection. You need to continue to make those objections. I'll overrule that objection.
I wasn't anticipating one, but I wanted to be prepared.
You wanted to be prepared?
Yes.
Be prepared for what?
The possibility of a robbery happening.
How long were the young men out of your line of vision before you next saw Mr. Ferguson?
I guess about 20 minutes, 20 to 30 minutes.
And as I understand your description, the boys would now be coming back up 129 towards the Citgo and then your store onto Gainesville.
Yes.
Did they come out of the woods, or help me with that? Where did they appear to come out of?
Down the side of the road.
And what's down there?
There's a used trucks, parts, and a Mack truck place.
And when they came back in your line of vision, had anything changed at all?
In what regard? What?
This is not a test. I'm just asking if you remember. Had anything changed?
Anything changed about what?
Their appearance?
Oh, them?
Yes, sir.
Nothing that I remember.
Did you see the young men with the weapons at that point?
I observed one with the gun.
Was he the taller fellow?
I don't remember.
You don't remember. And what was he doing with the gun?
He was just walking along casually with it in his hand.
Did you hear any people blowing their horns that day?
No, I didn't.
Did you keep your eye on them as they came up 129 towards the Citgo?
Yes, I couldn't watch them constantly then because I was busy. But I did, when I was outside, I did watch to see what they were doing.
And I believe you testified on direct examination that the two young men headed towards the Citgo, is that right?
Yes.
One went in, is that right?
Yes.
And then one went to the spigot next to the propane tank, is that right?
He went to something beside the propane tank.
And then kneeled down as if he were drinking some water.
He moved as if he were reaching for a spigot to turn it on or something.
And while he was doing that, the other young man was in the store, is that correct?
Yes.
Approach, please. Mr. Ferguson, the state has made a diagram. Come on down, if you would, please. They made a diagram of the store and put up a picture to depict it. Do you recognize that store?
Yes, it looks.
Speak up now.
It looks as the Citgo next door to Ferguson's does.
All right. If we're standing on 129 looking at this store, your store would be about here, right?
Right.
All right. What's over here?
The Mack truck.
All right.
Lot.
Take a look at this diagram and orient yourself. Have you been in the Citgo?
A couple of times.
All right. Not to buy gas, I mean.
No.
Is that a fairly accurate diagram based on what you can recall?
I couldn't say. I didn't observe that much.
Right. Well, let me ask you this. If this is a picture, this is the way you remember it, correct? Mm-hmm. Here's the front doors. Here's the propane tanks. Here's the water spigot. We okay here?
Okay.
All right. This is the front door. Here's the propane tanks. Here's the water spigot. Is that right?
Yes.
Now, if you would, hold that and show the jury where the young man who did not go into the store first went when you observed it.
To this area right here.
And then kneel as if you were attempting to get a drink of water.
Something in that manner, yes.
And point out for the jury where the other young man is while he was doing that.
He came this way.
All right. Gun in or out?
He had put the gun in when he came onto the lot out here.
What happened with the other young man's gun, if you know?
I don't know. I didn't see it.
Let me ask you this. Did you ever see the young man who initially went to the spigot? Did he ever stand on this side of the store?
I never saw him.
So the other young man exit the store, is that right?
Yes.
And go where, please?
He came over this area also.
Where the other young man was?
Yes.
All right. Thank you, sir. Have a seat. Are you sure about that?
As well as my memory serves me, I am.
You have a pretty good memory?
I'm no judge of that. Sometimes I think so, and sometimes not.
How long do you remember the young man being at the propane tank before you went on about your business?
I don't know. I just saw them there as I was pumping gas, and I left to go inside. It was just...
Did you see anything that happened after that?
Nothing.
Did you ever see... Stand up, Steve. Did you ever see this individual come up to the store?
No, I didn't.
Have a seat. Did you ever see him go in the store?
No, I didn't.
You ever see him come out of the store?
No.
Do you know what happened of your own personal knowledge in that store on July 15th around 4:30 in the afternoon?
No, I don't.
You told Mr. Kersey that the guns looked real, correct?
I told him I could not tell whether they were real or not.
All right. Can you tell today whether they're real or not?
I don't know. If I saw them close enough, I probably could.
Would you want to wait till somebody walked in your store with the gun sticking in your face to determine if it was real or not?
Objection to it's just your speculation, argumentative. All these things can be argued, but it's not proper questioning for witnesses, and it simply isn't.
Sustained.
Thank you.
Thank you, Mr. Ferguson.
Mr. Blair, any additional questions for Mr. Ferguson?
Yes, very brief. Of your own personal knowledge, in reference to time, do you know anything what happened at 4:45 p.m. to 4:48 p.m.?
No, I don't.
And at the time that you saw the young men together at the propane tanks, could you tell what, if anything, they were doing with their guns or where the guns were at that time?
No, I could not.
So, thank you very much.
Mr. Summer, Mr. Ferguson may be excused, is that correct?
Yes, it is.
All right, Mr. Ferguson, you're excused. Thank you for coming. You may leave.
And so we're waiting to see if the prosecution is going to call another witness.
I think so. I'd like to go a little bit longer. Ladies and gentlemen, will that be okay with you?
Right. I'm sorry, Your Honor, I misunderstood. I'll call Parker Risley.
All right.
Thank you.
And so the judge decides to go slightly past the normal lunch hour in order to call another witness on the stand, this case moving rapidly. And let's talk, while we have this slight break in the action, to Lauren Mack. Lauren, the last witness.
Yeah, that's correct.
And you didn't know what he was on trial for, right?
Not well. At the bottom of the screen, it gives like a little recap of what's been going on. So as I sat waiting to see if it was him or not, by could identify him by seeing him, then little things said about what he was accused of.
And you felt that you needed to, on your own, call the district attorney's office and interject yourself in this case. Is that correct?
Yes, that's correct, sir.
All right, to get your 15 minutes. Isn't that true?
Objection, that's argument.
She's on cross.
It doesn't make it admissible.
She's on cross,
It
Judge.
doesn't make it admissible.
You may answer.
Are you enjoying your 15 minutes, Lisa?
No, this is definitely not my.
This
not
is
a lot of fun.
difficult for you, right?
Interrupting the witness during her answer.
Sustained.
Is this difficult for you to talk about this?
Yes, it is. I am not enjoying it. No.
Yet you voluntarily, 10 years, a decade ago, you alleged this happened, and there's no proof, right?
Objection, Your Honor.
Is there any proof?
Objection, Your Honor. She's testifying under oath. Thank you.
Is there any proof?
Objection.
Court TV has become a channel that now people are looking at it in great amounts, just so they can be witnesses on trials if they feel they can fit in.
The defense counsel suggesting that, having seen the wonders of Court TV, she said, I want my 15 minutes on Court TV, the Warhol concept.
And she got a free trip to Atlanta and an opportunity to testify against...
No, whisked to Gainesville.
Whisked to Gainesville, sorry.
So the question is whether or not the attack that the defense makes at that point is sufficient. Obviously, you're the defense lawyer. This witness pops up. You have to decide whether or not to attack, and if so, how.
Well, this is all you can really do with her, because, I mean, here she's a very creditable-looking person, and, she's got a good demeanor. And really all you can do with something like this is to kind of, mimic what she says and make it sound not believable.
Michael, let me interrupt you. It looks like something's happening in the courtroom. We think it's jury indicating that they're ready to go, but we don't know because, in fact, there's a note. So let's go back to Gainesville and see what's up.
God, sorry.
It's okay.
Hopefully you're right. Until not really. Yes, and there's a lot of
While we're in our speculation mode, we're guessing that the jury may be inclined to tell the judge they want to quit for the day and start again tomorrow, but we don't really know. All we know is there's some action in the courtroom, some notes been sent out. Michael Griffith, this is, of course, among the tensest of times for the defense counsel, the defendant, prosecutors, anybody involved in the case, not knowing what's going on.
This is after you've earned your money. This is the waiting period, and you never know what these juries are going to do. Sometimes you think you got a slam dunk, and you find out differently, but this is a very tense time.
The one thing you can be reasonably certain of is that you'll be surprised somewhere along the way.
Absolutely, particularly with some of the questions that are asked.
And especially in this case where you have not only a contest as to the central facts, but all this other stuff kind of spinning around the edges. Lisa Walker McIntyre, the other crimes evidence against one of the alleged victims. And now, let me ask you this. From Lisa Walker McIntyre, obviously, prosecutors hope that the jury will infer the defendant's not truthful, that he had a racial animus in firing at these defendants, that he's willing to fire his gun irresponsibly. What about the concept that they might just decide he's not a nice guy, that he has racial attitudes but that it doesn't affect their attitude about what happened? Is there a possibility that it enhances the possibility of conviction just because jurors don't like him?
Yeah, that could happen, particularly, you know, he comes off as this Rambo type of fellow, and of course he said horrible things about black people. You've got a black juror there who might start getting the jury really pumped up, and people may realize that this is not what the new modern Georgia is all about, and we want to find guys like this guilty because they're not part of our society any longer.
But in fact, jurors should not use the evidence that way, and the judge told the jurors that they should only use evidence when it's admitted for a limited purpose. Is that something that you think is always manageable in the context of deliberation?
It's something that we lawyers are always very fearful of, because no matter what a judge says, it's not necessarily that the jurors are going to take that as gospel.
And you weren't suggesting that only the black juror might be outraged by this testimony?
Oh, no, certainly. Absolutely, the white jurors can be outraged, too.
Well, the participants in the trial are standing, which means the jury's coming in, which means in a very few seconds we'll know exactly what it is they said in their note. Let's find out. Let's go back to Gainesville.
All right, Coach Eli, to the jury, you sent out a note that you want to recess for the evening, and I needed, for this first time in particular, to make sure I'm on the record with this instruction. Anytime that you cease your deliberations, then you must cease them until you're all gathered back in the jury room and your deliberations are called back into session by your foreperson. So anytime that you take a break during your recess, be it overnight such as this or during a 15-minute recess that you may take some other time, you must cease your deliberations at that time. Don't leave the building talking to another juror about the case. Make sure that you cease deliberations and only conduct deliberations, only discuss the case when you're in session in the jury room deliberating under the instructions of the foreperson. So please make sure you follow all the instructions that I've given you previously during this evening recess, and we'll look forward to seeing you at 9 in the morning. All right? Thank you.
Well, that's all there's going to be for this case for today, but of course we'll be back with Verdict Watch for tomorrow, and more importantly, Dan Broden is going to be here in a moment to continue our coverage of this trial. Michael Griffiths, it's been a pleasure having you with us.
Thank you, Ray.
I know you'll be back in the future if you're not wandering off on some other continent defending someone else.
I'm going to Okinawa in a week or two for 2 more Marines.
Well, call us from there. We'll take your call.
I'll do that.
In the meantime, we're going to take a break. Dan Broden will be here. I'll see you tomorrow.
The jury tonight as it decides the fate of Stephen Kolokorius in a Court TV exclusive trial. Kolokorius is a former Sheriff's Department employee, and he stands charged with aggravated assault after firing his gun at 2 black teenagers outside a convenience store. But Kolokorius says the shooting was in self-defense. He claims the young boys were armed and poised to rob the store. Well, in closing arguments today, prosecutors who claim the boys were innocent and even put their BB guns down prior to the shooting replayed an audio-taped 911 call placed by the defendant after he fired his weapon.
Did you see any guns on them?
He saw 2 guns on top of something. What he saw was these 2 BB guns on top of that container. And when he saw Mr. Summer introduced race into this case, and we've got to talk about it, what we saw was 2 black men, young boys, outside of that store. And he saw, according to what he said on the tape, not a young man approaching the store, raising his gun at him, not a young man approaching the store, pointing his gun at him, not a young man approaching the store saying anything, not a young man approaching the store threatening him in any fashion. What he saw was 2 young boys.
So as you just heard, and as you're about to hear again, prosecutors claim that the shooting was motivated by racism.
And as the judge will charge you in this case, you're going to look at it as an objective, according to the standard of what an objective, reasonable person would do. Not a subjective, strong word, but under the evidence in this case, true. Not a subjective bigot who was there to shoot. An unjustified, preconceived, vigilante action that was unreasonable under all of these circumstances. These young men walking across, no reason to call the police, no reason to run them down, no reason to pull a gun in the car if he had one, and gun them down. and gun them down.
Let's go back out to Clara Tuma in Georgia. Clara, what exactly does the prosecution say about race in this case? Did Lee Dara talk about race throughout his case, or did he just get into it today in summation?
It was today during the final witness, the rebuttal witness, the former girlfriend, and then in his closing arguments. But there's been a lot of talk about race among the spectators who've been watching this trial, but not so much in front of the jury until today. And then we saw prosecutor Lee Dara concentrate much of his argument on the issue of race as he tried to portray Stephen Kolokorius as this sort of trigger-happy guy out looking for trouble, out itching for a fight.
All right, and Clara, let's take a look ahead now. What are the options for this jury in this case?
Well, Jamie, they can, of course, find Stephen Kolokorius not guilty. But if they choose to convict, they could convict him of the felony of aggravated assault or the misdemeanor of reckless conduct. Now, aggravated assault also has a lesser charge, and that is simply pointing a gun, and that, too, would be a misdemeanor.
So, assuming a conviction of something, what are the possible punishments?
Well, the misdemeanors each carry a maximum of 1 year in jail. The felonies, that is the 2 counts of aggravated assault, carry a maximum of 20 years in jail apiece. The minimum here is probation, so it is possible that even if Stephen Kolokorius was convicted of the most serious counts, he could still walk out of the courtroom a free man because the judge could give him probation.
Stephen Sadow in Atlanta is a criminal defense attorney. When is one allowed to use lethal force in self-defense?
Whenever one feels that he is facing deadly force or immediate, violent, serious injury.
Is that his subjective evaluation given his background and life experiences, or is it, as the prosecutor says, more sort of an objective person, reasonable man standard?
Well, it's not subjective in the clearest sense, but it's a reasonable standard based on all of the surrounding circumstances. I guess the best way to put it is you do not have to totally discard the circumstances that the person finds himself in. At the same time, if the person has some unusual manifestation, character disorder, that doesn't get taken into consideration in determining whether or not his reaction was justified under the circumstances.
Rob Tarver, if there are 11 whites on this jury and 1 African-American, and if we assume for just a moment, as the course of our discussion tonight is taking place, that perhaps white people might be apprehensive and worried and fearful at seeing 2 people, any people, with guns, but African-Americans might say, we see guns all the time, at least in our neighborhoods, in our community, it doesn't bother us. So there's a different reasonable person standard depending upon the color of your skin, isn't it?
As a person who's from Georgia originally, I can tell you Georgians are used to guns. But I do want to say this. I want to go back to something that Stephen said, because I agree with your premise, Greg. It's all about the subjective, how you view the incident. But the problem is here, and this is where race rises into it, you don't want people's subjective determinations of when they should use deadly force to be countenanced on race. And that's why it is legitimate to explore this person's motives and possible biases, if that is the reason why he's doing it.
But Rob, although obviously we wouldn't want people to base such a critical decision on race, we always factor those things into our decisions, don't we? Can you ever expect someone not to bring their personal experience to a split-second decision like that?
We can ask that that not happen, particularly when you're talking about deadly force. You can ask that you look at a human being's behavior objectively and not the fact that because he is of a certain race or persuasion or ethnicity that he is more likely to injure you than someone else. If we do that, if we're going to allow that type of thing to be a factor in the use of deadly force, well, then the doctrine is just completely shot. It becomes a racist doctrine subject to interpretation and favoritism for some people and not for others.
Still ahead, Vanessa Clark's son was shot at outside a convenience store tonight. She gets to fire back verbally. We'll talk with this woman who almost lost her son live in just a moment. Hope you'll stay with us.
You found out about this case watching court TV, didn't you?
Yes, that's correct.
And you weren't too afraid to pick up the phone and call the district attorney?
No, I wasn't.
So what's the difference?
Well, I come home with my son and my husband from the park. My husband just finished school and we were celebrating. And I was looking through the channels and saw this on TV. and saw what it was about and realized that they didn't know about Stephen what I knew about him. And I thought it was the right thing to do, to call and give them that information.
Mm-hmm.
When I called, I didn't think I would be coming here.
Are you enjoying your 15 minutes, Lisa?
No, this is definitely not my...
This is
not a lot of
difficult
fun.
for you, right?
Interrupting the witness during her answer?
Sustained. Is this difficult for you to talk about this?
Yes, it is. I'm not enjoying it, no.
Yet you voluntarily, 10 years, a decade ago, you allege this happened, and there's no...
She was able to leave court. Several of the supporters of the alleged victims went up and embraced her and told her how proud they were and how happy they were that she had come forward and was willing to come to Georgia and testify. And of course, they had never met before, but just her testimony on the stand was enough to merit hugs from families and friends of Montel Butler and Kellen Clark.
Clara, the defense attorney, Dan Summers, at one point had indicated he would bring on some rebuttal following her testimony. Did they finally call any witnesses to try to counteract Lisa Walter McIntyre?
Not a one. In fact, on Friday, the defense attorney had promised that Steve Kolokorius would take the witness stand again should this testimony be admitted, because on Friday, which was the first time the defense heard about this, they thought it would be devastating. And the defense attorney was saying, absolutely, we'll put Steve Kolokorius back on the stand because this is not true. He said his client categorically denied almost everything that Lisa Walter McIntyre was about to say, including the incident with the AK-47. But flash forward to Monday over the weekend, and the defense attorney called no witnesses at all. Now, he offered no explanation of that to the jury. Outside of court, he said that he thought her testimony was not worthy of belief, and that by trying to rebut the rebuttal, that he would have just called more attention to it, so he just let it drop.
Clara, now, you know Dan Summers, veteran defense attorney, is keeping a poker game face, but come on. We saw Kolokorius on the stand. He single-handedly opened up testimony to his views on Hitler, that the Holocaust maybe didn't happen, the specter of beatings with this girlfriend in the past, and racism. Do you really think Dan Summers was going to take a gamble and put Kolokorius back on the stand for another swing at the ball?
I was going by what he said he was going to do. Maybe that was the mistake, was to trust what somebody said they were going to do. You know, there's a lot of explanations for it. It's true would be one of them. It's false, and it's not worthy of belief, and it's so minuscule, as Dan Summers says, that it's not worth even worrying about. That's another. Or another is, as you point out, that by simply trying to rebut it, a lot of doors could be opened there.
Boy, you aren't kidding, Clara. I think you did the right thing in retrospect by not putting Kolokorius back on the stand for another bite at that apple. Clara, you spoke with Lisa Walter McIntyre after court, and how did she respond to the notion that she's the jilted lover?
Oh, she didn't like that at all. In fact, Nancy, she says that she's the one who dumped Stephen Kolokorius, not the other way around. And she said, first of all, she was surprised that prosecutors wanted her to come to Georgia. Then she was even more surprised at the way she was treated by the defense. She was attacked on the witness stand during cross-examination in front of the jury, vilified by the defense outside the jury's presence, and she said she was just surprised at the way the whole thing turned out. I did speak with her after her testimony and asked her to explain why it was that she called the district attorney's office in the first place.
Well, I realized that they didn't have information about Steve that might be really helpful to the prosecutor's case, so I thought I could just call and give them information and they could do whatever with it, and then that would be that and be taken care of. But they needed me to testify, so I thought it would be the right thing because I know how he is, and if he did it and got off, I mean, he'd probably do it again, so I know I would feel really guilty. So
you say you know how he is. How is he?
He's just very violent and very racist. He's a neo-Nazi, and he's just a really mean person.
Now, the defense says that you're saying this because you're a jilted ex-girlfriend. Is that true?
No, I broke up with him, and actually he tried to commit suicide after I broke up with him, so, you know, obviously it's not true.
Now, you dated him, and you say he was a racist. Did you share those beliefs?
No, absolutely not. I tried for a very long time to make him not believe that way and try to show him the error of his ways, like many women do, and try to fix things, but it didn't work, no.
Tell me a little about his thoughts first toward African Americans.
He just thought they should all go back to Africa. He thought they were just subhuman. Said every racial epithet slur you could possibly think of about them, and very openly and very frequently.
And what about his thoughts about Hitler? You told the district attorney's office about that, and it turned out that was not admitted in court.
Right.
What were those thoughts?
He just thought that the Holocaust would just happen on a much lower scale than, this typical propaganda stuff, and he didn't think it was that bad a deal, and he idolized Hitler, and, he and his friends would do the little Sieg Heil to each other. It was just really revolting.
And the other incident that you testified about was an incident with a gun when you said he fired an AK-47 beside you.
Yes, that's right.
What was that about?
I continually threatened to leave him because he was so abusive, and that was his way of making sure I didn't.
And did it work?
Yeah, it did work for a long time. But then I just couldn't deal with it anymore, so I just bit the bullet, so to speak, and made the break.
And the defense attorney in his closing argument at one point referred to you as what's her name. At one point later tried to discredit you by saying, oh, she's out for her 15 minutes of fame. Would you like to respond to those?
Yes, I would. This whole thing has just been really awful. I missed Mother's Day for this. It wasn't my idea of fun. And I had to do what I thought was right. And I just wanted to do this interview so people would know that that's how I felt and would know that the things they said about me, I guess they said some other horrible things about me that, that didn't get on to weren't admitted into the court, but was said on court TV and such. And everything they said was just a total bunch of crap. And I know the defense attorney has a job to do, but, I want people to know that it's not true.
And one of those that he said that is particularly inflammatory, I want to make sure you have a chance to respond to it, and that was his allegation you took LSD back then.
That was just the most ridiculous thing in the whole world, and even the judge said it sounded like a desperate attempt, and he was absolutely right, and it's completely untrue, and I want my friends and family to know that that's not true about me.
Do you feel threatened or intimidated now after testifying?
Well, it's been a long time, and I started finally getting over it, but I live a long way away, and we'll be moving, and getting a new number and things like that, so I think it'll be okay. Hopefully he'll be in jail, so it won't make any difference.
And I know it's been a whirlwind since last Thursday for you. A lot of events happen very quickly. Even from this vantage point, would you call again? If the same thing happened, would you do it again?
Yes, I would, because it was the right thing to do, and if you don't do the right thing, then it's hard to live with yourself.
Have you stayed in touch with Mr. Kolokorius?
Oh God, no. He once tried to take me forcibly from my school and was subsequently arrested, and that's when he tried to commit suicide, and then I never heard about him or from him again, thankfully.
Well, Lisa Walter McIntyre, thank you so much for stopping to talk.
Yes, thank you. Bye-bye.
Now, we heard her describe an LSD incident. Now, it's not really fair to say it's an incident because what it was an allegation with no proof from the defense attorney. This came outside the jury's presence before court started, and the defense attorney said that he had some information that she may have been using LSD back about the time that these alleged allegations, this incident with the gun took place, and he said he wanted to explore whether she may have been, quote, tripping at the time because he thought that might have influenced her testimony. But the judge said, do you have any proof at all of that? And the defense attorney said no. So the judge did not let it in. That allegation did not come before the jury because there was just no proof of it.
Clara, you're right. In Georgia, as in most states, there has to be some foundation, some specific foundation, before you can impeach a witness on matters such as drug use. And I can bet you your bottom dollar that that so-called information regarding her alleged LSD use came from Stephen Kolokorius, and without him ever taking the stand to put that in front of the jury, there was no foundation on which to base such a cross-examination. Wow, that was bombshell testimony, Clara. What else could she have said that the jury was not allowed to hear?
Well, Nancy, everything she could have said didn't get before the jury. You say what they did hear was a bombshell. Well, they didn't hear about her statements about Stephen Kolokorius' feelings about Jewish people and about Adolf Hitler. We just heard her say in that interview that he admired Hitler, that he thought he was right, and that he thought the Holocaust was not nearly as serious as some people think it is, that 6 million people had not actually been exterminated. The judge did not let that in. Also, the prosecution tried to get in information that, or an allegation that Stephen Kolokorius beat this woman when they were together. She says it was a violent relationship and that you heard her say he hurt me often. The judge said no, that couldn't come in. The prosecution specifically tried to get in testimony testimony that the incident surrounding the gun incident with the AK-47, there was a beating just before that gun incident, but the judge did not let that come in either. So even though what she said could be very powerful for the state, there was a lot more that the defense was able to keep away from the jury.
Clara, did you notice in the cross-examination of Miss Walter McIntyre yesterday, Dan Summers asked, well, were you hurt? Did he ever hurt you? And we know he was referring to the shooting incident, but he nearly opened up yet another can of worms when she said, oh, yeah, he hurt me all the time. She was referring to the alleged beatings.
And then
for a moment there, I thought, oh, here it comes. More impeachment is about to pour into the courtroom, but Dan Summers backed off immediately and changed the subject, and I could just hear him mentally shifting gears all of a sudden.
He narrowed that question down immediately. I mean, when the gun was fired, he narrowed it down to a specific time period.
Clara, the jury was only out for about 20 minutes yesterday during deliberations. What is their schedule going to be like today?
Well, Nancy, they were due back about 20 minutes ago, but we're told one of the jurors had some car trouble, so they're running a little bit late this morning. Of course, they can't begin until all 12 jurors are back in the jury room, so we expect deliberations to begin this morning in about 10 or 15 minutes whenever this one juror gets there, and then they'll set their schedule. If they want to work through lunch, they can. If they'd like to take a lunch break, their schedule, the judge says if they would like to work late tonight, they're welcome to do it. It's really their call.
Clara, of course, the story, the law behind the fact that they cannot start deliberating until all 12 are there is that it's sacrosanct. 11 cannot deliberate. If a juror is missing from the jury deliberation room, it's got to all start all over again. There must be all 12. So the other 11 must wait for that 12th juror to get there before they can actually start deliberations. Clara Tuma, I was just wondering, what was their reaction during the closing arguments?
Well, Nancy, if you saw the closing arguments, I'll tell you, they were not as emotional as they'd been expected to be, because this was a high-pressure case, lots of emotion throughout the trial. But in closings, following the weekend break, it looked almost as if both attorneys were a little deflated. They weren't nearly as fiery as we'd been led to believe that they might be. So the jurors seemed attentive, but there was really not the fire and brimstone argument that might have drawn their attention and riveted them to the arguments. They were almost free-form, no time limit, and that, in my mind, may have hurt both attorneys because they seemed to wander maybe just a little in their closings.
You're right, Clara. When you've got a time limit, and normally in Georgia for non-capital cases, it's a 1-hour time limit on argument. When you have a time limit, you want to pack a punch as quickly as you can because you know your time is going to run out. And I had anticipated a lot of gunslinging during those closing arguments with the replica guns, the 2 BB guns. Let me ask you this, Clara. Who all was in the courtroom supporting Stephen Kolokorius during those closing arguments?
Well, his mother has been here throughout the trial. His family members, he does have some brothers that live in another state, and they were unable to come to court, even though they're supporting him. That's the word from the defense team. She's been there every day. By numbers, there have been far more people on the other side of the courtroom. And as you know, Nancy, in the courtroom, I describe it almost as a bizarre wedding when there's a bride side and a groom side, only this time it's a defendant side and a plaintiff
Clara,
side.
I think you stole that line from me. Do you remember a court case years ago in Atlanta when we made that observation in the courtroom? You're so right. It lines up almost like a wedding. Everyone seems to sit in their assigned seats. And
they don't want to sit on the other side.
Yeah, they refuse to sit on the other side, and the closer you are to the case, the further up front you sit. It's almost like relatives at a wedding. Clara, thanks so much for your report, and I'm looking forward to speaking with you later in the day. Bye, Clara. While we wait for this verdict to come in, we're going to take a quick look back at some of the key moments in the trial, beginning with opening statements and those first impressions. Everyone stay with us.
This defendant, Stephen Paul Kolokorius, acted unreasonably, acted unjustifiably, acted without the bounds of the law, and committed an aggravated assault.
It is reasonable for Mr. Kolokorius to have done what he did, whether or not the boys were about to engage in an armed robbery.
Feelings about Hitler. He referred to Hitler.
Yeah, that didn't come in front of the jury.
But he did take the stand and say, I never shot at a human being. you know, as we said before, I assumed that his lawyer and he had discussed this at great length before he took the witness stand, and was rather surprised at her testimony, which rebutted that.
You know, Isabel, have you ever put a witness on the stand? I never have, where no matter how many times you've interviewed them, you've gone over police reports, you've discussed their prior testimony, something new always comes out when you put a witness on the stand. It never fails.
I think it's probably more of a problem for prosecutors than it is for defense attorneys. And for defense attorneys mostly because for the most part, we don't have to prove anything.
Right.
And for the most part, we don't put on cases for precisely that reason. We sit and we wait to see what you guys have to say. But I think you know, prosecutors are stuck with their witnesses as they come. They don't get to choose who the witnesses to crimes are. When you have witnesses who have baggage there and who are not professional, not police officers or civilian witnesses, there is always danger that something new happens. And it's happened in virtually every trial I've ever been in. Something happens and they're like, whoops, I forgot to tell the prosecutor about that, and comes up on the witness stand.
Never fails, no matter how many witnesses I've ever put up. Every witness always has a detail they forgot to tell me before they get on the stand. When we come back, we'll be going back into that Georgia courtroom. And remember, we are on a verdict watch. What's your verdict in the case? And what will that Georgia jury have to say? Stay with us.
All right, as you just heard, that was a different case. The judge has other cases on his calendar. That may be an arraignment. We don't know. And he's taking care of other business while the jury deliberates, as most judges do. Life goes on in the courtroom. We are going to take a commercial break, and we'll be back with more. Stay tuned.
This portion of Court TV is brought to you by Lanacane with antibacterial, the only itch killer that's a germ killer, too.
Force is necessary to defend himself or a third person against another's imminent use of unlawful force. In short, a person may use force to stop a crime against another person. But was Stephen Kolokorius justified when he shot at two teenagers? Right now, a jury is deliberating, and that gives us an opportunity to get our first look at what's making legal news from Court TV's Dan Broden. Dan.
June, thank you very much. Good morning, everyone, or good afternoon. A judge hears arguments today over the sentencing of a central figure connected to the Oklahoma City bombing. Attorneys for Michael Fortier claim their client should be set free because he testified against convicted bombers Tim McVeigh and Terry Nichols. Fortier pled guilty to charges of withholding knowledge from federal authorities concerning the blast. Prosecutors want him behind bars for at least 11 years. Also today, a judge will consider whether victims of the blast should be allowed to speak out at the May 27th sentencing. A White House assistant is making an appearance before the federal grand jury investigating the Monica Lewinsky matter. Rebecca Cameron, an Oval Office staff aide, appeared at the Washington federal courthouse as prosecutors
Or the jury concerned about what the punishment would be for the various options they have in front of them. Brian, does that signal anything to you when they're asking about the punishment? Is there anything that you can glean from that?
I think that they're ready to assign responsibility for some criminal act. The question is they're trying to decide how much responsibility. And if one juror thinks that, well, he did something wrong, but I don't think he should be punished that severely for it, the jury may then ask the question, well, what would he receive?
Is that a jury nullification issue then? I mean, are they not going by, they're supposed to be reading the law, the charges given to them, and seeing if the facts fit what the charge is, rather than thinking, I don't want him punished for this much time, and he really shouldn't spend that much time in prison. I mean, unless they're going to nullify and say, you know what, he didn't deserve it, he didn't mean it.
See, the notion of jury nullification has this ominous tone to it, that the jury is going to disregard everything that goes on in the courtroom, disregard what the judge said. But I think Another term for jury nullification, or what a jury does, is a jury's sense of purpose and a jury's sense of the community. What really should happen in a set of circumstances like this? They're not 12 machines that go into the room, they're 12 human beings. And I think that they bring their emotions and life experiences to analyze the facts involved here. Is it nullification? It's not going to fit exactly what the judge has told them to do, but hopefully the jury gets a sense of what has really gone on and metes out what is hopefully a just punishment, what goes on here. This question to me would signal they're ready to find him guilty of something.
All right, well, we are going to go back outside the courthouse where Court TV's Clara Tuma is standing by with a friend of the defendants. Clara.
June, Sean Cannoni came up to Georgia from Florida yesterday after seeing the allegations on Court TV that his friend, his longtime friend, the defendant in this case, was a racist. He says that's absolutely not true and is here to tell us a little about it. First of all, you know the defendant. What's he like? Is he a racist?
No, definitely not at all. I can prove it. I mean, several different things have happened in my life where I've seen him respond to different things. I mean, we feed the homeless down in Miami, Overtown, and most of our indigents that we feed are black, and I've seen Steve out there with myself feeding people down in Overtown, so he's definitely not racist.
And have you ever heard him use derogatory terms to refer to African Americans?
Not at all. Not at all.
Now, you mentioned to me off camera an accident that you and Steve Kolokorius came upon one time. Tell us about that.
In 1984, my Corvette was smashed into a telephone pole, so we rode up to Belglades, which is like the AIDS capital of Florida, and to go up there and see how my friend was who wrecked my car. And we came upon a head-on collision with about 7 different cars and 5 fatalities, and several of the people that were still injured were in a canal, and several of them people were black, including black children, that me and myself and Steve risked our lives to save these children and the other people involved in this accident. And, you know, for a man to risk his life to save a black person, there's no way, shape, or form this man could be prejudiced.
And you knew him back when you guys were both in college. There's been allegations he was at one point, shaved his head, was a skinhead, went to a skinhead rally. Did you ever see anything like that?
Steve wore his hair short all the time. I don't think it had nothing to do with any type of rally. That's just his style of hair.
Do you think race has played a part in what happened out at the Citgo station?
No, it's not a racist issue. It's somebody committed a crime. Somebody was about to do something. Steve had no time to find out what transpired. All he saw was someone pointing a gun at him. He was in fear of his life. He did what any normal person would do or any normal law enforcement officer would do, and justifiable use of deadly force, and that's what he did, and that's what he should have done.
Well, you must have thought about if you were in the same position. What's your answer to that?
I would have used justifiable force of deadly force.
Now, you've talked with Steve Kolokorius since you've been down here in Georgia. How's he doing in this trial?
He's holding up as anyone could expect. I mean, he's firm, and he just has, you know, upset and depressed a little bit, but he's doing well.
Now, when you called from Florida and called the lawyer's office and said, my understanding is you called and said this is not true, he's not a racist, did you offer to testify, or did you consider, would you have testified?
Yeah, I was outraged. I said, this ain't the Steve that I know. I said, you better put a witness on stand to tell the truth. Obviously, I didn't think this witness was telling the truth or just making up falsification just to get on TV.
Do you have any idea why the defense didn't put you on?
No, I don't. I don't.
And have they discussed with you why they didn't call any rebuttal to the rebuttal witness?
No, not at all.
Do you think that was a wise move on their part?
I think they should have called a rebuttal witness to clear Steve's character.
And in all the times you've known him, have you ever heard him say anything that you perceived as racist?
No, the kind of line of work I'm in, I deal with indigents, and we help people no matter what. And I've heard Steve, and I've seen Steve's compassion towards human beings, black or white, and his compassion has been great for people. Like everybody in America should be, just not certain people going out to help people. Everybody in America should do those things to help people that are indigent. And Steve was one of those people.
And you've talked with him since you've been here. What's his reaction to the allegations in court yesterday that he was a racist?
He doesn't even know what to say. It's like shocking to him.
Okay. Well, Sean Cannoni, thank you so much for stopping to talk with us. June, now he is one of the people who are supporting the defendant throughout the trial. Only Steve Kolokorius' mother has been on his side of the courtroom consistently, and we found out today that some of his friends and family members have just been out of state and been unable to come, even though they have been offering support long distance.
Clara, did you ever speak to the defense attorney about why they decided, if there are witnesses available like this, why they didn't decide to call at least one rebuttal witness to counteract the testimony of his former girlfriend.
I did, and in fact, he said he thought that by calling a surrebuttal witness that he would be emphasizing it in the minds of the jury, and he said he thought that by discarding it, by not calling a rebuttal witness, he thought he might be able to treat it as if it were not important and maybe get the jury not to concentrate on it as much as reminding them of it by calling in a witness.
Well, that's certainly a very important strategic move on the defense part. Thanks so much, Clara Toomer. We continue with our jury watch. We are going to take a commercial break. The jury has been sent back to deliberate, and we will see more of the trial of Stephen Kolokorius as they do so. It amazes me that you see two teenagers
convict him of, but they may say, we still think he's guilty of something, we don't want to acquit him. And so they still have some options where they can go to a lesser included kind of offense. So all of these are certain kinds of offenses. They couldn't go, say murder if you're talking about aggravated assault, because that would be a higher charge, and they have not been instructed by the judge that they are supposed to look at that. But this pointing a gun under the Georgia Penal Code, I assume, I'm not familiar with this particular part of the Penal Code, but I assume that this is included under aggravated assault so that the jury can say, okay, we're going to find him guilty of aggravated assault and of pointing a gun and any other offenses that are below the highest offense that the judge has instructed us that we can do. Or they may say, we don't want to find him guilty of the aggravated assault, but we still think he's guilty of something, maybe not the highest thing, so then we go down to the lesser included offenses.
And if you add the fact that for each aggravated assault charge, there's a pointing a gun charge as a lesser included offense, and then there's another charge of reckless conduct independent of those first two. Although we don't like to think that jurors compromise, I suppose one could say that it is an invitation, if jurors aren't certain or if there's a split, that there might be some way of working out something in between.
Absolutely. I mean, that's why this is a lawyer's tactic also at times, because, for instance, in the nanny case, the lawyers had an opportunity to say, okay, we can either ask for murder, or we can ask for manslaughter, or we can ask for an acquittal. And the defense made the decision not to ask for a manslaughter charge, because I think they felt that if the juries were given the choice of a murder or an acquittal, they would feel that they didn't want to compromise, and therefore they would acquit. So sometimes you make a tactical decision to decide to ask the judge not to include the lesser included offenses and to just go with the highest or an acquittal, and sometimes you're wrong.
And of course, both sides have options in some situations, and then there are others where a judge either decides on his own or is required to do so.
Yes.
Let me tell you that the judge has finished with the other matter he's been dealing with. The other participants in this trial are in the courtroom, except for the jurors, and the judge is off the bench for a moment. When he returns, when the jury comes in, we'll bring you the verdict as soon as it happens. Interestingly enough, as you mentioned, the case in Massachusetts, which was so controversial, involved an area of the law involving murder and manslaughter. And there again, much controversy about the defense election as to whether to not go with manslaughter and then to seek it afterwards, and prosecutors saying they sought it. But you can't really tell until you know the facts of the case which side is going to think it gets an advantage. It's usually the side that thinks it's in most trouble that's going to look for some possible lesser included, because they say, well, I might not be able to get the maximum charge, but maybe I can get something else.
Right. And of course, the side that's not in trouble may say, I don't want to even risk this. I want to just go for the maximum because I'm convinced I'm going to get it.
Okay. Now, the young man whose body is turned, if you've just joined us and haven't been following this case, is Stephen Paul Kolokorius, a young man who is facing the possibility of either conviction or acquittal. The jury is going to be rendering its verdict in a moment. The young lady to his left is part of the defense team. She's been there throughout the trial, though she hasn't participated in the trial itself very much, but has been there constantly talking to the defendant and giving him advice and perhaps comfort. On both sides of the courtroom, there has been, at least for the last 2 days, a fairly sizable gallery, though during the earlier parts of the trial, there were not so many folks, okay? And perhaps you'll have a chance now to look at the gallery. Arrayed on this side to your right would be the defendant's side, or generally, it's not a formal requirement, but generally speaking, those supporting the defendant would be on that side. And on the other side of the courtroom, you can see folks who are generally, well, right now all you're seeing are some belt buckles, but you will see folks who may be connected to the prosecution, or the victims in this case, more sympathetic to the alleged victims. And of course, if you note a racial difference, it is because there have been, at least the subtext in this case has been a question of whether there was racial prejudice involved. And indeed, there was testimony from a rebuttal witness called by the state that the defendant had expressed views hostile to blacks during the course of his life. And in fact, one of the theories argued by prosecutors in summation was that he acted very quickly and without adequate cause to shoot because the victims were black. But obviously there are other issues besides race in this case, and we'll know very shortly what a jury has to say. I'm talking to Professor Barbara Ellen Schwartz, who is a second-time guest here. I think you were here with Nancy Grace on another occasion, but this is your second time with us at Court TV. And the issue that we didn't have a chance to talk about a moment ago when we were focusing on what the jury knows about the victims was there was also an allegation of a sexual assault by one of the victims against a young person. That's probably even more unusual to come into a case like this, where there are allegations that he may have seemed a violent person and therefore his prior alleged violence with others came in. But that's even more unusual, is it not, to have a prior bad act involving an alleged sexual misconduct come into a case like this, is it not?
Yes, because one of the things that we always have to worry about in terms of the defendant is that this information can be so prejudicial to the defendant that even if the information, you know, maybe even if there is information of a prior act, very often the court will say, this information, we have this information, but we're going to keep it out because it's not similar in kind to what's going on now. And the jury may be so prejudiced because a prior sexual act, this is a young teenager, and this kind of information coming into the jury's mind may prejudice them, even though in fact it has nothing at all to do with this case. It didn't occur at the same time. It occurred quite a bit tough time earlier than this, and there's no indication that there was any connection between this prior bad act and what he's charged with now, or what he is dealing with now. And so the jury may feel this is a bad person, and therefore they'd be much more likely to discredit his testimony, even though he is the victim in this case, as opposed to being the defendant in the earlier case.
Now, on the other side of the coin, the defense was not happy that some other bad act evidence, as we call it, or other things unrelated to the events of this day came in about the defendant. That is, after the defendant testified that he'd never fired his gun before and that he did not act out of racial bias or prejudice, his former girlfriend was allowed to testify that the defendant had expressed racial animus, had used racial epithets about black folks, and that he had fired an AK-47 at her on a prior occasion. It's probably more within the realm of what's usual for that kind of evidence to come in against the defendant once he testifies, but even so, that's the kind of testimony that can be significant, and defense lawyers generally don't like to have that kind of evidence come in.
Understandably, because that can do the same thing for the defendant that the other kind of testimony can do for the, in this case, the victim, and that is that it can prejudice the jury against the defendant. As you said, he testified he'd never shot a gun before, and then his ex-girlfriend comes in and talks about him doing this, and also in a way which is very frightening, taking her out into the woods and shooting a gun by her side and threatening to kill her if she ever breaks up with him. So this is sort of evidence, at least it may be evidence, that this is a man also with very violent tendencies who may shoot before he thinks.
So now we have two interesting contrasts here. At both extremes, there are factors that jurors are allowed to consider, but only for a limited purpose. That is, the jury can't say it's all right to shoot at MONTELL Butler because he's a bad guy, and they can't convict this defendant because they don't like his racial attitudes or how he treated his girlfriend in the past. The kind of evidence we're talking about that has nothing to do with the events of July 15th comes in for a limited purpose. But is that kind of an intellectual game that lawyers and judges play with themselves when we ask jurors to consider something but only for a limited purpose?
In my experience, I would think it absolutely is. You know, it's like we do this very often. It's just like sometimes when a lawyer will come in and say something and the judge will tell the jury to disregard it. And in those situations also, that often puts out a red flag for the jury to really listen to it. If we're told to disregard it, it must be something very important. And I think the same thing here. When you're instructed to do something for a limited purpose, it might arouse your curiosity.
Let me interrupt you just for a moment to point out that the lady in red behind the defendant is the defendant's mother, Janice. She, too, I'm sure, is quite anxious as we await the verdict of this jury. After deliberating 4.5 hours, this unsequestered jury indicated a few moments ago to the judge that it had a verdict. He had another matter to dispose of. Then he left the bench for for reasons unknown to us, but we anticipate he'll be back on the bench in a few moments, and we'll learn what the verdict is. In the meantime, we're talking to Professor Swartz about a number of aspects of language and deliberations. On the other hand, while I agree with you that it's hard certainly to expect people to disregard things, I've had jurors come up to me and say, you know, Mr. Brown, I thought your guy did it, but the state didn't prove it beyond a reasonable doubt. That is, jurors, I think, do take seriously concepts like reasonable doubt and burden of proof. So there are some of the things we construct in the law that are kind of intellectual barriers or hurdles that we expect people to overcome that are taken seriously, and others in which we're probably engaging in some kind of fiction. And endless debates among lawyers and professors and people in legislatures and judges leads to refinement and debate, but I'm not sure that we've easily separated the wheat from the chaff, which ones work and which ones don't.
Yeah, I have a lot more confidence, probably like you do, in the jury system. I mean, because I do think that overall, even though you may tell people at some point to listen to, take things and use this for a limited purpose, and they may not do that, I have ultimate faith that in most situations, the jury actually does its job and takes it very seriously, and that they're really trying to figure out for themselves what this beyond a reasonable doubt means. That's a very hard concept in the law.
And in fact, in some places, a reasonable doubt is defined as an honest and reasonable uncertainty, which doesn't really give you much more clue as to what it means.
Yeah.
What we're going to do, we're waiting for this verdict. We don't want to go away because we don't want to miss it, but we thought maybe we'd show you a highlight relating to one of the things the professor and I have been talking about, and that's the testimony of the girlfriend, Lisa McIntyre, who testified yesterday morning. This is what she had to say about some of the defendants' attitudes as they related to race, and we'll find out in a few moments, perhaps, whether that may or may not have swayed this jury. So let's listen to a little bit of what the girlfriend had to say yesterday. Keep in mind, we will interrupt at any moment when we believe a verdict is about to be rendered.
Can you tell us?
Followed a little part of the case on court TV, and thereafter, she says, called prosecutors and became a witness. So the issue clearly joined the defendant saying, no, he didn't have those attitudes, a prosecution witness saying that he did. And there still remains the question of whether jurors will consider that, and if so, what importance they'll attribute to it. Interesting that, as a general rule, while we speculate about these things, unless we get to talk to jurors afterwards, we never know how each particular fact may have been involved in the verdict. Is that because the courts really don't want to know, sort of like the sausage factory, you don't want to know how it's made, or because there really is a sense that the province of the jury, we even use the term province, should not be invaded by others?
I think it's considered sacred. I mean, just the jurors are there to make their decision, and they can base it on anything. I once had a professor of mine come back and tell me that a juror came up to him. It was he argued a case on St. Patrick's Day, and he was wearing a green tie. And she came back afterwards and told him that she had voted his way because of his green tie. You know, that's unusual, I hope.
I think they generally have more substantive reasons, but certainly the folklore among lawyers involves a lot of paranoia about, and some of it justified, about the need to make sure that, for example, how you behave in the hallway or how the defendant behaves in the hallway is not anything that might be objectionable to jurors, because you want them to focus on the facts most times, although sometimes you may want to distract them. The young lady, by the way, who we saw a moment ago seated next to the defendant is Elizabeth Reisman. She's another lawyer involved in the team, but the principal lawyer, Dan Summer, for the defense, is in chambers, we think, with the judge. We think along with the prosecutor. At least both of those lawyers are missing from the courtroom, and the judge is clearly not on the bench. We'll know, I'm sure, in a few moments, though the time, I'm sure, is dragging for the families of the victims, the families of the defendant, and the defendant himself, because this is among the most tense moments you can experience in a courtroom. Knowing there's a verdict, not knowing when it will be rendered, and, of course, not knowing what that verdict is. It's the kind of thing, I suppose, for which, despite the distinguished work that you and your colleagues do in law schools, there's no way to train someone to handle this. As a lawyer, you learn using whatever people skills you've evolved over time and whatever experience you develop in the courtroom, how to handle this, what to say to a defendant, what to say to worried relatives at this moment, most of which is just pablum, because they're going to have knots in their stomach until it's rendered, and nothing you can say or do will alter that.
I think this uncertainty is just uncertainty, and as you said, you just have to sit there with them, be supportive, and keep your fingers crossed, you know, because obviously nobody knows until the verdict is rendered. So the lawyers are also feeling pretty nervous. Okay. Because, of course, they want their side to win also.
One of the other areas that the professor and I have discussed about things that came in that don't go so much to what happened on June 15th, but are maybe considered by jurors, is the defendant's statement, followed by a contradiction by Ms. McIntyre, that the day he fired that gun, July 15th, 1997, was the only time he'd fired a weapon other than target practice. This is what he had to say when he was questioned about the prior firing of his gun.
You testified on direct examination that your discharge of this weapon that you discharged on July 15th, 1997 was the first time you had to discharge, I think you said first time you had to discharge your weapon. What it was that you meant by that?
That's the first time I've ever had to shoot my weapon in defense of my life.
What other purposes, if any, did you use your weapon for?
Target practice, shoot cans, bottles, targets, things like that.
Other than shooting your weapon on this occasion, in connection with how you testified you shot the weapon on July 15th, 1997, is the only thing that you use your weapon for is target practice, shooting cans, bottles, and that sort of thing?
Yes.
Well, in the lower right-hand corner of your screen, right there, should be a verdict watch bug. We expect it to disappear shortly because we've been told there is a verdict in the case we've been watching for the last week. The trial involving Stephen Kolokorius, charged with aggravated assault on 2 young teenagers. The jury indicated about 10 minutes ago that it had a verdict, but the jury hasn't appeared, the judge is not on the bench, and the principal lawyers are not at counsel table. We can only assume the judge is conferring with counsel, but that we will have a verdict very shortly. We're waiting, as you are, to find out what this verdict is, and we've been looking at some of the evidence that came in, particularly some of the evidence that may have affected the jury, but which was not related solely or exclusively to what happened on July 15th. We've just seen the defendant indicate that he never fired his weapon before that, except, of course, in connection with target practice. But this is what his former girlfriend had to say when she was called in rebuttal.
I think I asked you, was there a specific incident between you and Stephen Paul Kolokorius involving the use of a gun by Kolokorius as against you?
Yes.
All right. Now, you described the mode of transportation by which you got to the place in the country. Is that correct?
That's correct.
All right. Now, when you got there, when you actually got there, all right, did you remain in the car or get out of the car?
No, you had me get out of the car.
All right. Where were you seated in the car when he had you get out of the car?
I was in the front passenger's seat.
Did he use any words to give you indication for you to get out of the car?
He screamed at me to get out of the car.
Well, what's happened is that Dan Summer, the defense lawyer, has returned to counsel table and is conferring with his client. Evidently, something has happened that warranted the judge talking to the lawyers, and Mr. Summer obviously has an obligation to convey whatever happened to his client. It just makes our waiting for the verdict a little more interesting. There's no way in the world for us to know what this is about, whether it has to do with the form of the verdict or what the jurors may have said. We are now in the realm of pure speculation. All we know is that we were told about 15 minutes ago that the jury had rendered a verdict. The judge handled another matter, left the bench, counsel left the courtroom, and now Mr. Summer has returned to confer with his client. And you can read his countenance as well as I to determine whether this is good news or bad for the defense. In any event, I imagine very shortly we'll be learning exactly what happened. One of the things, Professor, that a defense lawyer has is an obligation to communicate everything that happens to his client, though there are those occasions when there may be information that others don't wish him to have, but the lawyer has an obligation to tell everything to the client, does he not?
Yes, he does, and that's appropriate. He is the client's advocate. He or she is the client's advocate.
But interesting, complex discussions sometimes about when things that happen in the courtroom are the lawyer's choice and when the defendant's choice. I mean, it's pretty clear, for example, that a defendant has to decide whether to testify or not. On the other hand, whether or not to call witnesses or whether to ask certain questions is something that lawyers have debated for a long time about whether the defendant has the right to insist that certain things be done or not done. So there is sort of a murky area, though, with respect to issues concerning deliberations. You would assume a lawyer would always keep his client fully informed and they'd make joint decisions.
And you would assume for anything that was considered major in a case that a lawyer would make sure to discuss it very carefully with the client, because ultimately it's the client's life and not the lawyer's life that is at stake.
Well, one of the things that can happen is that, I'm sure the viewers would be shocked to know this, but some lawyers have egos. I suppose I have to include myself in the number, and sometimes it's possible for a lawyer to begin to say, this is my case. The lawyer fights hard, works hard, and this could be a prosecutor or a defense lawyer, but in fact, the case belongs to neither. In each case, each has a client. The prosecutor's case, it's the state, which is usually some boss somewhere sitting in a room. And in the defense case, it's a defendant. And where there are differences of opinion, ultimately, you have to keep in mind that it's the destiny, especially on the defense side, of the defendants that's at stake. And while a lawyer may disagree with the decision, ultimately, on critical matters, it's really up to the defendant.
That's right. The lawyer goes on to his or her next case, and the defendant has to live with that decision. And therefore, it's extremely important that the defendant understand and realize that he or she is involved completely in whatever happens in that case.
One of the things that I think is perhaps lost when we watch this scene and it seems so tranquil is that, in fact, depending on the jury's verdict, this could be the defendant's last moment of freedom. That is, if there were a conviction, the judge could choose to revoke his bail and he could immediately go to jail and await sentencing. On the other hand, a not guilty verdict and he's home free. Obviously, there's another option, which is a conviction followed by bail pending sentence. But for a defendant, I mean, this is really the critical moment, because based on what those jurors say, he may or may not be seeing his last moments of freedom. And I don't say that to artificially build suspense, but to say that's one of the realities in this situation.
I feel tingling myself for that reason, because I think that's right. And you know what's at stake. And even if the person is convicted but is given bail, it's very different than a person who has not been convicted. He will be viewed very differently by the community. He will see himself very differently, and he will be, you know, in a state of sort of uncertainty, because he may very well be going away to prison, even, you know, or even if he has to wait a while for the appeal, he is a convicted criminal until the appeal is heard. And
great anxiety between the date of conviction and sentence, even if a defendant is at large, because he now has the possibility, however distinct, of spending time in jail, has to prepare to do that while at the same time working as hard as he can to prevent that from happening. So this is the time which is one of tremendous uncertainty for that defendant. On the other hand, clearly victims, especially in a case of violence, can have their own apprehensions about what may lie down the road depending on the jury's verdict.
I was going to say that the lawyer, of course, the lawyer's role doesn't end at conviction if the person is convicted, because then the lawyer has a very hard role to try to deal with the sentencing and to try to get for his or her client, you know, the most lenient. If they're a defense lawyer, you're going to try to get the most lenient sentence you can, maybe even parole, maybe even probation. And if you're the prosecution, you're going to be working very hard at that during that time period that you have to try to be able to persuade the judge when you come up for sentencing that this defendant should get the maximum sentence.
Well, Mr. Kolokorius just left the courtroom. We think it's for a moment. Your guess as to why is as good as mine. We're in the realm of pure speculation and some anxiety, especially understanding the anxiety of those in the courtroom now awaiting the verdict. In the meantime, why don't we focus on another moment that may have been of great anxiety, the moment at which Mr. Kolokorius said he looked at Mr. Clark and was somewhat anxious himself.
Recalling that you're under oath, you tell me all of the factors that made you feel funny about these individuals outside in front of that store.
Asked and answered, Your Honor.
Overruled.
What made me feel funny about that day was when I walked into that store, the man identified as Kellen Clark gave me a really hard stare. Other than that, I mean, there's no other reason that I would feel funny.
We are now ready to go to Gainesville, Georgia, because there's a verdict about to be rendered.
If we could go back on the record in the Kolokorius case, it's my understanding that the jury is unless there's another matter that we need to attend to, I'm going to ask Ms. Villiard to bring the jury in. Case, please make sure that the jury receives the same courtesy that you would want when the verdict is announced. Any outburst would be unacceptable, and make sure that you're prepared to receive the verdict in any fashion that the jury may return it. In the event that anybody cannot do that, they need to exit the courtroom now, or the deputies will assist you in doing that at this time. All right.
Well, while the judge is sending for the jury, we might comment briefly on his admonition. I have seen many verdicts rendered in courtrooms, and sometimes there is a quiet, almost eerie calm, but sometimes outbursts, cries of varying dimensions. And so it is frequently true that judges will suggest to spectators not to respond at all. Frequently, defense counsel will urge his family members, the members of his client's family, not to respond. And prosecutors sometimes do the same with victims because it is a very emotional moment. You now see Mr. Kolokorius standing, which presumably means the jury has actually entered the courtroom. As you know, we don't show jurors' faces. It's a matter of policy here at Court TV, though it's also the rule or the law in many states. But we are now, at last, a few seconds away from hearing the verdict in the case involving Mr. Kolokorius. We've been waiting for about 15 minutes while the judge attended to some aspect of this case in chambers with the lawyers. We are now going to hear a verdict in just a few seconds.
All right. Jury has reached a verdict, is that correct?
Yes, sir.
I would need to review that verdict for its form and content if you'll surrender that to Mr. That. It's Mr. Whitmire to announce the verdict if you chose to do. Practice as the clerk of court provides us with a clerk and publish the verdict if you direct that that be done. Is that what you would like to have done?
Yes.
All right, then I'll ask that that be done. The verdict appears to be in proper form and content, and I simply will ask the clerk to publish it at this time.
It was a verdict that lesser included offenses.
You and Mr. Summer at the bench, if I could, for just a moment, please.
Well, this is about as prolonged and agonizing as a verdict can get. Initially, we were told it was a verdict. Then there was a delay while the judge handled another matter. Further delay while the judge in chambers presumably conferred with counsel. And just as the judge was about to authorize the clerk to read or publish the verdict to the defendant and to others assembled in the courtroom, he summoned counsel to the bench. Obviously, there is something that has been the subject of discussion to this point. We'll eventually find out what it is, I'm sure. But this is about as prolonged an ordeal as a defendant could face. Nonetheless, aggravated assault, the principal charge this defendant faces, and that carries a serious penalty of up to 20 years in prison should he be convicted. On each of the aggravated assault counts, there's a lesser included offense of pointing or aiming a gun or a pistol. And there is also a third charge of reckless conduct which the defendant faces, and in short order, we think we'll be learning what decisions the jury has made with respect to those verdicts. Interesting that right now there is a meeting called at the bench to look at the verdict form after the judge had decided that that form was in proper order. So we'll just have to wait, because to this point, most of what we've been doing is speculation. Professor Schwartz, seem an unusually prolonged verdict for you?
Yes, and I'm sure it does for the defendant. You could see his face, and he looked very nervous, and his hands were covering his eyes, and you could just feel his own tension. We can't see the victims.
Let's take a look at him, and it's not surprising that Ms. Reisman is offering him some kind of comfort, because for him, whatever this verdict is, this moment has to be sheer torture. as it may very well be for the victims' families, but he's a man whose destiny most immediately affected by what's about to happen. Let's see if we now proceed with the reading of the verdict or whether there's further conferring by the lawyer. He's talking to someone, not the defendant.
Verdict for us at this time, if you would, please.
In the Superior Court of Hall County, State of Georgia versus Stephen Paul Kolokorius, criminal file number 97-CR-1306A. As to count 1, aggravated assault, we, the jury, find the defendant Stephen Paul Kolokorius not guilty of the offense of aggravated assault. Count 2, aggravated assault. We, the jury, find the defendant Stephen Paul Kolokorius not guilty of the offense of aggravated assault. As to count 3, reckless conduct, we, the jury, find defendant Stephen Paul Kolokorius guilty of the offense of reckless conduct this 12th day of May. Ron Ely, jury, foreperson.
I'm going to ask at this time that Mr. Whitmire display that verdict to Mr. Dara and Mr. Summer prior to its filing. Although we discussed a issue at the bench, that issue will be noted, Mr. Dara, but any other objections in reference to the verdict?
No, sir.
All right, Mr. Summer.
Yes.
All right. Once you've obtained the verdict form after displaying it to both sides, then if you'll make a copy, file it, make a copy for the attorneys and for the court, please. You want to look at that verdict, Mr. Summer? Any?
You want to look at it again?
No. All right. Conducted its duties and responsibilities to the end. You will have no further duty in this case. Once you've returned the verdict, then your job is complete. I must say that I haven't seen a jury in a good period of time in this circuit that has worked as hard or as diligent as you have as a jury body, and for that, I thank you. The district attorney thanks you, and the defendant thanks you in this case. Our system would not operate without juries. In this case is certainly no exception. I'm going to now turn to what is my responsibility. I have the responsibility for sentencing in this case, and I take a variety of factors into consideration in sentencing. And this case will receive the same consideration that I give any case. And in reference to what I intend to do with this case, I intend to delay sentencing to allow the attorneys to have the opportunity to present any evidence that they would like in reference to sentencing. But during that time period, based on the evidence that I heard in the case and the facts as I found in the case, which I would then utilize for sentencing, I'm going to require this sentence I'm going to require Mr. Kolokorius to be taken into custody and held until the sentencing hearing. We will have a sentencing hearing within 10 days of today's date, and at that time the court will impose its sentence in this case. The sentencing hearing will be obviously not only open to the public, but for you to attend if you choose to attend at that time. But at this time, Mr. Kolokorius and Mr. Summer, I would require Mr. Kolokorius to be taken into custody at this time based on the conviction of the jury, although noting only a misdemeanor conviction based on the facts and circumstances that I have found exist in the case. I'm going to ask that that occur at this time.
There you see Mr. Kolokorius heading towards the jail.
Although we've taken a great deal of your time,
let's go back to the courtroom. We'll talk later in a moment.
To step back into the jury room so that we can complete paying you and then place you in recess. If you'll step back into the jury room for me, please.
Well, kind of unusual developments. The first is, of course, that the defendant was acquitted of the most serious charges. Each of those aggravated assault charges carried potentially 20 years in prison. That's 40 years possible. And so he was acquitted of those. He was convicted of reckless conduct. It's a misdemeanor charge carrying 12 months in jail. I'm going to talk to Professor Swartz about that in just a moment because it's a little unusual for a defendant to be remanded under these circumstances. But also, I think we figured out the reason for the delay. At least let me saddle myself with this guess and no one else. And that is that, you recall we said there was a lesser included offense. The jury was told that if it acquitted the defendant of the count of aggravated assault, it should consider pointing or aiming a gun or pistol. It appears the jury never considered the verdict of the lesser included of pointing a gun or a pistol, and that may have been the reason for the delay. The judge nonetheless considering the verdict a proper one. The defendant convicted of a misdemeanor which carries up to 12 months in prison. And Professor Swartz, while obviously judges have broad latitude on bail matters, this judge is remanding this defendant. Would suggest he does intend to give him some time, maybe up to the max, because he's suggesting that he views this as a serious case, and kind of unusual in a misdemeanor for a man to be held over because generally if you're only facing a year in jail, the court assumes you'll come back for sentencing.
I agree. We both made faces of surprise, basically, when this happened. I'm very surprised. I would not have expected that. And I agree with you. I think if he's holding him over for 10 days now, it is unlikely that he is going to release him at the time of sentencing. So I think it is likely that he is going to serve some time here.
Based on the fact that there was no argument either on the bail issue and I wouldn't be surprised if the defense counsel hadn't learned about the verdict when he went up to the bench, because certainly he didn't seem surprised that the judge was going to remand the defendant. In that 10-day period, which is not so long, both sides will have a chance to submit information to the court, and then there'll be a sentence, but one I think is fair in inferring from Judge Fuller's. Certainly if the judge knew he was not going to send him to jail at all, he wouldn't remand him.
Right.
He wouldn't take him back to the county jail.
Right.
So at least we know he's going to do 10 days. Beyond that, I think it's fair to speculate that the judge intends to impose some time and to make separate findings of fact, which may even differ from those of the jury.
And this is where we talked about there is an important role for his lawyer here as well as for the prosecution, because his lawyer is going to really have to try to persuade the judge now not to impose the maximum sentence on him.
It's true, and although we saw Mr. Summer with some justification taking some congratulations from his co-counsel, because obviously they beat the two more serious counts, his job is just beginning. The ultimate question is deprivation of freedom and liberty, and I'm sure that's what Mr. Kolokorius is concerned about. So you see him, I suppose, with mixed feelings, one having saved his man from a very long prison term, but still facing the possibility of hearing a sentence of 1 year in jail imposed in 10 days. We're going to take a break, and we'll be back in just a moment to continue our coverage.
The young boys to kill, that more or less cemented that part for me right there.
Yeah, and it's interesting you just called the alleged victims the defendants, because that's how it seemed in trial a lot of times, didn't it?
It did.
What did you think about all the testimony about Montel Butler's past?
Well, you have to take some into consideration, but I tried my best and did the best job in my ability to do this. I tried my best to keep to the facts of the case. That was the most important thing. We can't judge things that happened 10 years ago, and even 3 weeks later, it had nothing to do with this case. This case was a complete separate idealism. His past is very speculative, as we found out, and it is very, it's just very revealing to have those things at such a young age that he had, and well, we had to get down to business and do what we felt were right as jurors.
Now, as for the events at the Citgo, do you believe that Stephen Kolokorius believed an armed robbery was about to occur?
It's possible, but the evidence pointed to that possibly, but we couldn't justify exactly how he handled the situation. His handling of the situation was, this isn't John Wayne in the Old West. This is America in the 1990s. It is a dangerous world we live in. And there's no doubt in anyone's mind about that. You can read your daily papers or watch this TV every day, and you can find that out. So we just had to basically act as we felt was true. I didn't feel that he was guilty of an aggravated assault because I don't believe he done it maliciously. I really don't. I believe he did believe there was a potential of a robbery in place. But his handling of the situation, I felt, was a little bit forward.
Now that he's been convicted of a misdemeanor, Mr. Kolokorius faces a maximum of a year in jail, 12 months in jail, or as minimum as probation. What would you like to see the punishment be?
Basically, since this is his first offense that is known, I would say my basic opinion, 3 to 6 months would be plenty for him to serve.
But time in jail, you'd like him to serve some time?
Yes, to learn a lesson by. But it's really hard. That's for the judge to decide. It's not for me.
Do you think race played a factor in what happened at the Citgo?
Not as far as I'm concerned. No.
Well, thank you so much, Brian Wiley, for coming to talk with us. We appreciate it very much.
Thank you.
It's always interesting to get insights from jurors. And Raymond, let me pass this back to you. I see the mother of Kellen Clark ready to talk with us next.
Clara, we'll free you up to get us more of those good insights. In the meantime, Professor Swartz, were you surprised that thus far both jurors have indicated, neither juror has indicated they thought race a factor in this case?
Well, it does surprise me, but I think it's very common for jurors to say that. It's hard to go into people's subconscious. You know, we have to just kind of take them at their word. But these were 2 black youths. This was a white man. This is very often the case. I mean, you think about the Bernard Goetz case in New York City.
Interesting comparison.
And there we had a white man who was surrounded by 4 black youths, and he took out a gun. He thought that they were going to rob him, although there was no proof that they were going to. And he just started shooting. And one of the concerns in that case also was this issue of vigilantism, because he could have shot up all the people in the subway. I mean, he was sitting in a crowded subway shooting a gun. And although he was not convicted of the greater charge, he was convicted of illegally having a gun. And in that sense, he was given a 1-year, I think it was a 1-year prison sentence also. So the jury there also wanted to send a message to him that even though they didn't say he was being a vigilante, they wanted to let him know that he shouldn't be doing this in a subway.
Okay. Well, Clara has done it again, found another interesting and important person. This person, Kellen Tyler Clark's mother. Clara?
Well, Raymond, Vanessa Clark has been in court for most of these proceedings. She is the mother of one of the alleged victims in this case, Kellen Clark. And thank you for joining us, Mrs. Clark. What's your reaction to the verdict?
I'm very disappointed that Stephen Paul Kolokorius wasn't convicted on aggravated assault. I really feel that justice wasn't served here today. But I can just say that I'm very thankful that my son, Kellen Clark, is alive today. And I'm thankful that, and in my heart, I believe that the true judge, which is God, will have his time one of these days.
Do you think this will have any effect on the civil suit that your family is thinking of filing?
I really don't know, and I really don't care at this moment. The most important thing to me was that Stephen Paul Kolokorius answered to what he did July 15th.
What will you tell your son about this verdict?
I guess I would tell him this, is keep believing. Someday something has to change.
Okay. Thank you, Mrs. Clark, so much. Raymond, it's a difficult time here at the courthouse. There are people on both sides of the issue, and you can tell it's an emotional time. It's a very difficult time. You could see that on Mr. Kolokorius' face when he was convicted. I'm not sure how well that showed up on camera, but in the court, it appeared to be a very emotional embrace that he shared with his attorney, Dan Summer, as he learned for the first time that he would not face that potential of 40 years in prison for the aggravated assaults. As he heard that not guilty, he began to get very emotional and hugged his attorney.
Clara, there was a long delay between the moment we first learned of the verdict and the actual rendering of it, at least long in the span of time for people to wait for a verdict in a criminal case. What was the feeling in the courtroom during that period of time?
Well, Raymond, there were a couple of reasons for that. One is that the judge was handling another matter that coincidentally Dan Summer was handling, the defense attorney in this case. They were questioning a witness on a totally unrelated case, and that took a large amount of time to finish that, and the judge had already said he would finish what he was doing before he took this verdict. And then there was a wait to get enough law enforcement officers in the courtroom, as I said, more than a dozen in there. Well, during the hearing, not much emotion in the courtroom as people were just filing in, but as the law enforcement officers came in and word spread through the courthouse that indeed a verdict had been reached, it began to get a little emotional, just a little tense in there. There were a lot of emotions, a lot of things riding on this jury verdict on both sides of the courtroom.
I noticed that Coach Ely said you could not please anyone, or you could not please everyone. And also, I think that Mr. Wiley sort of referred to a sense that the community should should be clearly understand you can't use firearms in an irresponsible way. Obviously, jurors aware of the extent to which the community is focused on this case.
I don't think they couldn't be when they looked out in the courtroom and saw some of the civil rights leaders from the Gainesville area in court every day. I think it would have been obvious, even if they hadn't known about the case beforehand. And most of these 12 jurors said they did not know about the case before they were chosen as jurors for this trial.
We understand the prosecutor's statement that there are no victories in these kinds of cases, and there's much to that. But fair to say in a broad brush way that supporters of the defendant, notwithstanding the fact that he's exposed to a year in jail, would regard this verdict as a victory, and folks related to or supporting the victims, as Ms. Clark regarded as a loss or something less than full justice?
It may well be, and Raymond, if you'll give me just a second, we can find out from the horse's mouth, as it were. We have one of Stephen Kolokorius' friends ready to talk with us, and then also defense attorney Dan Summer.
Okay. Well, we'll be anxious to hear what those other folks have to say, because this is a verdict that has a profound impact on that community, and I suppose the larger community that's watching that includes you, so stay right there.
Of the offense of aggravated assault.
Those are the words of a jury, or actually the clerk of the court, rendered about a half hour ago. Mr. Kolokorius acquitted of counts 1 and 2 aggravated assault, but convicted of reckless conduct. That carries a maximum of 1 year in jail, and in fact he was remanded. That is sent by the judge directly to jail for 10 days to await a sentencing hearing, which will then determine how much time, if at all, he will spend in jail. Of course, after verdict, as you know, we always try to remain in the locale and find out more about what happened in the case. And we've got Clara Touma in Gainesville, so you know everybody of significance is appearing before our camera. Now the defense counsel. Clara?
Well, and Raymond, now we're about to speak with Sean Cannoni, who is a good friend of Stephen Kolokorius, is the defendant in this case. Thank you so much for joining us, and what's your reaction to the verdict?
I think the verdict was definitely fair. Stephen reacted in a way he was trained to react in a law enforcement capacity, and he did what any other law enforcement officer would do. And it was a split-second decision. I don't think it was done maliciously. It wasn't based on race. It just happened.
It looked like he was a little emotional as that verdict was read in court. Did you read it that way?
Emotionally happy, I believe. Yeah.
Now, you didn't get a chance to speak with him, but you did speak with his mother. What was her reaction?
She's glad that the serious charges he did not get convicted of, and the lesser charge he was convicted of, and we just got to reassure her that everything's going to be all right, because she's a nervous wreck right now.
Why do you think he was taken into custody for a misdemeanor?
I believe it was to put the community at ease, basically. Most people that get convicted of misdemeanors that have ties to communities such as Stephen would be released on their own and then come back for trial. But I think that he was definitely put up just to put the community at ease.
Describe that a little more. To put what community at ease?
Put the racial tension at ease, to keep things cool, basically. I'm from Miami, a place where they have lots of riots, and I've seen lots of riots. I had friends killed in lots of riots, and if anything could be done to prevent a riot, it's in the best interest of the community to do that, even if somebody has to do jail time over it.
The maximum sentence now is 1 year in jail. The minimum is probation. What do you think the appropriate sentence would be?
Because Steve didn't act maliciously, I would say probation.
And what would you say to people who say this was a trigger-happy young man who fired before he got all the facts, who fired before these, what he called were armed robbers, even walked into the store? What would you say to them?
Steve was the chief of my security, and if that was the case, he would have never worked for me. I trusted his judgment.
Thank you so much, Sean Cannoni. Appreciate you talking with us, Raymond.
Clara, and I want you to know, I knew that wasn't the defense counsel. It just happens sometimes. But I think maybe Clara will get the defense counsel before we're done. In the meantime, I wanted to ask you a question, Professor, about the difference between felonies and misdemeanors. At common law, going back thousands or hundreds of years, there was, a felony was something that could involve forfeiture of all your lands and estates. A serious distinction between major and minor offenses that's been carried over into contemporary America.
Yeah, not only forfeiture of your lands, but very often death.
Forfeiture of the blood, as it was called, which was a little more dear even than your lands, but certainly serious. And while we don't forfeit, in fact, it could carry forfeiture for your family as well, but we don't obviously carry to that extent. But we've maintained that distinction, and generally misdemeanors less than a year or a year, and in some cases even the right to a jury trial and a whole other panoply of rights attached, depending on whether it's a misdemeanor or a felony. Of course, to the person during the time, either can be significant.
Yeah, but obviously if you know you're convicted of a misdemeanor, when you're charged with a felony, you certainly know that you're not going to go to prison for more than a year, so you know that your time in prison is not going to be humongous.
Well, another factor is that when you fill out those little forms that say, have you ever been convicted of a crime, some of them you can actually say no if your only conviction is for a misdemeanor as opposed to a felony. That's how much of a distinction we tend to draw between felonies and misdemeanors.
Yeah. And, you know, just here, when the prosecutor didn't know whether or not he would be deprived of his right to carry a gun. He knew for sure that had he been convicted of a felony, he would be deprived, but he didn't know whether or not a misdemeanor would also require that he be permanently deprived of his right to carry a gun.
Okay. Well, here, Clara Tuma is standing by with another person, not the defense counsel, but a father of Mr. Clark, one of the victims in the case. Clara?
Raymond, you're exactly right. This is the father of Kellen Clark, John Clark. Thank you so much. And Mr. Clark, what do you think about this verdict?
I think it was wrong that they just charged him for aggravated assault. I think he should have been charged at least for one count for the shooting, because one person had got shot. But I don't like the way it ended up.
Do you think that race played a part in what happened out at the Citgo?
Well, yes, but not race for Hall County, the race of Stephen Kolokorius. Because my son said he followed him to the store. And then they saw him maybe once or twice on the road. And, well, he had a good lawyer. The lawyer did what he's supposed to do. But,
may I interrupt you, Mr. Clark? You're saying that your son told you that Stephen Kolokorius saw he and Montel Butler before they encountered each other at the store?
Yes, he did. But see, he was 13 at the time, and as he said in the courtroom, I saw him, but then the lawyer questioned him, you know how he was probably nervous. He said, well, I thought I saw him. Then he said, yeah, I saw him, I thought I saw him. Then he saw him, because he told me he saw him that day. And, well...
And do you think Mr. Kolokorius saw them on the street with the guns and then followed them to the Citgo?
No doubt in my mind. That's what happened.
And did you tell the prosecution that?
Yes.
The prosecutor?
Yes, but it wouldn't come out. That's right.
Now that we've seen Mr. Kolokorius convicted of reckless conduct, the sentence is up to a year in jail. What do you think the right sentence would be?
The right sentence would be, well, more than a year. Maybe 10 year, 5-year probation. You know, anything except for a year. To traumatize my son, and I got to look at him, and then the whole county wouldn't lock him up. Then I couldn't do nothing about it because I'd end up in trouble. So, yeah, he need to take this to another level.
So are you saying he should do jail time, or are you saying you'd be satisfied with probation when he's out on the street?
He need to do jail time, just like I would if I'd done it. I'd have done jail time.
Now, I asked you if you thought race was an issue out at the Citgo. What about in the jury? Do you think that the fact that there was only one African-American on the jury might have made a difference?
It made a big difference. It should have been at least 5 to 6. Don't you agree?
I'm asking you.
I'm telling you like I feel. It should have been at least 5 to 6. Either way you put it. You put one African American up there against 11 whites, what can he do? He had to follow along with it. He had to follow the suit. So that's what he done.
Okay. Well, John Clark, thank you so much. I know you've been reluctant to come on camera before. Thank you so much.
All right. Appreciate it.
We appreciate it. Raymond, let me hand this back to you. And I promise when we come back, Dan Summer, the defense attorney.
Well, Clara, have you ever broken a promise before?
Not to you.
Okay, that's important. Professor, an interesting issue of race. The Supreme Court has increasingly, in the last several years, really since 1986, addressed the issue of race and jury selection, but it's never mandated, required that people of any race be on the jury. It simply said you can't exclude people of a certain race. First of all, I guess we should talk about the policy concept and then what the result is, because the court has never required that there be any mixture of any particular racial group on the juries. On the other hand, it said that a white defendant can complain if blacks are excluded. So it's kind of a mixed bag in which the court doesn't address the issue Mr. Clark addressed, which is how come there aren't more blacks on the jury, but has sort of by the back door talked about the issue issue in policy terms.
Well, you know, the whole question of what does a jury of your peers mean? And people can argue that in a lot of areas, not just in racial terms. I mean, people who are a certain religious group, let's say, and especially if the case before the court deals with some kind of religious slur, might feel offended also if people of their religious background aren't on the jury.
But the court has extended this concept to gender and race, but it's never said what I think most folks would expect it to say, that is that a jury should include a certain number of people. And yet the court has wrestled with this issue, probably not very successfully, but I know I threw that out and haven't given you a chance to respond because Clara has gone out and gotten yet another interesting person to talk to, not the defense counsel, but a member or at least one of the leaders of the Southern Christian Leadership Conference, Clara.
Raymond, Dan Summers is coming up, but now we have the privilege of speaking with Jeffrey Williams, who's a member of the Southern Christian Leadership Conference and who's been here every day at this trial, monitoring it, waiting for this jury verdict. And Mr. Williams, what do you think of the verdict?
Well, I don't think it went far enough. I think the jury was trying to just let Mr. Kolokorius know that he was wrong, but I don't think that the verdict fit the facts in the case.
Now, you had said all along you were skeptical of this jury verdict because there was only one African American on the jury.
Yes.
What do you think now?
I think that weighed out. I think if there had been more black people on the jury, or the two younger guys that was struck had been still on the jury, that had been more independent thought in there, and we'd probably be still in there if they didn't come back with a stronger verdict.
Now, you live here. Tell us a little about the county. What is the racial breakdown of Hall County?
I think there's probably 120,000 in Hall County, and only about 8,000 of that Afro-American.
Okay, what do you think the appropriate sentence would be?
I think that he should have been charged and found guilty of at least one count of aggravated assault because a bullet did hit one of the gentlemen in the neck, and doctors testified it was only centimeters to an inch from taking their life. So I think that aggravated assault would have been a direct verdict and a correct verdict.
Okay, what about sentencing, though? Now that it's a misdemeanor, a max of 1 year in jail, would you be satisfied if he were to receive probation?
No, we're not satisfied with the reckless conduct. In fact, as soon as I leave here and get an opportunity, we'll be contacting our national offices and also Jesse Jackson, which is a member of our national family, and we'll be moving to the federal courts to let them look at the case and have Mr. Kolokorius charged in federal court.
Have you spoken with anybody yet in the federal system?
Yes, they've been monitoring this case all the time because first of all, it took 3 minutes for the GBI to get 3 months for the GBI to get their report here. So we've been in close contact with our national office and also with prosecutors in the federal court, and I think now it'd be time to go in that direction.
And are you saying that you will seek to have Stephen Kolokorius charged with civil rights violations in federal court?
Yes, I think that this definitely, it came out, the reason he started approaching his gun was because the guys were black, and I think with his history, I think that's the reason they shot at him. I think that he said he got a funny feeling because somebody was looking at him. I don't know what his relationship with black people is, how much involvement he have in it, but from my study, that's always been a thought up through the era that that's a racist attitude.
Now, we spoke with two members of the jury. They said they didn't feel like that race was at issue there, or the deciding issue. They said they thought he fired much too soon before he had all of the facts of the situation. But that's not your belief, is it?
I think they probably thought that, I think race was an issue because they didn't want to give a young white guy a maximum sentence. They wanted to say you did wrong, but we're not going to send you to jail and give you all that time. That was very evident when they asked the jury if aggravated assault was a felony and reckless conduct was a felony. They probably found out on their lunch break that reckless conduct was a misdemeanor and aggravated assault was a felony, so they came back with the reckless conduct verdict.
What do you think this conviction will do to the state of race relations here?
I think that this conviction will make people work harder. I think the district attorney office will probably work harder, and I think the GBI agent will move more quickly, and the black community will move, and to make sure there are more jurors on the jury system. I think that we're many of us have been friends. Steve Kolokorius, of course, wasn't for Gainesville. We went to school with a lot of these people who are friends with people in the white community and his Hispanic community. That's not the problem. The problem in this case is Steve Kolokorius has his ex-girlfriend has noted and spoke to many of us, was a member of skinhead and had Nazi background. And in fact, he made that they should kill all niggers and send them back to Africa. And I think this is what this case is about, and I think that's the reason that he shot. He had an opportunity to shoot at two people that he might have thought were real guns. In all actuality, it was toy guns. He had an opportunity to do it, and he did it.
And there is some movement from the defense team to try and have a meeting in some of the African-American churches with the defendant and some of the leaders in the community. Do you think that would do any good? Do you think that would maybe heal some of what's happened because of this trial?
I think the first step would be to contact the federal court and have Mr. Kolokorius tried in the federal court. I think that then at that time, if they want to meet after that verdict, everybody be more than happy to meet with them. I don't think that this verdict was, and this jury gave us the answer we're looking for.
Hey, Jeffrey Williams, thank you so much for staying to talk with us.
Thank you.
Appreciate that so much. And Raymond, let me send this back to you. And I do see Dan Summer over here, the defense attorney, waiting to talk with us.
I don't believe you, Clara. But in the meantime, interesting that no segment of the community has the right to impose its will on a jury. And in fact, we insulate a jury. On the other hand, if justice is a secular faith, everybody needs to believe the system is fair. A continuing undercurrent, whatever you think about the particulars in this case, of black folks feeling that the system doesn't serve fairly, talk about seeking federal prosecution. Certainly there is a theoretical right to do that, but in fact, how often are there federal indictments after a state court has disposed of a criminal matter like this?
It's not easy to get a federal indictment in these cases. On the other hand, in New York, we did have a situation with the Yankel Rosenbaum case in Brooklyn, where a state jury did acquit the defendant, and then the federal jury came in and they did indict the defendant, and they actually did convict him of different charges. It wasn't the same charge. So it does happen. There's often a very long time period between whatever happens in the state court and whatever happens in the federal court. I think in the Yankel Rosenbaum case in New York, it took about 5 years.
And a similar result in the case involving the officers from the Rodney King case.
Yes.
Acquitted in the state courts, tried in the federal courts, but those very unusual circumstances. Yes. It's rare, despite the fact that it's often requested. Well, now they tell me that Clara Tuma is standing by with the defense counsel in this case. Let's go to Gainesville and find out.
Raymond, live and in person, as we promised for several minutes now. Dan Summer, the defense attorney in this case. Thanks so much for staying to talk with us. Mr. Summer, first of all, what's your reaction to the verdict?
We're glad. We're very glad.
And what was Stephen Kolokorius' reaction?
Relieved. Very relieved.
Now, you two shared what appeared to be a pretty emotional embrace as the verdict was still being read. Could you describe what that was about?
Well, it was a very emotional trial, a lot of high tensions, and he was very relieved that he was not convicted of the felony counts of aggravated assault. And we sort of anticipated a compromise verdict, and we were very, very happy to walk away with the reckless conduct conviction.
Jeffrey Williams from the Southern Christian Leadership Conference just told us he'll be going to federal court to try and seek federal civil rights charges against Mr. Kolokorius. What's your reaction to that?
I'll just defer to the United States Attorney's Office and the Justice Department. If they review the transcript, I think it'll be obvious there was no racial motivation in the case, notwithstanding the testimony of what's-her-name.
And, of course, what's-her-name being the former girlfriend of the defendant who testified. Let me go right to that question. Then she testified yesterday, said that your client was a racist. Why did you not bring in a witness after she testified to try and counteract what she said?
We discussed that, honestly, and we felt that this trial needed to come to an end, and I didn't really think that her testimony, while obviously damning, really necessitated a response. The evidence of his innocence on the particular charges that we were concerned about was so overwhelming that we didn't feel that her allegations dignified a response.
You said you were expecting a compromise verdict. Why was that?
The jurors obviously, I don't say obviously, I felt the jurors heard enough evidence to raise a question about whether or not he should have perhaps waited a second or two longer to see if Mr. Butler was going to actually come into the store or what he was going to do. And that may have played some role in it. I spoke to one of the jurors, and I think their feelings were they didn't want Stephen to have a gun, and by finding him guilty of reckless conduct, that may have resulted in his license taking away. Although it's interesting, we're doing some research right now. I think that the reckless conduct statute, and I'll need to do some more research, but I think that statute's been declared unconstitutional. And if it has been, then obviously we'll bring that authority to the court and ask that the conviction be immediately vacated and then Mr. Kolokorius be released from custody.
I'm sorry, the charge on which they just convicted him, you say, is unconstitutional? Why did you not realize that before it went to the jury, if that's true?
You know, it's interesting. I remember a case where I think it was the disorderly conduct being held unconstitutional, and we spoke about it, and I can't really say it was anything brilliant on my behalf, but it was certainly the lesser of the charges, and had the jury not had a compromise count, then it could have been a lot worse. So, I mean, I don't really want to take any credit for it because I really don't know the answer right now. I've got to having Elizabeth do a little research, but if that's the case, then sort of blind luck, I suppose. But I'll advise you further when we find out.
Now, you said that the jury may have been trying to keep Stephen Kolokorius from owning a gun in the future. Is that grounds for an appeal?
No, not at all. I mean, whatever a jury does in deliberation is sacrosanct, and unless there's some kind of, you know, misconduct or some kind of violation of the rules that pertain to jurors, you can never impeach a verdict with you know, a juror's statement. So.
Well, is that right? Does the conviction preclude him from owning a gun in the future?
No. It's a misdemeanor conviction. Wouldn't have any effect whatsoever.
Why do you think he was taken into custody on a misdemeanor conviction?
I'll defer to Judge Fuller on that. I don't know.
Ever had a client convicted for a misdemeanor taken into custody before,
Sure.
like this?
Sure. DUIs. You got to go to jail if you get convicted of a DUI, Georgia.
Any other crime?
I can't think of one off the top of my head, but yeah, I've had a lot of people go to jail for misdemeanor convictions. Most often it's battery cases where there's some kind of domestic violence. And perhaps the judge felt because this did involve an allegation of violence and given the heated passions in the case that it was an appropriate thing to do. I don't quibble with Judge Fuller. I like him very much, and he's a great judge, and he and I will be talking further about this once I have some research in my hand indicating what the constitutionality of the statute is. And I'm really not certain about that.
Well, another thing that you'll be discussing with Judge Fuller, no doubt, is the sentencing coming up. What will you be asking the judge to do?
Time served. I think that's appropriate and a fair sentence.
And Mr. Summer, over the last couple days, we've seen you making overtures to members of the African-American community, particularly some church leaders, and you've asked them to set up meetings, at least a meeting, so you and Mr. Kolokorius could go and speak to them. What was that? What do you hope to accomplish there, and why do you think that's important?
Well, I think it's important because it's always a good thing to open up a dialogue, especially when you have a situation like this where there's obvious racial animosity, whether it's grounded in fact or fiction. There are some hard feelings, and this is a bad situation, and there were going to be no winners with this verdict, and I told them that. I said whoever wins, the other side is going to be, you know, upset about it. And I felt early on, while there was no verdict, that it would seem more genuine, and it was genuine, our offer to, if they would invite us to one of the churches, to go and have a kind of an open discussion, to air some of the feelings and perhaps begin the healing process and perhaps, you know, make something good out of something bad. And they seemed receptive to that, and they're willing to talk about that, and that's something we're going to pursue further.
Do you have hopes of doing that before sentencing, or do you think you'll put it off until this case is concluded and then move on?
It'll happen if it happens at all after, obviously, Steve is released. He's incarcerated, so it'd be difficult for him to attend any meeting while he's in the custody of the Sheriff's Department. But I spoke about that with Steve, and he was very receptive to it. He wants to make the effort to perhaps build some bridges. And this is a good community, notwithstanding a lot of the things some of the Yankees were saying. This is a good community. It's a tight-knit community. There are very good relations between black folks and white folks, and I respect their opinions and I respect their feelings, and I think they share the same feelings, and there's no need for divisiveness. And when you have an opportunity to move on and perhaps establish a dialogue, you got to take that opportunity. I know President Clinton wanted to do something like this, and this is a perfect living example of how you can take something very bad and perhaps get some good out of it. So.
Which Yankees have been criticizing you that you've been objecting to?
That dude from New York saying we all tote 45s. Nancy will know what I'm talking about. Come on down, and I'll be happy to take you to lunch and show you we're not a bunch of rebel, redneck, gun-toting, flag-waving yahoos. It's a pretty decent place to live, and y'all can visit.
Will you appeal this verdict?
It depends. I really haven't made that decision. I think there are a number of very good grounds for appeal. And by the way, one of the jurors, one of the things one of the jurors said was they all thought that Montell was in a gang by the hash marks on his eyebrows. It was interesting that they picked up on that, even though we weren't allowed to go into that. So.
Well, and that's interesting. The next subject I wanted to broach with you was the rather controversial decision on your part, and at least controversial in some quarters, to bring in the criminal history of Montel Butler, one of the alleged victims in this case. Describe for us why you thought it was important that this jury hear, one, from his alleged rape victim, and then two, from some teenagers who were involved in a fight with him.
Well, I wanted the jury to understand that Mr. Butler had violent propensities and would at least be capable of doing a holdup, which is a very violent act. And if they heard evidence that in the past he was capable of extreme violence, it wouldn't take much of a leap of imagination to see him sticking a gun in somebody's face. And frankly, I don't know if the boys were going to do an armed robbery or not. And as I said to the jury, it really doesn't matter because that's what it appeared was going on. And anybody in Steve's position would have believed quite reasonably that this was an attempted holdup. And that was the whole point.
Do you think Stephen Kolokorius' testimony that he has no regrets and that he would do this again may hurt him come sentencing?
No.
Why?
Because frankly, he believed it was an armed robbery. He believed that at the time, and I guess he believes it now. And, you know, it's really nice to stand here, you know, months later and debate about what you would have done or I would have done. I mean, you have to make a split-second decision, and unfortunately, there's a lot of good officers who are no longer with us because they hesitated. You know, the lesson of this case is don't play with guns, kids, because it's a bad thing to do, and it's very dangerous, and it causes problems. And, you know, this is just one of the problems that it caused.
Okay, Dan Summer, thank you so much.
Sure, I'm happy to be here. Thank you very much.
Raymond, you heard it. I'm sending it back to a Yankee back up in New York, just not the one he was complaining
I was going to say, I'm assuming not the Yankee to whom he referred, or you'd let me engage in the debate. But anyway, I don't know who that Yankee was. I guess you'll have to do more research and investigation. You always find out, get to the bottom of things. Professor Schwartz, anything that Mr. Somerset surprised you?
Well, first of all, I was surprised that he was pleased with the verdict. I mean, I understood that, of course, he would be pleased that his client would be acquitted of the most serious charges. But I was surprised that he didn't also say, I thought my client should have been acquitted of the less serious charges. So that was one thing that surprised me. You know,
Were you surprised that he said he anticipated a possible compromise rate?
You know, I think that a good lawyer thinks through these things. I was surprised he said it on the air. But I'm not surprised that he anticipated that because I think, you know as a defense attorney, that you have to anticipate a lot of different things. And so it doesn't surprise me he might have even counseled his client that this is certainly a better result than getting the, most serious kinds of charges, getting convicted of the most serious charges. I was very surprised to hear him talk about the constitutionality of the statute and, because that, I think, took us all by surprise. None of us would know that.
Well, he seemed to take himself by surprise because he's still trying to figure that out. It would be interesting if it was, because it certainly will constitute a complete victory for Mr. Kolokorius, presumably, if the judge finds it that way.
Right, and it almost sounded like one of the reasons he didn't do the research ahead of time was that he understood that if he couldn't offer the jury a lesser kind of charge, they might go with a more serious charge. And so he didn't want to leave them with no intermediate option. And therefore, he may do the research now and find out, but he may have deliberately decided, in a sense, not to find that out ahead of time so he could leave that option to the jury, which they took.
Interesting strategic choice. We're going to take a break, but we're going to be back, and we hope you'll be there when we do return.
It's amazing what you can order by phone these days.
Might sway the jury against Montel Butler, or the alleged past of Stephen Kolokorius may make the jury not believe what he says. if the two jurors that we spoke to are an indication, they said neither one of those made much of an impact at all. They said they tried to key in on what happened out at the Citgo station, and from the two jurors that we spoke with, it sounded like the deciding factor in their mind was that the youths were still outside the store, and that if the youths had come inside the store with the guns out, it might have been a different story. But the coach, the jury foreman, said he couldn't conceive of a situation where you could shoot through a door under those circumstances and be justified.
Clara, not only is there a sentencing yet to come in this case about 10 days from now, but also a sense of residual feeling of resentment on the part of the victim's family and the black folks you've talked to, who think that there were racial issues in this case that were not addressed by the jury and not addressed yet. So it seems as though the trial may be over except for sentencing, but the story here may continue on.
The story continues. The story continues. And if, in fact, the defense attorney is successful in having this meeting that he's talking about between Stephen Kolokorius himself, or among Kolokorius, the defense attorney, and then members of the African-American community, that may be able to try and soothe some of the feelings that have been made a little raw by this jury verdict. But it depends on how the meeting is conducted and just what is said there. The one thing that I have heard over and over in this courtroom from people who were supporters of the prosecution, supporters of the alleged victims, is that they seem to take offense at Kolokorius' testimony that he did not regret what he did and that he would do it again. The people I spoke with, supporters of the alleged victims, said that they wanted him to say, I regret that I did it. I'm sorry. I thought I had to do it at the time, but I've regretted it every day since then. I nearly took a young man's life. And when he didn't say that, and in fact said that he would do it again given those same circumstances, that seems to have rubbed some people wrong.
Sounds as though they believe that he would and are angry about it. One last question, not the usual final thoughts question because there's been so much happening today, but were you surprised when the defense lawyer indicated that maybe the reckless conduct charge was unconstitutional?
Yes.
And do you have a sense of, had you heard that before at all? And no. Do you have a sense that he was saying as used in this case, or that the statute was unconstitutional?
Well, I spoke with him just after we did the interview, Raymond, and he said, no, I don't want to say it is unconstitutional. He said he's just received some indication that it might be. So that's, I guess, the beginning of the story there. He did not bring it up in court. He never gave the judge any notice that that might be true. And the judge's law clerk was all over the law in this case. As soon as one of the lawyers mentioned a case, it was rare that his law clerk hadn't already read that case and briefed the judge on it. She was just a hawk in looking at the cases, and it would be surprising if she missed that indeed this statute had been ruled unconstitutional. But what we have now is an initial indication from the defense attorney, Raymond. Dan Summer did not want to say that it absolutely was unconstitutional. He's saying he's looking into the possibility that it might be.
Clara, more splendid interviews from you. Thanks for the work and the excellent coverage. We never know where you're going to turn up next, but we know we'll be getting the real insight in whatever case you're covering. We want to thank you, Clara, but we're not finished with our coverage. In fact, Professor, I want to ask you a question. There's been reference to the civil case. The question I think most folks might ask is if the damages are so, I mean, forget all the questions about liability, whether he was at fault or not civilly. If the damages amount basically to a cut in whatever emotional or psychological trauma, which is hard to measure, came afterwards for these two young men, and given the problems with Montell Butler's past, is this a civil action that's viable? That is one likely to go all the way, result in either a significant settlement or a significant verdict, or are there damage issues here that might cause a problem for the plaintiffs?
Well, it's not Montell Butler, I think, who's bringing the damage action. I think it's Mr. Clark and his family who are...
But no doubt Mr. Butler's past will be a factor in that case.
Right. And maybe that's one reason that Mr. Butler has not joined in a damage action. That's possible. We don't know because we haven't been privy to those discussions. But first of all, it's very difficult to win a damage action when you have when you've had an acquittal in the criminal case. So in that sense, at least by having a partial conviction, the family has more reason to think that more positively about the civil case. I mean, we saw a very strange thing in the O.J. Simpson case where we saw, first of all, an acquittal in the criminal case, and then you could say a conviction. I mean, because damages in the civil case, but that's very rare. Usually when people, when a defendant is acquitted in a criminal case, they usually don't, the family of the victim doesn't usually go forward. But we have to remember that the standard of proof is different in a civil case than it is in a criminal case.
Well, let me press the damage question a little further, which is that not only does it seem to me that you have minimal physical injuries, though the possibility was there that this young man or both could have died. But you also have a problem of the deep pocket, and that is, unless in fact there were some finding that the county for which this defendant was an employee, a civilian employee, was responsible for his conduct, most people like Mr. Kolokorius of his age would not have huge resources that would justify mounting a civil suit, because what do you have if you win? So I wonder whether at some point the plaintiffs will have to look at the damage question and perhaps be disappointed that, notwithstanding this difficult for them result in the criminal case and an unlikely federal indictment, that the civil case also may not bear fruit.
You know, it's true. It depends on whether, because usually when you bring a civil case, you don't have to pay a lot of out-of-pocket expenses. The lawyers usually will charge, you'll pay a contingency fee. So it depends if they can get a lawyer.
But that's usually a lawyer who's looked down the road and seen the possibility of winning, possibility of getting some money, and the possibility of recovering. So it seems to me that while there is a civil suit, it will be interesting to see in the long run whether that is fruitful for the victims, especially as they seem to feel very strongly that the issues in this case have not been fully explored.
Yeah, well, I think you're right that if they can't connect the state, then they're going to have a very difficult time, and they probably a lawyer will tell them that you can't go forward unless you have enough money yourself to pay all the legal fees up front, because you're right that a lawyer probably isn't going to take the case. If you can find that the state is somehow implicated because he was an employee.
And the issue of well, it is interesting, just that is the jurors seem to say that they, in fact, found him reckless in part because he had had training, and therefore should be responsible to handle this situation without the offer of force. Under those circumstances, perhaps the plaintiffs will be encouraged, because that suggests that whatever training he had didn't take, or there may have been a flaw in the training.
Right.
But we'll have to see. Among the many questions to be explored, we're going to take a break right now, but of course we'll be back, and we certainly expect you to be there. Of the two serious charges against him, aggravated assault, about an hour and a half ago. Convicted of reckless conduct, remanded by the judge in 10 days. Remanded means he's in jail. In 10 days, he'll be sentenced. The maximum he could get is up to a year in jail. Right after that verdict, Clara Tuma went out and talked to the foreman of the jury that rendered the verdict. Remember, this is a case in which the defendant charged with shooting at two young men who he said he thought were getting ready to rob a store.
I don't know what was in Steve's mind, but I do know this. It happened in such a quick time. I don't know if that would have much factor in it, but you cannot pull a gun and shoot through a window, and that's a point we tried to make. We don't believe that type of vigilante type should be, it should happen.
Now, the one substantive note from the jury, other than lunchtime or wanting to go home for the day, was asking whether aggravated assault was a felony and whether reckless conduct was a felony. What prompted that note?
Well, because of some of the earlier talk that made by some of the people without bringing it up, now there was contradictory statements made. And that we did not feel. We wanted to make a statement, but not make one where we stomped too many toes. But we felt that we had an obligation to this community to tell the people, hey, don't come in here and shoot like that. You can carry a gun and keep it in your holster, that's fine.
Interesting comments from the jury foreman, a person named Coach Eli, apparently well known in the local community. Professor Swartz, before we go forward from here, it sounded as though you were thinking, I should say, I can't read your mind, but I think you were sort of talking, that in fact perhaps his description of what the jury found factually consistent also with aggravated assault as well as with the lesser, not the lesser, the less serious charge, the misdemeanor of reckless conduct.
Yeah, I was surprised because he said we don't tolerate people shooting guns through windows. And that's really what you're talking about with an aggravated assault. You're shooting a gun with an attempt, trying to injure somebody. And this is what Kolokorius seems to have done in this situation. So I was surprised he just saw that as recklessness rather than looking at this as some kind of aggravated assault. And I'm, wondering, again, why they sent that note about a misdemeanor and a felony, if they were influenced in some way, but maybe they really didn't feel he had done something with such knowledge that they could, such knowledge of foresight, particularly that he had planned it in some way, or that he really had planned to do this, and so they didn't want to punish him with such a very, very large sentence.
Well, some wise, perhaps not to be answered. But in any event, this is perhaps the critical testimony on cross-examination as the defendant explained his own state of mind as he fired the shots that were critical in this case.
So when you parked your car, being in a hurry, you walked faster than you ordinarily would. Or you ran or you jogged. Isn't that correct, sir?
That's correct. I jogged.
You jogged in?
Jogged or walked really quickly.
All right. So you were in a hurry to get into the store and get your Diet Dr. Pepper?
Yes.
Now, at the time that you did that, ran into the store.
His characterization is a jog.
All right, the jury will recall what the evidence was. Mr. Derry, you can ask your question.
At the time that you traveled from your car to the store on foot, at what speed you described, can I ask you whether or not you saw the two individuals that were outside the store?
Yes, I did.
Where were they at the time that you saw them?
They were down there by those propane tanks on the other side from me.
At the time that you saw them, did you notice either one of those State's Exhibit 1 or State's Exhibit 2?
No, I didn't.
And you walked into the store, is that correct?
Yes, I went to the store.
Okay. Or that is, you jogged into the store at that point, is that correct? And are those the words that you used as far as going into the store, as far as traveling?
Yes.
Okay. So you jogged into the store, is
Yes.
that correct? All right. And when you jogged into the store, did you make any hand motions or head motions toward the two young men outside the store?
No, I did not.
And you did not see at that time either of State's Exhibits 1 or 2, is that correct?
That's correct.
But when you got into the store and you testified on cross-examination that you felt funny about those guys out there, isn't that correct, sir?
That's correct.
And you had not seen any weapons
That's
or
correct.
any toy guns?
That's correct.
What factors made you feel funny about those guys out there?
The guy that I had made eye contact with gave me a really hard stare.
So a hard stare made you feel funny about one of the guys who was out there?
Yes.
What other factors made you feel funny about the guys who were out there?
That was it.
Now, and because you felt funny, because you said a guy had a hard stare at you, which of the guys, by the way, had a hard stare?
I believe it was the guy in the blue shirt.
And you saw the two young men testify in court, is that correct?
Yes, I did.
Which of those two young men gave the hard stare at you?
Kellen Clark.
Why was it that you felt funny about a hard stare, as you described that, about Kellen Clark, or from Kellen Clark?
Just made me feel uneasy.
What about that made you feel uneasy?
I can't explain that. I mean, Have you ever been in a place where someone keeps looking at you or stares at you real hard and it makes you feel uneasy?
Did he keep looking at you or staring at you real hard?
Well, on my way into the store, he was looking at me, and then I made eye contact with him, you know, when I got up closer to the door and went inside.
Where was he at the time that he made eye contact with you as you were jogging into the store?
He was down there by the propane tanks.
Well, where at the propane tanks?
At the south end.
Where in connection with the south end?
Do you have that picture again?
Yes, I do. Specifically show us where at the south end.
He was right down here. Right down there.
Was he in front of the propane tank or beyond the propane tank?
He appeared to be beyond the propane tank down here.
Was he
outside a local convenience store? On later examination, the guns turned out to be real-looking fakes. Kolokorius' lawyer says his client prevented a robbery of the store by the two teens, one of whom did have a violent juvenile record. But the state of Georgia had hoped that Kolokorius' own record of alleged racial animus would prove to be of more interest to the jury. After the verdict, Court TV's Claire Tuma had an opportunity to talk to prosecutor Lee Dara about his feelings toward the verdict.
It's not a matter of personal disappointment or happiness or anything of that nature. It's a matter of a jury making a determination based on the facts. It's our obligation to present the facts, to ask the jury to do justice. This is what the jury determined to be justice in the case, and again, the state doesn't have any quarrel with the jury's verdict.
Claire Tuma later was able to speak with Dan Summer, Kolokorius' defense attorney.
Obviously, I felt the jurors heard enough evidence to raise a question about whether or not he should have perhaps waited a second or two longer to see if Mr. Butler was going to actually come into the store or what he was going to do, and that may have played some role in it. I spoke to one of the jurors, and I think their feelings were they didn't want Stephen to have a gun, and by finding him guilty of reckless conduct, that may have resulted in his license taking away.
Claire Tuma's had an opportunity to talk to Dan Summers, the lawyer you just saw there, the defense lawyer. Subsequent to that on-camera interview she did, she's now standing by live from outside the courthouse in Gainesville, Georgia. Tell us about it, Clara.
Well, Dan, the defense attorney, Fred, the defense attorney says that this whole jury verdict is now in question, and the reason is because he says he has just discovered a case from the Georgia Supreme Court that says this reckless conduct statute is unconstitutional because it is too vague. Now, at this moment, at this hour, the defense attorney, prosecutor Lee Dara, and the judge are meeting behind closed doors discussing this very issue, discussing whether this jury verdict can stand. Now, it's the defense position that if indeed he's reading this case right and if this statute is unconstitutional, that Stephen Kolokorius is a free man because he was acquitted of the greater charge of aggravated assault. The defense position is you couldn't then retry him for aggravated assault. He's already been acquitted of that, and you couldn't retry him for reckless conduct because that statute, according to the defense, is unconstitutional. Now, this clearly was news to the prosecutor and the judge, and it's the subject of much discussion at this hour.
Did you have any opportunity to get any sense from him as to whether he might have just suspected, and I'm putting that as kindly and as indirectly as I can, that this statute was very much in danger, in jeopardy, in question, and that he didn't raise it until after the verdict because now he's got a verdict. If the statute's no good, double jeopardy attaches?
Well, I did ask him that, and he said no. He said that in his mind, this case he was thinking of applied to another charge that I forget at this moment, but it applied to another charge, and he said that was in his mind, and that after the jury verdict came up, he began thinking about it and then looked at it. But it's a good question you raised, Fred, one that I'd already thought of, and that is, was this just lying in wait, allowing this jury to consider a charge that he now claims is unconstitutional, knowing that should they convict him of that lower charge, that the judge would throw it out. But as I say, let me repeat, this is all up in flux. It's all up in the air right now. It's in flux because it's just now being discussed with the judge. And if the defense is right, then they would file a motion with this judge, and this judge could indeed throw out this jury verdict.
We should say here that there's certainly no rule against a lawyer lying in wait and using some defense lawyers' wiles here. By the way, what is happening in the meantime to the defendant who was kept in custody after the decision?
Well, Fred, he was taken into custody even though he was convicted only of the misdemeanor charge. That was prearranged. The judge had already told the lawyers that should there be a conviction on any charge, that Kolokorius would be taken into custody, and he was. Now, we are told he is not going to be held here in Hall County, which is where he was a jailer just last July. We're told that he's been taken to a county near here and is being held in a jail, just not the one at which he at one point was a jailer. If this conviction is not overturned by the judge, if things proceed the way they are as of this minute, sentencing will be within 10 days and he'll be brought back then. Now, the defense can put on evidence then. There is a time for victim impact statements, and then it'll be up to the judge to sentence. He's got a range here from probation all the way up to 12 months in jail.
Did you get any sense there that some of the things that are going on today, that is the incarceration of the defendant after he's been convicted only of a misdemeanor, which itself is in some question, and then not being put in the local jail but being put somewhere else, is in deference to some of the racial tensions in the community?
I think it is. I think it's a way to try and make sure that those tensions don't escalate over the next couple days. And by incarcerating Stephen Kolokorius, the judge took that, tried to ease some of that tension. I think maybe that's the best way to say it is. He took Kolokorius off the streets. There is now a conviction. He is in jail. The defense attorney says that if this conviction stands and they get to sentencing, he'll ask the judge to sentence Mr. Kolokorius to time served, which sentencing will be within the next 10 days, so it would be a maximum of 10 days. The defense says that would be an appropriate punishment for this conviction of reckless conduct, again, if that's allowed to stand.
Claire, do you get a sense that you're going to be told any more after this meeting that apparently is going on now?
I don't know. I don't know. I know that they are back behind closed doors, and there's at least the judge and both attorneys there. We don't know exactly who else is there. The district attorney herself is not. She was in court for the verdict being announced, but she's not in this meeting. So it's unclear just how serious an allegation this is. Again, this is coming from the defense team, from defense attorney Dan Summer, and no confirmation from the prosecutor that he agrees with the interpretation of this particular Supreme Court case. In fact, they haven't even told us what case it is so that we can go look at it and tell you whether our reading of it supports the defense interpretation or not.
Clara, I would think that even if there's a strong case being made by the defense before the judge, Judge Andrew Fuller in there now, in view of the situation and in view of his concern about feelings in the community, he would certainly wait a few days at least before he would make a decision adverse to this conviction.
I agree. I think that whatever decision is made won't be made this afternoon. I think that if there's going to be further action, it'll be later in this week or next week.
Well, in any event, we're going to see you later as we respond to some email about the trial and the verdict in the case of Georgia versus Stephen Kolokorius. Thank you very much for being with us. Clara, we'll see you later. We're going to take a break right now. When we return, we'll take a look back at some key testimony in the case, and then we're going to hear some more reaction from spectators and participants in that Gainesville, Georgia courtroom.